Yeah. Sometimes I get so mad, there's no controlling me. My thoughts get so bad, I'm like, I might grab a bat, I don't know. My wrath, my blood boils over like, oh God, here goes. I lost all feeling from my head to my toes. You said some shit that I can't let go, so just stay tuned for the rest of the show. So have you ever felt betrayed? Switches how you see things, realize something needs change. Cause I know you got me fucked up, let me show you what's up. Cause enough is enough. I'll take a face full of pavement just to make a statement. I know there's no turning back. Oh God, adrenaline wasted, so mad I can taste it. I know there's no turning back. I'll do what it takes, I ain't making mistakes like that. I'll bleed on your face just to make you go take it back. I'll lose my shit, I go crazy when I'm mad. And now you go wish you would shut the fuck up real bad. And now that I'm gone, yeah, I know there's no turning back. And now that I'm gone, yeah, I know there's no turning back. I don't fucking take smoke, I'ma poke a hole through you, choking's overdue. Come at me and you won't get any older, dude. Crack your holder too. Heating up inside of me, blood so violently. Thanks for trying me. Now it's finally time to see how this rivalry becomes a dynasty. I know there's no turning back.
Calling next participant. Thank you, Your Honor. This time, people call James Hale. Would you please come forward, sir? That door goes out towards you. Watch your step. Okay, please remain standing to be sworn. Raise your right, no, this way. Raise your right hand.
Do you solemnly swear or affirm, under the penalty of perjury, that the testimony you're about to give before this court is the whole truth and nothing but the truth?
I do. You may be seated, sir. And I'm going to ask that you keep your voice up because we are recording this, all right?
Yes, ma'am.
Thank you. Sorry. Good morning, sir.
Good morning.
Could you please stay and spell your name for the record?
James Hale, H-A-L-E.
Okay. First name?
James, J-A-M-E-S.
Okay, thank you. And, sir, are you currently employed?
Yes, ma'am.
Okay. And, where?
Phoenix EV in Greenville, South Carolina.
Okay. And Mr. Hale, is that where you currently live?
Yes, ma'am.
And prior to moving to South Carolina, where were you living?
In Detroit, Michigan.
Okay. And, when you, were living here in Detroit, were you employed?
Yes, ma'am.
And where were you employed?
I was employed at the Senior Citizens for Independence under Henry Ford Hospital and at Northland Mall.
Okay. And what year, were you employed at Northland Mall?
The end of 2013 and the beginning of 2014.
In Northland Mall, is that located in the city of Southfield?
Yes, ma'am.
Oakland County,
Yes, ma'am.
here in Michigan?
Yes, ma'am.
Okay. And, Mr. Hale, what was your job at Northland Mall?
I was a security officer
Okay. And were you hired by the mall itself, or were you hired by a private security company?
by the private security company.
Okay. And when you were hired by the private security company to provide security at Northland Mall, did you have to go through any type of training?
We had manuals that we went through, and we went through training on how to apply handcuffs.
Okay. And did that training also include how to interact with customers at the mall?
No, ma'am.
Okay, all right. And you said training as to how to apply handcuffs.
Yes, ma'am.
Did you have to complete that training before you were issued a pair of handcuffs?
Not really, no, ma'am.
Okay. All right. As a security guard, did you carry a weapon?
No, ma'am.
Okay. What about a radio?
Yes, ma'am.
Okay. Did you carry mace?
No, ma'am.
Okay. Now, Mr. Hill, are you familiar with the term observe and report?
Yes, ma'am.
And how are you familiar with that term?
That's what we were supposed to do. How can I put it? As far as I understood, being a security guard, you were a visual deterrent. You were there to make the client and the customers feel safe, knowing that someone was watching over you. You see something, you report it.
And was that your understanding of your role at Northland Mall to be a visual deterrent?
Yes, ma'am.
Okay.
I'm gonna object as the relevance of his role.
Your understanding.
Each person might have a different role.
Sorry.
Sorry.
I believe my question was that your understanding of the job as a Northland security guard as to what your role was?
Yes, ma'am.
Well, thank you. Thank you. Excuse me. Now, Mr. Hill, I want to direct your attention to January 28, 2014. Were you working at the Northland Mall on that day?
Yes, ma'am.
And were you working in your capacity as a security guard?
Yes, ma'am.
And, sir, on that particular day, what were your duties and responsibilities?
I don't remember everything that I did that day, but I know I was in dispatch. It was my turn to be in dispatch that day.
Okay. And do you recall your shift on January 20th, 2014?
My normal shift was 5 to 11:30, I believe.
And you mentioned that you were on dispatch. Can you explain for the jury what that means?
To be in dispatch, you sat in the office, you monitored the cameras, and you answered the phones if anyone called for assistance.
And were there other security guards working at that time on January 20th, 2014?
Yes, ma'am.
Okay. And as a dispatcher, are you able to be in contact with the other security guards working at the mall?
Yes, ma'am.
And how so?
With the radios.
Okay. And the radio, is that like a walkie-talkie?
Yes, ma'am.
Okay. And where was the dispatch office located inside the mall?
It's in the basement.
And the dispatch itself, how is it set up? I mean, how are you able to watch what's going on in the mall if you're working in dispatch?
They had closed circuit monitors and cameras all over the mall.
Okay. And if I know you can remember, how did those closed circuit TVs work? Like, were you able to point to a particular area of the mall?
You could punch in keys and pull up cameras. You could rotate cameras to see certain areas. Yes, ma'am.
Okay. Now, sir, on January 20th, 2014, did you speak with a person by the name of Labib Ansari?
Yes, ma'am.
Okay. And if you recall, did he have a store in the mall?
Yes, ma'am.
Okay. And when you spoke to Mr. Ansari, did you call him or did he call you?
He called me
Okay. And do you remember how many times he called?
twice that day.
And let's talk about the first call. I don't want you to tell me what he said, but based upon the information you received, what did you do?
I radioed the patrols to go to LA Diamonds.
And was that the name of the store?
Yes, ma'am.
Okay. And you said he called twice.
Yes, ma'am.
Can you recall how long a time it was between the first call and the second call?
Maybe 2 minutes.
Okay. And the second call, did you have a subsequent conversation with Mr. Ansari?
Yes.
Okay. And again, without telling me what he said, based upon that conversation, what action did you take?
I informed Sergeant Chafin of the situation as Mr. Ansari had told me, and I began a CAD entry because we had to put it into the system.
Okay. And now you mentioned the name Sergeant Chafin. Who was Sergeant Chafin?
He was the officer in charge of the whole team that day.
Okay. And you said you were entering information into a CAD?
Yes.
Describe for the jury what a CAD is.
It's a computer system where we have to put notes for any activities that come in.
Okay. And is that what you were doing while you were receiving the information from Mr. Ansari?
Yes, ma'am.
Okay. And so you relayed information to Sergeant Chafin?
Yes, ma'am.
Okay. And what's the next thing that happens?
I pointed the camera to the front. We didn't have a great view, but I pointed the camera to the front of LA Diamonds,
Okay.
where I noticed the person standing there with the hood on.
Okay. And this person, and are you watching the television the whole entire time, or are you entering information? What is?
I'm entering information and looking back and forth. I don't type that well. finger type.
Okay, that's fair. Okay, and so you said you would point the camera in the direction of LA Diamonds?
Yes, ma'am.
And what do you see?
I saw an individual standing at the counter, and I saw as Sergeant Chafin and Sieberling walked up.
And this individual standing at the counter, do you remember anything about him as to what he looked like, how tall he was, what he had on?
He had a hoodie on, so I couldn't see his face too well. I don't know if it was an accurate measure of how tall he was. I believe he might have been 5'11". That was just about it.
Okay, and you said you saw him standing there?
When Sergeant Chafin walked up, I watched the individual take a step back and then take a step forward towards the Sarge.
Okay,
I saw Sarge put his hand up as in a warning, as in don't, and I saw the individual get maced.
okay. Now you mentioned Sieberling? Did you, say yes for the record? I'm recording
yes.
everything. Okay, and you saw Sieberling too?
Yes,
Did he arrive with Sergeant Chafin?
yes,
Okay, and Sieberling, do you see him in the courtroom today?
yes.
Okay, and can you just point to him?
Gentleman right there.
Okay, and there's 3 gentlemen, be a little bit more specific.
Gentleman in the black suit with the glasses.
Okay, you're right, let the record reflect that the witness has identified Mr. Sieberling.
The record was so reflect.
Thank you. And so was Mr. Sieberling, was he with Mr. Chafin?
Yes,
Sergeant Chafin?
yes,
Okay. And so you said, you saw, Sergeant Chafin mace the individual?
yes.
Okay, and what did you see next?
The individual went down, and then I saw Sergeant Chafin and Mr. Siebling attempt to put handcuffs on him.
And are you watching this the whole entire time?
At that time, I had to pick up the phone, and it was protocol that if anytime someone was maced, we had to call 911 to alert the police to come.
Okay, now you said that you saw Sergeant Chafin and Sebring attempt to put handcuffs. Can you be a little bit more specific? What did you see them do?
I saw them approach him and turn him over, and he was struggling.
Okay, when you say turn him over, at this point, is he still on his feet?
No, he was on the ground.
Okay.
He was on the ground after being maced, and they went to turn him over to apply the handcuffs.
Okay, so let's take a step back. So at some point, he's standing up after being maced?
No, after being maced, he bent over and just went down to the ground.
He went down to the ground. And when he went down to the ground, did you see Mr. Sebring and Mr. Chafin go down to the ground with him?
They went. They were hunched over him, attempting to handcuff him. Yes.
Okay. The individual that you saw on the ground, was he throwing any punches? As to what you could see.
I saw him thrashing around. I don't know if he actually. I couldn't tell if he was actually throwing punches, but he wasn't being still.
Okay. Do any additional security guards show up?
Yes.
Okay. And do you know who showed up?
I don't recall in what order they showed up, but I know
I don't need the order, just
Officer Hamilton showed up. Officer, I can't think of his name. It's the gentleman right there in the middle, and then Officer McGee. They all showed up.
okay. You said Officer Hamilton showed up, and then you said the gentleman in the middle.
Yes.
Okay. And can you just be a little bit more specific?
Gavin.
Okay.
Officer Gavin.
Okay, all right, he showed up, you're on the record, but again, and then who else showed up?
Officer McGee.
Okay, and do you see him in the courtroom this morning?
Yes, Mom. He's the gentleman on the end.
Okay, you're on the record, that the witness has identified.
The record was so reflect.
Thank you. And so eventually, these 3 individuals show up?
Yes.
Okay, and when these 3 individuals show up, what happens? What do you see?
Well, they didn't show up at the same time.
Okay.
If I recall correct, Sergeant Chafin called for assistance. And then I saw all of them on the ground. They were tussling like they were trying to get control of the individual. and they were having a hard time.
Okay. Now, when you use the word tussling, what do you mean by that?
Wrestling?
And they were wrestling the individual?
Yes.
Okay. And could you tell if the individual was face up or face down? When this
I could not
wrestling
tell.
was going on?
I couldn't tell.
Okay, all right. Are all the security guards, are they all on the floor with the individual?
Yes.
Rephrase your question.
Where did you see all the security guards with the individual?
All the security guards, they were on the floor with the individual.
Could you see their hands, the security guards' hands?
I wasn't paying exactly close attention to their hands.
Okay. Now, you said that all the security guards were on the floor with the individual. Do you know how long they were on the floor with him?
No, ma'am, I don't recall.
Okay. Was it minutes, seconds, hours?
I don't think it was hours. It was several minutes.
Okay. And what do you see happen next?
After a while, they stood up and I don't recall who did it, but they lifted the individual up and leaned him up against the wall at LA Diamonds.
Okay. Now, when you say they, who are you referring to?
I don't recall exactly who it was that moved him.
Okay, now, when you say eventually they got off the floor, they being who? Who got off the floor?
The security guards.
Okay, and when the security guards got off the floor, where was the individual that they were?
He was still on the floor in handcuffs.
Okay. Could you see if he was face up or face down at this point?
I believe he was face down and they rolled him over and sat him against the wall.
Okay. Was he moving?
Yes.
The individual was moving? That was on the floor that was face down?
When
After
they
they were handcuffed?
after they set him against the wall, he did move.
Okay. Did you call 911?
Yes, ma'am.
Okay. And before your testimony here this morning, did you listen to 3 911 calls?
Yes, ma'am.
And did you recognize a voice on those 911 calls?
Yes, ma'am.
And whose voice was that on those calls?
It was my voice.
Okay. Your Honor, I'm referring to People's Proposed Exhibits 25, 26, and 27. And those 911 calls, were they an accurate recording of the calls that you made on January 28, 2014?
Yes, ma'am.
Okay. And just for, in terms of timeline, when did you call 911? What was the first call, if you can
The
remember?
first call was when he got maced the first time.
Okay. And why did you call 911 at that particular time?
That was protocol.
Okay. And we play that will be this. I'll move for admission, Your Honor, 25, 26, and 27. I'll move for admission.
No objection, no objection.
Thank you.
Admitted?
We have a gentleman who's causing issues at one of our jewelry stores. Our security just had to
first call that you made to 911?
Yes, ma'am.
Okay. And let me back up for a second. Now, before Sergeant Chafin makes contact with the individual, what was the individual doing?
Tell you what the store owner told me he was doing.
No, you can't tell me what the store order. What did you see from you looking at the camera?
When I looked at the camera, he was just standing there.
Okay. And so eventually you called 911 a second time?
Yes.
Okay, and this will be your for the record, exhibit number 26. Yes, it was a bit big off.
28, 2014, 17, 38, 44.
Now, Mr. Hill, you used the term 10100 in speaking to the dispatch, the 911 dispatcher. What is a 10100?
If I remember correctly, and I can't say I do, I believe it meant that the person was disturbed.
And were you trained as to how to deal with a individual who is disturbed?
No, ma'am.
And then eventually there was a third call that you placed to 911?
Yes, ma'am.
Okay. Yeah. Now, at the beginning of the call, there was a 911 call. There's a male voice. That's it. Did you remember hearing the male voice at the beginning of the second 911 call that I played?
I believe that came over the radio. Yes, ma'am.
Okay. And did you recognize that voice?
I believe that was Sergeant Chafin.
Okay. Yes, 20 seconds.
28, 2014, 17, 49, 34.
Hi, my sergeant requesting, I guess the ambulance unit as well.
Okay, is somebody hurt or for commitment?
For the second gentleman.
Okay, is somebody hurt or for commitment?
1 second. What's that, somebody else?
Now, Mr. Hale, was Southfield Police and or EMS requested?
Yes.
Okay, and why?
Sergeant Chafin told me to call him.
And did they eventually respond to Northland Mall?
Yes, ma'am.
And were you still working in dispatch at that time and monitoring everything on the camera?
Yes, ma'am.
And did they eventually arrive?
Yes, ma'am.
Okay, now, on the 911 call, you give information as to go to J-Lot?
Yes, ma'am.
Okay, and
The-
what is J-Lot?
The parking lots were sectioned off and called different letters of the alphabet. And I told them I was guessing because I was still fairly new and we didn't have a map in dispatch. So I just took a guess at J-Lot.
And were you watching when EMS arrived?
Yes.
Okay. And what did you observe?
EMS came in the door that was facing Greenfield Road, and they came over and started their procedure with the gentleman.
Let me ask you this. You stated earlier in your testimony that the individual was put up against the pillar or the wall.
Mm-hmm.
Could you tell if he was still handcuffed at this time?
Yes,
Okay. Was he
He was-
handcuffed in front or behind?
behind his back.
Okay. I'm gonna show you the video. That's exhibit number 1. Yes. Now, Mr. Hale, are you the one that's in dispatch kind of focusing the camera on this area of the wall?
Yes, ma'am.
Okay, all right. And this is on January 28, 2014.
Yes, ma'am.
And is that you kind of maneuvering it as it kind of motions?
Yes, ma'am.
Okay. And you're zooming in,
Yes, ma'am.
and why are you doing that?
To try to get a better view.
Okay. And is that the individual that you saw when you were in dispatch?
Yes, ma'am.
Okay. And do you recognize the security guard that's walking towards the individual?
That's Sergeant Chafin.
Okay. And what about the second security guard that's in view of camera?
That's Mr. Sieberling.
Okay. Now, Mr. Hill, at any time where you were watching this, did you see any weapons on the individual?
No, ma'am.
Okay. And is this the point where the other security guards arrived?
Yes, ma'am. I believe Officer Hamilton is already there. I believe that's Mr. Gavin. Yes, Mr. McGee.
No other questions, thank you.
Sir, you get a call from the LA Diamonds requesting you to send someone out there, correct?
Yes, sir.
And let me just back up. You ended up writing a statement. Is that true?
Yes, sir.
And when you wrote the statement, that statement was dated the 28th, the same day, correct?
Yes, sir.
And would it be fair to say, sir, that when you wrote out the statement, it was accurate,
Yes, sir.
it was truthful?
Yes, sir.
No one rushed you?
No.
You ended up having as much time to write as much information that was important, correct?
Yes, sir.
And you had time to correct it,
Yes, sir.
you had time to read it,
Yes, sir.
and you signed it as being truthful and honest, correct?
Yes, sir.
So isn't it true you get a phone call from the LA Diamonds owner saying a man just threatened to kill someone?
The first call that came through, he simply asked for assistance and he hung up the phone. He didn't state anything. The second phone call that came through, he said that there was a gentleman in his store staring at him, and the gentleman said, "I'm going to kill someone."
Okay. And he calls back and says, "Get someone up here before I shoot him myself."
That was the second phone call. He said all of that in the same statement. He said, "If you guys don't get somebody up here, I'll shoot him."
Okay. And then that's when you see Sergeant Chafin.
Approach.
You looked at your camera, the grainy video that you just saw, correct?
Yes.
That records in like every 2 seconds, correct? It doesn't play normally.
I don't know how it records. I just know it's constant.
Okay. When you were watching it, it's constant, but maybe record differently, correct? If you know.
I don't know how it records. I just know that what I see on the screen is what it records.
What you're seeing, when
Yes.
you're viewing it on camera as you were watching it live, correct?
Yes.
Okay. So when you're watching it live, you can see it in basically, it's basically live. Basically, there's no pausing, there's no skipping.
No.
When you watch the one that was displayed, people walk a little different.
Yes.
So it records differently. Would that be fair to say?
Yes.
All right. So at some point, sir, you see Sergeant Chafin. He's a sergeant, which means he's the one in charge of the scene, correct?
Yes.
And how long were you working for the security company on the day of January 28, 2014? How long did you be working for?
Maybe 3 months.
Okay. And did you work the floors of the mall as well?
I'm sorry?
Did you do security where you walked around the floors of the mall as well, or did you only do dispatch?
Oh, I patrolled as well, yes.
Okay. So at some point, sir, you see Chafin approach this individual, correct?
Yes.
You see Chafin, the sergeant in charge, point to leave. He tells him to leave. Do you remember that, sir?
No.
Okay. But would you agree that if it's on camera, then that's what it might be?
There's no audio in the office, so I can't hear anything. I can only
Okay.
speculate about what was said.
All right, that's fine. So, at some point or other, sir, do you remember seeing his finger pointing?
No.
At some point or other, sir, do you ever see Sergeant Chafin take out the mace and just hold it?
No,
Okay. So this is over 10 years ago, so your memory isn't the greatest, would that be fair to say?
yes,
Okay. So, you called 911 because you saw that mace was administered, correct?
yes,
So that's your protocol, right?
yes,
And as security, it's, you indicate something about observe and report, right?
yes,
So are you telling this court that the only duty that you had was to report things? So if someone was assaulting another, you're not supposed to intervene?
it goes different according to different security companies. I mean, if you're a police authority, you can do stuff like that.
I'm not asking that. I'm asking you in that situation, when your employment, when you work for Northland Law, are you telling this jury that the training that you got, the man that you read says that you're supposed to just observe and report, nothing else?
Yes,
So the man, let me ask you, who would know more about your duties, you or Weber? Neil Weber? Webster?
Objection, I asked the resident.
Okay, it's, judge, it gives it tells it gives information to fact finders, judge, in terms of what his responsibilities were.
Well, I believe that that's the question he should ask. Is whether or not who knows more about his job. I'm just asking, I believe that's the question he should ask.
Ask it that way or ask a different
All right.
question?
Does Neil Webster, he trains you, correct?
no, he didn't train me.
Is he training anyone at all?
I don't know if he trained, he wasn't the one who trained me. I don't know if he changed anyone.
Who did you report to?
Sergeant Chafin,
Okay. And who did he report to?
I believe he reported to Mr. Webster.
And sir, is the only person that can have mace someone that was, the only person that had mace that day was Sergeant Chafin, correct?
No, a lot of the guards had mace. I hadn't been there long enough.
All right. My question to you that day, was Chafin the only one that had mace?
If you know.
I believe all of them had mace, sir.
Did you see any of them with mace?
I believe it was a part of their normal uniform.
All right. So did you have mace?
No, sir.
But you had a uniform, didn't you?
Yes, sir.
And sir, do you remember while you were watching the video, do you remember that Cochran was getting the best of the officers in terms of the struggle?
Yes.
Do you remember describing it as he was handing them their asses?
I don't remember the term I used per se, but I do remember they were not having an easy time.
I'm sorry?
Yes, you may.
I'm going to exam transcript dated August 8, 2022, page 51 to 52. Sir, I'm going to bring your attention to,
Could you indicate the lines you're
Yes.
referring to?
line 24, 25, the next page is your answer.
Yes.
You described Cochran as handing them their asses, right?
Yes.
As a matter of fact, that's when you made a second phone call, or I heard you on the second call, the 911 call, basically saying, we need assistance ASAP, correct?
Yes.
And, sir, if you were out there that day, you'd assist Sergeant Chafin. Would that be fair to say?
No.
He was let him be. Is that right? It's yes or no. You let him be. Is that what you're telling the court?
Let him be.
Okay. So, sir, you were calling other individuals to go assist Sergeant Chafin, right?
Per Sergeant Chafin's request, yes,
So you were listening to your sergeant
yes,
because he's the one that has more authority than you, correct?
yes,
He has more authority than the other officers as well, correct, that are not sergeants?
yes.
Sir, you are entering information into a system as well, correct?
Yes.
Sir, did you read the training manuals that you were given?
Yes.
Did you ever voice your opinion, or did you ever have issues with training manual?
Not with the manual per se.
Okay, nothing further.
Morning, Mr. Hill.
Good morning.
My name's Wright Blake. I'm the attorney for Aaron Marie. So my questions are going to be pretty much focused with his activity and involvement.
Okay.
Is that fair?
Yes, sir.
And as we come here today, 10 years later, you recognize Mr. Marie being over there in the corner, correct?
Yes, sir.
And with your brief time with the company, he was a co-worker that you got to know, but you on a personal basis, or just a business basis, right?
Just a business basis, yes, sir.
And has his physical size, height changed over the past 10 years, or the last time you saw him?
No, I don't believe so.
Okay, pretty tall individual,
Yes.
pretty big person. Now, being the dispatcher on the 28th, prior to that, were you the dispatcher on the 27th of January 2014?
Our duties rotated on a daily basis.
So do you know if you were
I
the
don't
dispatcher?
recall, sir.
Did you have any information on a strange or an individual acting peculiar who may have showed up on the 27th and identified on the 28th?
You're not gonna object, you just say that you did not know, you did not work in dispatch on that day?
Well, let me ask this. Were there any bulletins that be on the watch when you go?
Not official bulletins, but we did have word of mouth.
You had what?
Word of mouth.
Okay. Did you have any knowledge of this individual on the 28th?
I didn't find out that the individual had been there at the mall earlier that week causing trouble until after this incident happened.
All right. What was the name of this security company again?
I don't recall, sir. I'm sorry.
And your tenure with this company was relatively brief, correct?
Yes, sir.
What was your date of hire?
It was in November
Of what year?
2013.
And what day did you leave? Or what month? Would around March be?
Maybe March.
Okay.
Yes.
So, during your brief tenure with this company, you had training in various aspects, patrolling the mall, fluid situations that may require restraint.
No.
You had no training?
No. There were no fluid situations that required restraint.
No, I'm saying,
This was
look,
not a daily thing.
well, you work there every day, right?
Yeah. I mean, we had situations come up, but
Right,
we
so
weren't
it's-
out wrestling with customers all the time. No, sir.
Right, but you don't know what to expect at the mall from a day-to-day basis, correct?
Correct.
You don't expect someone to come in and kill 10 or 20 people, do you?
No, sir.
But it happens, doesn't it? It has
It
happened, hasn't
can.
it?
Yes.
So you can't put down every well, you can't train for every possibility because you don't know what to expect on a daily basis, do you?
No, sir.
Now, getting towards the the physical structure of where you're located, the dispatch area, that's in the basement of what used to be the Northland Mall,
Yes, sir.
correct? And to get to that particular area, you have to take some stairs. Would you agree with that?
Yes, sir.
And not like 2 or 3 stairs, but around 20 or 30 stairs?
It's one flight.
So what's one flight for the benefit of us?
I guess it would be 20, because it would be 10 down to the midsection and then 10 to the bottom. Yes,
Okay,
sir.
so to get from the main floor to the dispatch area is 20 flights of stairs, correct?
It's 20 stairs, not 20 flights.
Okay, I stand corrected. 20 stairs. Now, when you get the first call, you said that was from LA Diamonds, Mr. Ansara, and that would have been around 5:34 p.m.?
I don't recall the exact time, but that's,
Okay, well, you heard the time that was on the exhibit, 17:34, which is 5:34. You would
Okay.
dispute that would be around the time that you received the call from him,
yes.
right? Now, at that particular time, did you know where Mr. Marie was stationed in the mall?
No, sir.
And you received another call approximately 4 minutes later from Mr. Ansar, or you said 2 minutes later?
2 minutes.
Correct. And it was a more urgent call. Would you agree with that?
It was a more informative call, yes, sir.
And during that call, you subsequently received a call from Sergeant Chafin, right? Or walkie-talkie?
What do you mean during the call with Mr. Asari? No.
Okay, but I said after that. Did you receive a call or some communication with Sergeant Chafin about the development of this?
Yes.
Now, prior to that, how many officers were on duty when you received that call, if you know, in the mall for this security service?
I don't know. I don't recall if anybody else was there, but it was definitely us 6.
So 6 officers who are responsible for all of Northland.
Yes.
Everything was relatively still open then, right?
Yes.
Macy's, what else do they have? Target?
Macy's, Target, LA Diamonds, Foot Locker, the food court.
And isn't there like an elevated level or lower level as well?
The lower level was basically where security was. Everything was on one level. Macy's had 2 levels, but that was inside of their department store.
Now, when you first saw Mr. Marie on the 28th of January, where was he, sir, if you know?
I watched him walk up on camera.
Isn't it true that he was in dispatch with you when you received these calls?
I don't recall who was in dispatch with me, sir.
You wouldn't doubt that or you wouldn't say he wasn't, would you?
I cannot say if he was or if he wasn't, sir.
Okay, well,
Dispatch is not an open room. You would have to walk out of dispatch and walk through the rest of the security office to find out who was there, sir.
I appreciate that, but as you're sitting around there watching televisions or videos, you don't see Mr. Marie, is what you're saying, or you don't recall?
The way the room
But
sits,
that's what I asked him to answer.
He has answered it. He doesn't know one way or the other. Let's go on.
Did you communicate to him by walkie-talkie, if you know?
I don't recall, sir.
Well, when you saw that the first responders, it was only 3 individuals, or first initially there were 2 and then 3, or strike that as 1, then 2, and then 3, right?
Mr. Sebring and Mr. Chafin got up there at the same time.
Okay.
Then I believe Officer Hamilton walked up and then Mr. Gavin.
And you saw the situation escalating, correct?
I saw the situation as it was on camera, sir.
Right, and it was escalating. Would you agree with that? It wasn't just dissipating, it wasn't going away.
No, it wasn't going away.
In fact, you saw the need to dispatch other officers to that area, correct?
Anytime Sergeant Chafin called
Sir,
across the
listen to
radio.
my question.
Wait, please. Only one person speaks at a time. Please, Mr. Hale, listen to this question and answer just this question, right? Thank
Yes,
you,
ma'am.
sir. And don't speak over the witness.
I apologize. Sorry, Mr. Hale. Didn't you see the need to call every officer in that mall on duty to that area, sir? Yes or no?
No,
So you dispatch to certain particular officers to go to that area?
When Sergeant Chafin calls across the radio, every officer hears it. So when he called for assistance, everyone heard it. It didn't come directly to dispatch. It came over the radio to every officer that was on duty.
So you didn't facilitate that? You didn't say, Mr. Marie, we need you over in Section A?
I do not recall ever telling Mr. Marie specifically to go to LA Diamonds.
But as a dispatcher, you have, on this particular date, there's a possibility that you did dispatch fellow officers to that area, correct?
Objection, Your Honor, he had asked and answered, he's now answered it.
That's not the same question. I didn't say anything about dispatch. He's a dispatcher. I asked him, did he dispatch any officers over to that area?
Okay. Well, why don't you just ask him which officers he dispatched, or if he, to that area, or?
Oh, sure. Which officers did you dispatch to that area, if any?
I remember calling over the radio saying LA Diamonds is asking for assistance. I did not call out any specific names.
Okay, so your purpose in dispatching that particular communication is to have other officers go to that location, would you agree?
Yes.
And you never knew where prior to his arrival, you never knew where Mr. Marie was located?
I do not recall, sir.
Now,
If I knew at the time,
I'm sorry?
if I knew at the time, that's one thing. Again, this is 10 years later.
Well,
I
I'm
do not
telling you
re-
the time, it's at
No,
5:38.
he said at the time
Oh,
of
at
the
the time.
occurrence. He may have remembered then, but he
Okay.
does not remember now. Okay.
Now, being a lover of the movie RoboCop or RoboMall Cop or whatever it is, does this security staff or mall cop, sorry. I always saw it once or twice. Mall cop. Did you have any vehicles or equipment to transport the officers from one end of the mall to the other?
There was a patrol vehicle that they used outside to patrol the parking lots.
So your answer would be no as far as inside,
No.
none of those scooters or anything. So they would physically have to get to that location, right?
Yes.
And how far is Target from LA Diamonds? If you know.
I know where it's at in the mall. I don't know the approximate distance.
100 yards, 50 yards.
I don't know how to measure in yards, so I'd say maybe a quarter of a mile, if that. Because you have to make, from LA Diamonds, go down the hallway, make a right, go to the next hallway, make a left, and go straight.
That's if you go straight to LA Diamond, correct?
That's coming from LA Diamonds to Target, yes.
And how far is the dispatch office from LA Diamond?
From where LA Diamonds is sitting, there's directly across the hallway, there's some steps. If you go down the steps, you make a left, and dispatch is in the hallway, directly up under the hallway that LA Diamonds is sitting at.
Okay. So, did you make a third call as well?
To 911?
Yes.
Yes,
And that was at 5:49, correct?
yes,
You wouldn't dispute that. So, all of this took place from start to finish in less than 10 minutes, would you agree?
yes,
And for most of those 10 minutes, Mr. Marie is not even there until at the end. Would you agree with that?
yes.
And did you ever see Mr. Marie walk over and get a glass of water and give it to the individual who was slumped over on the post?
No,
And you never saw a video where that happened, is that correct?
no,
You're not disputing that it didn't happen, or did happen, you just didn't see it.
I just didn't see it.
Did you, well, in the chain of command, you didn't have any rank position.
No,
Did Mr. Marie have any rank position?
I don't recall.
After this incident, you made a police report, or strike that, you gave a witness statement, correct?
Yes.
And who did you give that statement to?
I wrote the statement out and put it in CAD, and I believe it was given to the police department.
Okay, but you didn't give it to anybody yourself, you just put it in, you inputted it in your system, and that was the end of it, correct?
I input it in the system, and then I did the handwritten statement, and it goes into a binder.
And other than that, you never talked to anybody from Southfield Police Department?
No.
Oakland County Prosecutor's Office?
I don't recall if I spoke to the Oakland County Police Department, no, to the prosecutor's office.
And once again, after the 28th of January, you continued your employment at that company, correct?
Yes,
And Mr. Marie also continued his employment at that particular company and location after the 28th, correct?
yes.
Were you aware of any of those officers receiving reprimands or being suspended by your company?
Objection, Your Honor, that would be hearsay.
If you know.
No.
Objection.
Thank you, sir. Nothing further.
Good morning, Mr. Hale. How are you?
Fine, and you, sir?
Okay, earlier you said, I believe, that you did not take the handcuff training, correct?
I was given handcuff training on how to apply the handcuffs and to make sure they were locked in place.
So you did take training. Wasn't it extensive training?
I'm sorry?
Was it an extensive training? Or how were you trained in it?
I had to read the manuals, and I was trained on how to apply handcuffs before I went on the floor to patrol by myself.
So you also took the continuing training too? Or were you?
I don't know what the continuing training is, sir.
Well, your training was through a manual, correct?
Yes.
Let's see. If I show you pages from the manual, would you recognize them?
I cannot say that I would, sir.
Okay, but you will be able to read and see if this looks like the manual that you took.
Yes, sir.
Okay. May I approach?
Yes, you may.
Just look over it and see if you recognize it, and I'll ask you the question in a second. Do you recognize that?
It looks familiar, sir.
All right. It states that it's continuing education training manual. Those are just pages.
Yes, sir.
The pages that I gave you are page 4, 5, 6, 7, 9, and 12. I believe in that order.
Yes.
I would like for you to read pages 4, 5, 6, and 7, the highlighted parts.
Your Honor, at this point, I'm an object.
It's part of the manual. It's an exhibit. It's in evidence. You may read it. Go ahead, sir.
Oh, I want you to read them out loud, please.
Oh, okay.
The highlighted parts. The highlighted parts on page 4, 5, 6, and 7 right now.
Page 4.
What page?
What's page first?
What
Page 4 is first. They're in order.
No, what page of the manual for the record are you
Page
referring
4
to? Page 4, okay, thank you.
is, well, they're all, it's page 4, page 5.
I see,
Yes, page
okay.
4 first. Read the highlighted part out loud, page 4.
First and foremost, we must revisit IPC international policy and procedures related to the use of force and handcuffs as strictly a defensive restraint tool in Unit 2. We must use all other options, including nonverbal and verbal communication and direction, to attempt to gain compliance before we use handcuffs. Handcuffs will never be used as a tool or weapon to gain control of a subject. Handcuffs must only be used as a restraint tool after you gain control of the subject and they can no longer physically resist. The police should be notified when use of handcuffs. Once a subject is handcuffed, the cuffs should not be removed until a police officer is on site to authorize and assist in the release of the individual and take them into police custody. Don't handcuff compliant subjects. Don't handcuff violent subjects until after we gain control of them so they are no longer able to resist. Always require the use of handcuffs. The 3 situations in which PSOs may detain individuals are intentionally damage or vandalism to center or IPC international property, assault to anyone, robbery, assault during the commission of theft. In essence, we may only detain individuals to protect people, center, and or IPC international property or ourselves. Detain the offenders if possible. If the offender is threatening or uncooperative, request assistance from fellow public safety officers or police authorities via your radio. The officer is not to subject himself or others to dangerous circumstances. In all cases, officers should avoid the use of force. However, there is no alternative. Use only the force necessary to detain the individual. If an officer is informed and subsequently determines that a customer has either been robbed or assaulted in the center, then prompt action is required. The officer should immediately contact the police department for assistance. If time permits, a public safety officer should attempt to find out if the victim intends to sign a complaint against the individual who committed an offense against him. In this case only, a public safety officer may pursue and detain an individual who he has reasonable cause to believe has committed criminal offense against an individual. This requires that the officer either witness the offense personally or there remains no doubt about the occurrence and identity of the offender, either through his appearance or action. Violent, the act of physically inflicting injury on a person or the attempt to do so.
Pause right there. You're basically reading the definition of violence right
Yes.
here. Okay.
What page is it on?
You read page 9.
And I'm going to 12 now.
I got 9 and 12.
You will be applying handcuffs on persons only when they become violent in the course of an apprehension or detention. In these circumstances, it is essential to gain control of the individual before trying to place him or her into handcuffs. Control is gained through physical intervention as necessary to neutralize the individual. Once the control has been gained, handcuffs should be applied if it is necessary to maintain control until arrival of local law enforcement officers. You should use this technique learned in the course or techniques as close as possible to them when applying the handcuffs. Because of the nature of the event, you may not be possible to use these methods exactly as outlined. Remember that the most important part is to use handcuffs to prevent further injury to you, other people, and the person being handcuffed. In short, get the handcuffs on the person without anybody getting hurt.
Okay, thank you. You were the dispatcher that day, basically.
Yes,
So you were the person responsible for calling the police.
yes,
You called the police. Did you call the police before the second call from the LA Jewelers owner or after?
after.
After the second one. You also had a handwritten statement that you made to the police, correct?
Yes,
In that statement, you stated that the subject charged Sergeant Chafin, correct?
yes,
Okay. You also stated that when you called the police, that the officers were trying to get the subject under control, correct?
yes,
And that they were unable to get the subject under control.
yes,
Okay. You also stated in your report that to make sure, you said lot J, that was not the closest lot to the incident you stated before, correct?
sure.
Do you know about how much time or how far away those 2 points are in relevance of time in getting to them?
No,
Okay. But you also stated that the situation was on the other side of the mall in your report.
yes,
And to be fair, you were also typing at the time that all this was happening.
Yes, sir.
So you did not constantly look at the video to see what was happening in the video.
No, sir.
Correct. Sorry. All right, at that time, someone had to stay in dispatch at all times, correct?
yes,
So everybody else had responded, you're the only one who was left with responsibility of being in the dispatch at that time?
yes.
All right, thank you. No further questions.
Any redirect?
Just a couple of questions. The first question, Mr. Hale, is that I believe you were asked a question. I think it was Mr. Elder that asked you a question. He said, if you were there with Sergeant Chafin, wouldn't you have assisted? And your response was no.
Yes.
Okay, and why wouldn't you have assisted with Sergeant Chafin?
I was hired as a visual deterrent. Wasn't there to wrestle with nobody. That wasn't the first situation where they got physical with somebody. Not to mention the fact it went against my personal beliefs at the time, because during the day I worked as a nurse's assistant. I wasn't there to hurt anybody.
And Mr. Braxton had you to read some portions of the handcuffing procedures.
Mhm.
Yeah, say yes for
Yes.
the record. Yeah, keep your voice.
That's all right.
Okay. So could you read from the first paragraph, this, and I'm referring to page 18, first paragraph.
Are we talking about the manual?
Yes, this is the manual, this is exhibit 46.
Okay.
First paragraph, page 18, if you could read that portion.
When in handcuffs, subject will have limited ability to move, balance themselves, defend themselves, or catch themselves should they fall. Once you have placed handcuffs on someone, you have assumed the legal and moral responsibility for protecting them from harm. This means that you cannot leave them alone, let them trip or fall, damage their wrists or shoulders, etc.
And I believe there is a last portion on that, page 18. Let me just see if I can take this, if you could read that. The last paragraph in the two bullet points.
You must also be aware that handcuffed subjects, as a result of their limited ability to move, are at greater risk of suffering positional injuries. Positional injuries are injuries caused by placing a handcuffed individual in positions that have been shown to cause or aggravate injuries, including muscle strains, broken bones, and positional asphyxia. Positional asphyxia, suffocating as a result of a person's position restricting their ability to breathe normally. Avoid leaving people lying face down or hunched over in any way that could restrict the flow of air through their lungs.
Thank you. That's it.
Sir, are you aware of the fact that once the handcuffs were placed on Mr. Cochran, that within a very short period of time he was rolled over to the side? Are you aware of it?
No, sir.
Are you aware, did you see them roll him over on the side through the video that you're watching, or you didn't see that part?
I didn't see them roll him over, but I saw them lean him up against the wall,
And
help him sit up.
Did you see them also try to give him water?
No, sir.
Sir, you indicated that she asked you about a question I asked you about whether or not you would have helped Sergeant Schaefer.
Yes.
And you said it goes against your beliefs, correct?
It went against, yes,
So you worked here for, you said 3 months?
yes.
So you took money from a person, a company that gave you a job. You're supposed to, you read the manual, but you still stayed there and worked there knowing that's part of your job, correct?
We were hired as visual deterrent, sir.
My question was, you read the manual, it went against your beliefs, but you still worked there and you took their money, correct?
Yes.
Knowing that if someone, your fellow employee, needed your help, you wouldn't have helped them, correct? Yes or no?
It depends on the situation, sir.
So your answer is, depending on the situation, someone can get hurt, someone can get, maybe they can, depending on the way you feel that day, right?
Yes, sir.
Nothing further.
No questions, Judge.
No question.
Thank you. You may step down.
Thank you.
Thank you. Watch your step, please. Ladies and gentlemen of the jury, do you wish a brief recess before the next witness?
Cyber claim case number 2023-284857 FH.
My clerk is lining up the jury. As we speak.
All rise for the jury.
You may be seated. Call your next witness, please.
Thank you. At this time, the people will call Jill Jacobs.
Question step. If you could please turn towards me and raise your right hand, please. Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give before this court is the whole truth and nothing but the truth?
I do. Good morning.
Morning.
Could you say and spell your first and last name, please?
Jill Jacobs, Jillljacobs.
Thank you. And where do you work now?
Now I am a therapist with Solid Ground and Frontline Consulting.
And in 2014, was that how you were employed?
No, I was with the City of Southfield as a police officer.
And how long were you a Southfield police officer?
At that time?
Yes.
Okay, I got to do math. From 96 until 2014. So 14, 15, 16, 17, 18 years, I think.
Okay, on January 28th of 2014, were you working on that day?
I was.
And
And do you recall receiving a police run to the Northland Mall?
I do.
Is that in the city of Southfield?
It is.
County of Oakland?
Yes.
Were you working alone or with a partner?
It's solo in a car.
And do you recall the nature of the police run you were responding to?
Some type of disturbance.
Was there any other information, or were you just told some type of disturbance?
I'd have to look at my report to
Would
be
that re-
specific,
would
to
that
refresh
refresh
my
your
memory.
memory?
Yes,
Do you have a copy of your report?
I do.
Okay, please review that and let me know when your memory is refreshed.
The exact verbiage was trouble with the subject.
Okay. And did you actually respond to that police run?
I did.
What happens when you arrive at Northland Mall?
I was dispatched with another officer, Rolando Rivera, and we responded to the area that we were initially dispatched to, and we went in, and it unfortunately was the wrong location we were dispatched to. So we went inside, and then as we were trying to determine where the actual location was, a passerby saw us and asked us if we were looking for a certain situation. We said yes. He directed us towards it. As we were going to where the incident was, one of Northland security sergeants also ended up meeting with us and walked us to the rest of the area.
Okay, so from the point that you actually enter Northland Mall to when you actually get over to the area where the incident took place, you know about how long that took?
A few minutes.
And when you encounter the security sergeant, does that person take you the rest of the way?
Yes.
Okay. And what happens when you actually get to the area of the incident? Well, first, let me back up. Where is the incident inside the mall?
It is on the east side of the mall. We entered on the west side of the mall, and it is in front of a jewelry store.
Okay, do you recall the name of the jewelry store?
I think it was Diamond. I'd have to look at my report to be specific.
Oh, that's fair, it was 10 years ago. If that will refresh your memory, please do so.
LA Diamond.
Okay. And do you recall if this was inside LA Diamonds, or where was the incident as it related to LA Diamonds?
It was now on the outside in the hallway area, but at the pillar of LA Diamond.
Permission to approach the witness, Your Honor, if you may. I'm going to hand you what has already been admitted as People's Exhibit 51 and ask you if you recognize the story depicted in that photo.
I do.
And what is that?
That is where the incident took place of LA Diamonds.
Okay. And you stated that the actual incident that you responded to ultimately was outside of LA Diamonds. Are you able to direct us on that photo where the incident was?
To the right side of the entryway, where the column is that's gray with the blocks behind the red planter.
Spotlighted an area, am I in the right area?
That's the exact area.
Okay. Now, when you actually get to the area that you're ultimately get to the area you're responding to, what do you see?
We see some of the security guards are there. There was an individual on the floor who was handcuffed. One of the security guards was checking for a pulse. At that point, our preps did not work well inside, and I wanted to make sure that a life unit was on the way, so I went to an area near an entry-exit door of the mall in order to notify dispatch that we needed life to go code if they were not yet.
Now, first I want to talk to you about the handcuffed individual. Where was the handcuffed individual?
The exact spot that you had highlighted right there.
Was he standing against that post?
He was sitting down, slumped.
And I believe you said he was handcuffed?
Yes.
Okay, at the time that you approached the LA Diamonds area, is the individual talking?
No, unresponsive.
And you stated that you observed one of the security guards check for a pulse, was that correct?
Yes.
Do you recall which security guard that was?
I would have to look at my notes or my report for the exact name.
If that will refresh your memory, please do so.
Officer John Sieberling.
Now, what was it about the situation that made you want to radio and say go cold?
Because we had someone that was unresponsive,
Okay, and what does go cold mean?
that they're gonna use their lights and sirens.
And once you made that call over the radio, did EMS actually respond?
They did.
Okay, and do you know about how long after you made that radio call to go code did they respond?
I don't know the exact time, but it was quick.
And what happens when EMS finally arrives?
They made their way to where the individual was, and then they started their assessment, and at some point they started to use an AED.
And were you standing by when EMS started to, try to perform service on the individual?
Yes,
At any point in time, did you see the individual being responsive?
I did not.
What happens next?
The handcuffs were removed before EMS or our life unit started theirs. Then they took him and transported to Providence Hospital.
Okay. And do you remain at the mall while the individual is being transported?
Yes.
Okay, and what do you do at the mall?
Started collecting statements from the security guards that were involved in the incident.
And do you do anything else?
I notified dispatch that we needed detectives to come out to the scene, and then at some point our sergeant was also on the scene.
Now, I know you've talked about the individual was unresponsive. Was there any attempts to kind of at the scene identify who the individual was?
I did not.
And did you observe any weapons on the person?
I did not.
I'll pass the witness.
Good morning, ma'am.
Good morning.
How are you today?
Good, how are you?
Ma'am, back in 2014, you were kind of familiar with some of these security officers at Northland Mall, correct?
Yes.
Right. And that was through the number of times that you would be called to Northland Mall as part of your duties of being a police officer, correct?
Correct.
Right. So they had called for assistance at Northland Mall so many times that you became familiar with the security guards that worked there.
Correct.
Right. Now, when you are dispatched, is there a CAD entry that's made? Are you
Yes.
familiar with that?
Yes.
Now, you recall being dispatched for a man making threats to kill people?
I don't recall that.
Would it refresh your memory to see the CAD report from that day?
It would.
May I approach on? Thank you.
Oh, gosh. They're in my bag. I should be able to make it. Sorry. Mine are in my bag, so sorry. These might help.
You expect to be reading.
I didn't. Oh, much better. Okay. Yes, there are notes in dispatch saying making threats to kill people.
Thank you. How long has it been since you retired from being a police officer?
Just over 4 years ago.
Oh. It's probably been that long since you've had to come to court?
No.
No? All right. So, when you were working as a police officer, if the dispatch is, there's a man making threats to kill people, that's something you're going to take serious, correct?
Yes.
Right? Regardless of whether or not anybody reports actually seeing a weapon.
Correct.
You're not going to make any assumptions about the person being unarmed, right?
Correct.
When they say they're going to kill people.
Yes.
Right? And so you would have a concern for weapons yourself, right?
Yes.
Right? And you would be, anytime threats are made, especially about killing people, you would expect a volatile situation, right?
Possibly, yes.
And you would have concern for your own safety, correct?
Yes,
And the safety of other people, right?
yes,
Now, you arrived at the J lot with Officer Rivera on that day, correct?
correct.
And at one point you said you were looking for LA Diamond on the mall directory, right?
Yes.
And you couldn't find it listed there?
I don't know if it was listed or not, or if somebody saw us looking for someone first.
Okay. All right. So, but somebody approached you and said, "Hey, you're looking for the guy that security is restraining."
Yes,
Right? That was what you were told.
yes,
Right? And then they directed you there.
correct.
Right? Now, at that point, how long of a delay do you think it would have been from when the call came in?
A few minutes.
All right, so what, say maybe 5 minutes or so?
I would have to, actually on the CAD notes, it might say from our time of dispatch to arrival. It should be timestamped.
Coach on?
Yes,
You're probably better at reading it than me. If you find some information, let us know.
So it looks like we were dispatched at 18:04, which is 6:04. We arrived at 18:12, which is 6:12 p.m. I'm sorry, back up. I'm looking at the wrong, I'm looking at one of the other supervisors that was dispatched. We were originally dispatched at 17:41, which is 5:41. One of us, I don't recall which one, arrived at 17:49. The other, it shows, arrived at 18:08, which is 6:08.
The ones after 6 p.m. you would assume would be sergeants and detectives being called
Correct.
after
Correct.
the initial response.
So the initial dispatch time was at 5:41, 17:41, and then the arrival was approximately 8 to 9 minutes later. The other unit, looks like they took them a little bit longer to get there, or for someone to indicate that arrival had happened.
So when you say the 8 to 9 minutes, you know that's you arriving at the J lot?
Yes, that is us arriving. Well, that was me arriving at J Lot.
Right. And then at some point, there's a couple more minute delay.
Yes,
By the time you go look at the mall directory, a citizen comes up and says, you're looking for the guy security's trying to restrain,
yes,
and you get directed over there, right?
yes.
Okay. Now, then Sergeant Chafin approached you,
Yes,
right? And he advised you that the help command is not responsive now. Is that right?
I don't know what he said, but he got us to where we needed to
Okay.
be.
He came in
Yes,
and got you there even quicker.
yes,
Basically. Okay. Now, once you arrive at a scene at Northland Mall, you are now responsible for the scene, correct?
yes,
Right? You expect the security officers that are there to follow your orders, right?
correct,
You don't expect them to do anything unless you instruct them to do it, right?
correct,
Because you're the police officer from Southfield Police.
correct,
And that's what happened that day?
yes,
You knew that their protocol was that once they handcuffed someone, they were not to take those handcuffs off until a police officer arrived, correct?
Yeah, and I'm gonna object, lack of foundation.
Judge, she said she's been to Northland Mall so many times that she's familiar with all the security officers there.
I understand, but that doesn't mean that she knows exactly what's done in
Oh.
every situation. So we lay a foundation or ask another question.
Will do. Ma'am, about how many times would you say you had responded to Northland Mall before that day? If,
hundreds?
all right. And some of those times that you responded to Northland Mall, you would see that there were people that security had handcuffed, correct?
Yes,
And those handcuffs would remain until you or one of the Southfield police officers told security, take those off, correct?
I don't know what their protocol or policies were,
Okay.
so I can't say what would absolutely happen.
But in your experience, not knowing what's in their training manuals, you would agree that that was the course of action that would take place when you arrived and found that they had handcuffed somebody. You or a fellow officer would tell them, hey, I need you to remove those handcuffs at some point, correct?
I would not be able to give a definitive yes or no for this.
No problem. On that day, you yourself did not try to render aid yourself, correct?
No,
In fact, though, you were trained in CPR and first aid, right?
yes,
And you actually were an instructor for fellow officers on CPR and first aid, correct?
yes,
And Officer Rivera, who's with you, he's also CPR and first aid certified, correct?
yes,
Because all of the Southfield police officers had to be.
yes,
Right? Now, you observed Officer Seiberling actually checking for a pulse, correct?
yes,
And the officers were trying to render aid, correct?
yes,
And from what you observed, it appeared to you that they were doing exactly what they should be doing, correct?
yes.
Right. And so you didn't see a need for you to step in or tell them to step aside. I want to take over, correct?
Correct.
Right. In fact, you left the scene at one point because you said your radio wouldn't work inside and you wanted to step outside to.
Correct.
I think, what was the code you used?
To tell the dispatch to have life go code, which
Okay.
means lights and sirens.
Got it. And then at that point, you waited for EMS to arrive, right?
Yes.
Okay. And it was about 10, 15 minutes later?
I don't know the time frame, but they were there quickly.
All right. Now, you know for certain that you arrived before EMS, correct?
Yes,
Right. So it wouldn't be true that an EMS, how do I say, EMT, emergency medical technician would have been walking in with you and Officer Rivera, correct?
correct.
That is
They were not.
incorrect, for sure.
They did not.
Okay. You ordered the handcuffs removed after EMS arrived, is that right?
Correct.
Before EMS arrived, you wanted the handcuffs to remain, correct?
It didn't matter to me at that point. I just wanted to get advanced life unit.
Okay. Hey, no other questions?
Hi, Ms. Jacobs.
Hello.
I just want to pinpoint the exact time you saw the person slumped on the floor. Because I know you arrived at the mall, wrong address, the wrong location.
Yes.
What time was it, if you know, when you first saw that individual?
I don't know the exact time.
In your report, you indicated it was before 6 o'clock. Would you agree with that?
Yes,
Now, you've also testified that you've been to that mall hundreds of times and you're very
Yes.
familiar with it. Now, back in 2014, was the mall equipped with any portable life-saving devices?
I don't
If you
know. I don't know.
And you said that your duty, well, you remained at the scene and you collected witness statements,
Yes.
correct? How many witness statements did you collect?
Well, I started the witness statements. I did not collect them. I believe that the detectives ultimately were the ones who took the statements, or physically took the statements.
So when you said you started some, you took names and notes?
And I gave them the pieces of paper to start writing their statements.
Okay. Did you take statements from Mr. Marie, one of the security officers?
Whatever security officers were there involved, each of them were given instructions to start writing their statements. I don't recall all of their names.
Okay, and no one refused to make a statement. Would you agree with that?
Correct.
You also said there was an officer there who was collecting evidence.
Yes.
Were the handcuffs collected as evidence?
I would have to look at my report
By
to
all
see.
means, if that a refresher recollection.
Yes, they were turned over to our specialist, who is our evidence tech,
Okay, and who was that individual?
Pat Meyer.
Thank you.
Good morning, how are you?
Good, how are you?
I'm good, thank you. I have a couple of questions. Well, since you were an officer, with your extensive training, you were trained in the law, correct?
I'm sorry, I couldn't.
You were trained in the law?
Trained through the law?
No, trained in the law.
Yes.
Okay, so you had to know the elements of any crime, so in order to arrest the person, correct?
Yes.
In your years of being an officer, you've arrested people and you've checked off those particular elements of that particular crime, correct?
Yes.
So if you had a crime of, you have a crime of assault and battery, are they the same?
Assault, well, there could be assault, or there could be a battery, or there could be an assault and battery.
Okay, can you explain the difference of the two?
Objection, Your Honor, relevance.
Your Honor, I believe she is a witness for the crime, but she is also a expert in the area of this particular law of arrest, and because she's worked in years as an officer of the law, and she's arrested many people for the crime, the accused crime that my client has been accused of. So I believe that she is the crime of assault. So I believe that she would qualify as an expert witness also.
All right, well, correct me if I'm wrong, but I believe that what the defense is indicating is that there was an assault made by Mr. Cochran against Sergeant Chapis. Is that, am I correct in that?
Yes.
And Mr. Ansar.
And Mr. Ansar, so I will allow the question.
Thank you.
I'm sorry, would you say it again?
Could you explain what assault and battery is and what's the difference?
Unfortunately, I'm a psychologist now, and I truly would have to look this up to be definitive before I'm going to say this is assault, this is a battery. I would have to look it up in the, at that time I would not have, but I've been retired for 4 years.
Okay, that's fair. Let's see. Well, are you able to remember any of the elements of assault at the time that you arrested someone for? Have you ever arrested someone for assault?
I have.
Relevance.
Okay,
That's too far.
well, it's a little far to go, yes, okay.
All right. If someone, back when you were an officer, if someone made a threat, would you actually have to wait until the person actually hit them for it to be an assault?
Not in all circumstances.
Or before you arrest them?
Not in all circumstances.
Not in all circumstances.
Correct.
So they could actually verbally, it could just be verbal,
It could be.
just. That's not, thank you.
Can you read the record?
Please. Thank you. Good morning again.
Good morning.
All right, well, we should start where we left off. Threats. If you were called, if you had a police run for someone making threats, how would you assess that situation once you arrived?
I would interview the individuals and ask questions.
Would you somebody?
No.
And, if someone makes a statement that is threatening but not directed at anyone in particular, would you just go and grab that person?
Most likely no, but every circumstance can be different.
And during your career as a police officer, have you had to deal with people who may have had mental health issues?
Objection, relevance, because there's no evidence that anybody involved in it had mental health issues.
I believe the 911 call called for a 10100, which was described as a disturbed person.
Well, that doesn't mean somebody is mentally ill, so.
Well, I'll say disturbed person. I'll rephrase your honor.
Sure.
Go ahead, if you change your question.
Have you had to respond to runs that involved a disturbed person?
I have.
And how do you first assess that situation?
Objection to relevance in this case, that you have runs with disturbed people.
I'll rephrase. Have you responded to the mall for disturbed people?
I have.
And how do you assess those situations?
The same objection, it has nothing to do with this case. She's not the first responder, she's not the person that the initial contact with the decedent, so her experience for this has no relevance whatsoever.
Well, she was actually the first responder for Southfield Police, but I will rephrase the
Well, yes,
question.
by the time she got there, it was past the occurrence here, so.
Let's see if I can rephrase it again.
Try your best.
I'll do what I can. When you received this run on January 28, 2014, were you advised that a disturbed person might be involved?
I'd have to look at the CAD notes or my report.
Please do, if that'll refresh your memory.
I would actually need to see that again.
I'm sorry?
I would need to see, yeah. All the lovely glasses again. So, yes, so dispatch would have said Northland stating that he is mental and making threats to kill people. So that would have alerted to me that there was possibly some type of mental illness or disturbed person.
And would that affect how you respond to the scene?
Well, so unfortunately, it's difficult for me to say what I would have done 10 years ago because of my new position.
Would you automatically have gone in looking to arrest somebody, or would you first start by assessing the situation?
Always assess any situation.
Thank you. And when you first came upon the scene actually at LA Diamonds, and you observed the individual already handcuffed, did you observe anyone actually performing life-saving measures?
The one officer was checking for pulse, so that would have been one of our first measures to make sure that they're breathing.
Anything else?
That was the only thing that I saw.
Thank you. Nothing further.
Ma'am, if you are told that somebody is making threats to kill people, and then you respond, you said you want to assess the situation, okay?
Correct.
Right? Now, if you see this individual and you direct him to an area, you tell him to walk away from the person who said he was going to kill someone, right? And he just stands there. Does that factor into your assessment of the situation?
It does.
All right. And if at some point he starts to approach you and you tell him, sir, do not approach me, is that something you would say? Sir, do not approach?
Potentially.
All right. And if he does approach, how does your assessment change?
It depends on the set of circumstances.
Knowing that he had told you he was going to kill somebody, and then he approaches you, do you then have a concern about your safety?
Potentially.
And if he gets closer, the higher your concern becomes, correct?
Potentially, yes.
If his fists are clenched, is that something that would weigh on your mind
Absolutely.
as he's getting closer to you?
Yes.
Correct? Would you at that point take defensive measures to protect yourself?
In some cases, yes.
Would you consider pepper spray to be a defensive measure?
I would.
And you would consider it to be appropriate in that situation of somebody having threatened to kill someone and then approaching you after you told them not to, correct?
With the additional information, yes.
With his fists
Yes.
clenched,
Yes.
right? All of that information, if you were there, you would feel that applying pepper spray to that individual is an appropriate measure to defend yourself, correct?
I think that would be appropriate.
And once you've pepper sprayed that individual, you would want to restrain him, correct?
Correct.
Put him in handcuffs, correct?
Yes.
To prevent him from grabbing any objects or causing you any harm, correct?
Or others.
Right. You would have concern for yourself and for others, right?
Yes.
And if your fellow officers saw you struggling to put the handcuffs on that man, you would expect them to step in and help you, correct?
Your Honor, I'm going to have to object at this point. This exceeds the scope of redirect.
It is completely within the scope of every right.
I stopped at assessing the situation. We've gone to now we have people jumping in after an arrest.
Okay, well, that's assessing the situation. I'm overruling the objection.
If you were struggling with the man who threatened to kill somebody and approached you with his fist clenched, and you could not get the handcuffs on him, Officer Rivera was there with you that day,
Yes.
right? Was he a normal partner to you, or just that day he was your partner?
Just one of the officers.
Okay, all right. If a fellow Southfield police officer was on scene, you would expect that they would step in and help you, correct?
Absolutely.
All right. And if you had walked upon a fellow officer attempting to restrain somebody and not being able to, you would step in and help that officer, correct?
Yes.
If it was two officers trying to restrain that individual and unable to do so, you would help them, correct?
Yes.
If it was three officers trying to restrain the individual and unable to do so, you would step in and be a fourth person to help them, correct?
Correct.
A fifth?
If needed.
No matter what the number is, if they are struggling, you would step in to help them, correct?
Yes.
And that's what you would expect any officer to do, correct?
Yes.
Or a normal citizen, right?
I can't say what a normal citizen is going to do.
If you saw someone struggling today, you're not an officer, do you think you would step in to try to help?
I'm not a normal
Objection, Your
citizen.
Honor. Relevance and
Oh.
deceased
Just
scope.
say,
I'll withdraw the question.
thank you.
Thank you. I have no other questions.
No questions, Sean, no questions.
Thank you.
Thank you.
You may step down.
Thank you.
Ladies and gentlemen, it is about, according to my computer time here, it's 11:52. Would you like to be released for lunch, or do you want to continue with the next witness, knowing full well it will carry you past the lunch hour?
Can we approach?
Yes. Never mind? Okay. So, ladies and gentlemen, what's your pleasure?
We can continue.
Your next witness.
This time the people will call Patricia Meyer.
I'm sorry.
Patricia Meyer.
forward, please. The door opens towards you, so please watch it. Watch your step.
And if you could please turn towards me and raise your right hand. Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give before this court is the whole truth and nothing but the truth?
I do.
You may be seated.
Good morning.
Good morning.
Could you please say and spell your first and last name, please?
Patricia Meyer, Patricia, Meyer, Meyer.
And in 2014, where did you work?
I work for the city of Southfield as a police officer specialist.
And in total, how long did you work for the city of Southfield and the police department?
I retired in 2015 with 27 years, 8 months on.
Congratulations. Were you on duty on January 28, 2014?
Yes, I was.
And did you respond to an incident at the Northland Mall?
Yes, I did.
And is that in the city of Southfield?
Yes, it is.
County of Oakland?
Yes.
Do you recall what incident you were responding to on January 28, 2014?
I was responding to, at the time, a disorderly person.
And in January of 2014, what was your role within the City of Southfield Police Department?
I was a police officer specialist, which meant that I worked the road, but I also did evidence tech work.
And so on January 28, 2014, when you arrived at Northland, what's the first thing you observed?
First thing I observed was the Mr. McKenzie. He was handcuffed and sitting up against the post, and I went outside and flagged down the life support unit. They were having a little trouble trying to find the entrance, the correct entrance to come into the mall.
I'm going to ask you to try and keep your voice up.
Okay.
Okay. So if I heard you correctly, you went outside to flag down the life unit,
Yes, I did.
and were you able to do that?
Yes, I did.
Okay, and what happens when you flag down the life unit?
They came inside. I followed. They immediately started working on Mr. McKenzie. They took him out of the Northland Mall on a gurney and to Providence Hospital, and I followed them there.
Now, when you first enter the mall and you make your initial observation of Mr. McKenzie handcuffed, are you able to assess at that point in time if he's responsive or conscious?
I didn't see him saying anything or anything, but I literally just kind of ran past and ran out to get to flag down the life support unit because I was listening to the fire channel on my radio, on my prep, and they were having a difficult time, and I wanted to make sure that he got medical treatment as soon as possible.
And when you actually return to the area, the life unit is already...
Yes, they are there.
Okay.
Yeah, I followed them in.
Are they already beginning life-saving measures when you return?
As soon as I followed them in, and they immediately started, to try to revive him.
And at any point in time, do you see whether or not they can successfully revive McKenzie at the mall?
No.
Okay. And do they ultimately leave the mall with Mr. McKenzie?
Yes, they did.
Well, it's just a comment.
Mr.
What do you do at that point?
I followed them to Providence Hospital ER.
And why do you do that?
Because I am following them to collect any evidence that might be on Mr. Cochran's body.
And about how long does it take you and the life unit to get to Providence from Northland Mall?
Maybe 4 minutes, because Northland Mall and Providence are within a couple blocks of each other.
And what happens when Mr. Cochran his care is turned over to Providence?
I believe it's Dr. Stephen Avenchek worked on Mr. Cochran, trying to revive him. Unfortunately, they were not able to do so.
And at the point that Mr. Cochran's death is called, what do you do?
I start collecting evidence, taking evidence from Mr. Cochran, as far as clothing, anything that might have been inside the clothing, and then I photographed him, and I noticed, any type of injuries or anything like that.
Okay. Well, let's start with the clothing. Do you check the pockets before you actually take the clothing?
Yes.
Did you find anything in the pockets?
Inside the front pocket of his jeans, there was $644. And inside he had like a black winter coat on, and in the inside pocket of the black winter coat had a receipt from John R. Appliances. And it had a name on it and was just like a receipt.
And what did you do with those items?
They were turned over to the Southfield property room.
Okay. And you said you take the clothes as well?
Yes.
And what clothing items did you take?
His socks, his underwear. He was wearing a black T-shirt and then a gray shirt underneath, like a shirt, or as he used to term it, a white beater shirt. He was wearing a black coat, gray jeans with a black belt.
Did you find any weapons on Mr. Cochran?
No.
And you also looked for injuries, is that correct?
That's correct.
Did you find any injuries on Mr. Cochran?
I just saw a slight abrasion on his left knuckle.
That's it?
That was it.
And after you make these observations and recoveries, what, if anything, do you do next?
I went back to the store where the incident occurred, and I took photographs of the store and the area where the incident occurred.
And what's the importance of that?
So that in case we need them, we have an idea of how it actually looks.
Now, when you go back to Northland and you photograph, do you observe any weapons either in LA Diamonds or in the area of where you first observed Mr. Cochran?
No.
Do you observe anything of note when you return to Northland?
No.
Now, I previously showed you a series of photographs. Did you recognize those photos?
Yes.
And how did you recognize those photos?
Those are photos that I took.
And those were taken on January 28, 2014?
Yes.
Did they accurately reflect first the scene of LA Diamonds as well as items that were collected by you?
Yes.
Did you collect any evidence at Northland Mall?
Yes, I did.
What did you collect?
I collected the handcuffs that were used to cuff Mr. Cochran, and I also collected a can of pepper spray that was used to spray Mr. Cochran. And those were also turned over to the Southfield Police Department property room.
Commissioner to approach your room?
Yes.
Thank you. Those who would have been marked as People's Proposed Exhibits 48 through 66. Do you recognize those?
Yes, I do.
Those are the photos that you reviewed earlier today and that were actually taken by you?
Yes.
People would move to the People's Proposed Exhibits 48 through 66, excuse me.
No objection.
Commissioner Publisher?
Yes, you may.
For purposes of the record, we're looking at Exhibit 48. Could you tell us what we're looking at?
That's just the leaderboard for the SD card, so that it's got the complaint number on it, where it happened, what it is, the date I took it, and the time that I started the SD card. And it's my name.
So that time says 1900,
Yes,
7 p.m.
7 p.m.
Looking at exhibit 50, what are we looking at?
That's the LA Diamond Store, exterior facing south.
And moving forward to exhibit 53, what are we looking at?
Again, the LA Diamond Store, it's looking south west, but that's the east side of the LA Diamond Store.
And in this picture, are you able to point out where you first observed Mr. Cochran? When you first come into the mall?
No, not.
Where was he?
He would have been, there was a post further out from the store, I believe. I don't even know if it's,
Okay, looking at people's exhibit 51, do you see the post?
no, I don't. Okay, maybe I am mistaken. It might have been that front post there by the LA Diamonds.
Are we looking to the left or the right?
To the right.
And I have a post spotlighted. Does that help?
Yes.
And just for purposes of the record, that's to the right, kind of not quite behind, but behind that burgundy planter. Now let's go to exhibit 66. What are we looking at then?
That is the receipt, a copy of the receipt that I found in his inner pocket of his coat.
Now, when you were going through the pockets, did you find any forms of identification?
No,
Was this the only thing that had a potential identification on it?
yes.
And what are we looking at on exhibit 64?
That's the money that was in his jeans pocket.
In exhibit 65, is that the same money?
Yeah.
And is there a reason you take two photographs of it?
Just so that you can see the denominations and that, yes, the $644 is there before I put it into property.
And looking at exhibit 63, what are we looking at?
That is Mr. Cochran's phone,
And where was that recovered?
from Mr. Cochran.
Do you remember specifically where it was?
Actually, no, I do not.
Looking at exhibit 62, what are we looking at?
Those were the handcuffs that were used to secure Mr. Cochran.
And is that one or two sets?
That is two sets linked together.
And is that how you received the handcuffs?
Yes.
And looking at exhibit 60, what are we looking at?
That is the pepper spray that I received from Sergeant Chafin, Northland.
And then people will pass the witness to.
Ma'am, you are looking for evidence. When you find evidence, you photograph them, correct?
Correct.
And if you find a piece of evidence and there's evidence on that item, you zoom into that, correct?
If I can, yes.
You found no blood stains on these handcuffs, correct?
Not that I saw, no.
And so nothing to indicate they were used as a weapon, correct?
Correct.
And you indicated that you saw abrasions on his hand.
I saw just like a slight abrasion on his left knuckle.
Okay, so that can be from being aggressive.
That's correct.
And you take photos of things that you believe may be relevant to a case, correct?
Correct.
And to a theory of a case, correct? And
I'm
to
sorry?
a theory of what a case may be about, correct?
No, I just take what I think is going to be evidence.
Oh. Did you photograph his knuckles?
I do believe I photographed his body, his person. Yeah, I don't see any of those photographs here. It's recorded in my report that, yes, I photographed his body, so probably did, yes, but they're not here.
So to take a photo of his knuckles, that's something that you saw, you found very important, correct?
Well, it's something that I most likely would have taken a photo of. It's just not in these photos here.
Have you ever photographed an individual accused of domestic violence that had injuries in his knuckle on someone else?
Objection, relevance.
Judge, the foundation is that Your Honor, she photographs injuries, and she has an understanding that herself, national aspect, Judge.
There's no relevance to a domestic
Okay,
violence.
fine. You took a photo of his knuckles because that may be evidence of aggression, correct?
Yeah, I'm gonna object. It's
Why are you
still
looking at her? Answer the
speculation.
question.
I'm objecting.
Was she?
She is objecting.
It's still calling for speculation.
So she's an evidence then.
I don't believe she.
Okay, look,
I'm sorry. I did not know the court was getting ready to speak. I apologize.
Ms. Meyer, why do you take photographs of injuries on someone's body?
I take photographs of injuries on somebody's body because it might prove to be evidentiary at some further time in trial or in court, or a way of determining at some point in time what might have occurred. So,
And a photo of someone having an injury in their hand may be indication to what in your mind.
that they,
She was a police officer for 27 years. I think she can answer the question.
that there was an injury there. Not how it was sustained or anything like that, but there was an injury there.
So you don't have any basis as to why a person may have an injury in their hand in a situation like that, on her knuckles?
Yeah, I believe that was asked in action.
Thank you.
Ma'am, you indicated that there is no other injuries on this individual's body, correct?
There was nothing else that I noted at the time.
Okay. Ma'am, do you recall, you indicated that this was because you got a call to the mall because someone's being disorderly, correct?
It started off as a disorderly subject at the mall. That's the way our dispatch.
Did you get information indicating that this individual making threats to kill someone?
No.
Ma'am, you were notified of this through dispatch, right?
Yes, I heard it over dispatch.
Okay. So if dispatch says making threats to kill, would you agree with that? If the CAD report says that?
I do not remember what was actually dispatched, what the actual dispatch sounded like.
Okay. If I showed you the CAD report, would that refresh your memory?
It might.
May I approach John?
Yes.
Thank you. Do you see the highlighted blue, man?
Yes. I see it in the CAD report. I do not know if it was actually dispatched as such. I don't remember what the dispatch, if you had a recording of the dispatch, that might say, but just because they wrote it down, it's in the CAD report, doesn't mean it was actually dispatched over air.
So you don't know whether it was this.
I don't remember if it was or not, I'm sorry.
Thank you.
Ms. Meyer, you said that you had a dual role that particular evening. One as a police officer and the other as an evidence technician, correct?
Yeah, that's the role of a specialist in the city of Southfield. You're a peace officer, but you also have to take fingerprints, photographs, collect samples of blood evidence, any of that.
Okay, and you're not out there just freestyling, are you? You're directed by a detective or another officer about photographs or?
No, I have enough time on, you have to have a certain amount of time before you become a specialist, at least when I was there. And yeah, a lot of schooling and everything, so yeah, I don't need a detective to tell me what to do or another officer to tell me what to do. They usually just tell me what they saw, or, you know, there's something over there or something over there, and I will take care of it.
Okay, and you said you were able to develop the names from the evidence that you collected, correct?
All I saw was a name on a receipt. I don't know if, at that point in time, if that was actually Mr. Cochran. I didn't know, because there was no other identification other than that.
What was the name on the receipt?
I do believe it was Mackenzie Cochran. But let me check here. Yes, it's Mackenzie Cochran, and it's got an address on here also.
Okay, so up until that time, you had a pretty.
I'm sorry. That'll work better.
Up until that time, you pretty much had a John Doe on your hands. You didn't have a name, right? You didn't have the.
I didn't know who it was at that point in time. I just had a man.
Okay. Now, you carefully placed all those items into evidence and you turned those over to a detective or another officer?
I take anything that is put in evidence, then goes to the Southfield property room. So it goes in a property locker, so nobody else can get it. I did take I did make a copy of it so that the detectives would have a copy of it, but the original then would have gone into the property room.
And are you aware of whether or not a Southfield detective submitted a warrant request in this matter back in 2014?
No.
Are you aware of a Southfield detective ever submitting a warrant request for this case?
No, I don't deal at all with the second floor. I'm just a road cop.
Yeah, but you would have known that a warrant had been submitted, charges and filed, would you not?
No.
That was a highly different question.
Okay.
Pardon?
You ever been to court in the Southfield District Court?
I've been to court, but I never know until I get a subpoena for court whether or not something went, because.
Well, let me ask you this. Did you get a subpoena for People versus Aaron Marie back in 2014?
Objection, relevance.
Well, she's the evidence technician, Judge. I just want to know if she's testified about this matter before today.
I don't believe I have.
I will allow that question.
Well, she just answered it too.
Yeah.
Thank you.
Sorry.
That's okay. Nobody ever waits for me to put what she says. Mr. Braxton.
Good morning.
Good morning.
It's afternoon.
Oh, good afternoon. Let's see. So far, I've learned that you have a dual role as a specialist officer and an evidence technician. You have 27 years on force. You've, in that 27 years, you've also.
Your Honor, I'm going to object and also ask a question.
Well, I know. In that 27 years, you've worked as a regular officer too, correct?
Correct.
You've testified in trials.
Yes.
You've arrested people.
Yes.
So in order to arrest someone, you had to know the law.
Yes.
I'm going to ask you a question about do you, because of this, do you know the difference between assault and battery?
Do I know the difference between assault
Yeah,
and
could you-
battery?
Yes.
Well, a battery is an unwanted touching, and an assault is like coming up to somebody and kind of yelling at them and stuff.
Okay, so basically an assault is not physical.
Not usually, no.
Okay, but it can be nonverbal too, correct?
Yes, it can.
Okay, thank you. I saw on the video, and I'm sure you had, it was a picture of two handcuffs linked together. Is that how they were when you received them?
Yes.
Okay, so you did not change it?
Nope.
Okay, do you have any idea why the two handcuffs were linked together?
Yes.
Okay, could you please explain?
Well, Miss,
Gonna check and ask that you lay a foundation that it comes from personal knowledge.
Oh, okay. Those the handcuffs that you received, they were taken into evidence, correct?
correct,
And you received that evidence how?
from Officer Potter.
And did you do an interview, or did you? I asked you if that the handcuffs were linked together.
Yes.
And you said you knew. How do you know how the handcuffs were linked together? Who told you, or did you see?
Okay. Okay, the handcuffs were removed from Mr. Cochran when Life Support One was treating him. Officer Potter took them from Life Support One, I don't remember the gentleman's name, and directly gave them to me. So that's how I got them, and they were just still linked together.
Okay, in your experience as an officer, could you tell me why you would have had two handcuffs linked together?
Usually when you have somebody who's either got an injured arm or somebody who's big, big guy, yeah, you're gonna use two pair of handcuffs because they can't get their hands back behind their back.
Or if they're struggling?
No, usually it's, I don't remember ever using two pairs of handcuffs on somebody who was struggling.
Okay.
But it's usually because somebody's got like big broad shoulders or big chest or belly.
But it's used basically to protect them.
I'm sorry?
To protect them, you don't hurt them.
Yeah, so they don't get hurt. I mean, otherwise you're gonna wrench out somebody's shoulder.
Is this a technique that's taught?
Yes.
Taught to you? Okay, all right, thank you.
Can you redirect?
Very good. Other than the small abrasions on Mr. Cochran's knuckles, did you take any photos of any other injuries involved in this incident?
No,
Or are you advised of any other injuries sustained during this incident?
no.
Thank you.
Nothing, Judge.
Thank you. You may step down, Ms. Myers. Please watch your step. Okay. Mr.
Thank you.
It's almost 12:30. I know you want to get this completed. I understand. Yes?
No, I'm waiting.
Oh, okay. I'm going to allow them to go to lunch, and then we'll continue this afternoon. How many witnesses do you have left this afternoon?
Just one.
Just one?
Yes, one.
That's why we're gonna point that out to you to see if it.
Oh, all right, okay. All right, well then yes, I get it, I get it. So your fifth witness is Dr. Schmidt,
Yes, yes.
and that'll have to be tomorrow?
Yes.
Because he's out of town today?
Yes.
Okay, all right, well then let's let's finish up with this witness and then I can release you for the day. Call your next witness.
At this time, the people will call Detective Paul.
Excuse me.
Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give before this court is the whole truth and nothing but the truth?
I do.
I apologize for my voice. I have a bad cough and cold, so bear with me.
Okay, you sure it's just a cough and cold? I'm not-
Yes,
I don't wanna get
it's
sick.
allergy related.
Okay, very well.
Thank you.
No offense, but.
And I'm on medication, so
Good afternoon.
good afternoon.
Could you state and spell your first and last name, please?
Sure, first name is Hall, H-A-L-L, last of Hancock, H-A-N-C-O-C-K.
And in 2014, where did you work, sir?
City of Southfield Police Department.
And how long in total did you work for the City of Southfield Police Department?
23 years. I retired from there in 2018.
Congratulations.
Thank you.
Now, on January 28, 2014, were you called to an incident at Northland Mall?
Yes, I was advised of an incident, and I was called in from being off duty. Yes.
And what was your assignment with the City of Southfield Police Department?
I was in the Detective Bureau, and I worked at crimes against persons, generally all sorts of major crimes, even to include domestic assaults, those sort of things, homicides, robberies.
And you stated that you were actually off duty when you received the call to report to Northland Mall?
I was.
And were you provided any, I guess, description or information about the incident, why you were being called off duty?
Yeah, I was called by one of my supervisors in the Detective Bureau, advising me that there was an incident at Northland Mall involving a unknown person at that time, unnamed person at that time, and their security personnel, and that he had passed away, I believe. That was mentioned to me, and possibly mentioned to me that this individual had no form of picture ID, I believe.
And did you actually respond to Northland Mall on January 28th?
I first went to the Southfield Police Department to gather more information.
Okay. And what kind of information were you able to obtain at the police department?
I believe we were then notified that a piece of paper, I believe it was from an appliance store, was found on this now deceased individual. There was a phone number on it, and at that time, I believe I called the phone number.
Okay. Now, I noted in your initial answer you said you were notified. Were you working on this case with other detectives?
I was the main person handling the case, but yes, there were other detectives involved in assisting, yes.
Okay. And are you kind of like, I guess for lack of a better term, the quarterback of the investigation?
They call it the OIC, officer in charge.
Okay. But you all work on it together, is that correct?
Definitely, yes.
Permission to approach, Your Honor? Yes, you may. We're going to hand you what has been admitted as People's Exhibit 66. And do you recognize that?
I do.
And what is that, sir?
This is a copy of the a piece of paper that the deceased had on his person. It was from a John R. Appliances store. There was a name of Mackenzie Cochran, who was the deceased person, as we later found out. I don't see it noted in these reports that you handed me.
Sir, to your knowledge, did the Oakland County prosecutor ever file charges against these men, yes or no?
Objection, relevance.
I'll allow it.
No, they did not.
Thank you, sir. That's correct.
So you collected videos, correct? From civilians and also from security as well?
I didn't collect them. There was someone else that assisted with that collection.
Okay, well, you're aware of they being off in charge, they eventually submitted. Being off in charge, eventually they were handed to you, correct?
Sometimes they were handed to me, and sometimes officers would put them directly into the property section.
Okay.
And if I had to review footage, if I didn't have them personally, I would get them out of our property section to then review them.
Okay. As the officer in charge, sir, you collect evidence, correct? Or you gather evidence that's been collected.
Yes.
Right? You meet with potential witnesses, correct?
Yes.
You bring everything together that law enforcement put together, and you submit it to the prosecutor's office, correct?
Yes.
Did you also meet with the medical examiner as well?
Yes, I was there for the autopsy.
Okay. And Dr. Dragovich at the time was medical examiner, if you remember, correct?
Yes.
He's been there forever, hasn't he?
Yes.
And you met with, were you part of a meeting between the medical examiners and law enforcement?
I believe there was some sort of a meeting.
Okay. And at the time, this case had publicity, didn't it?
Yes.
And you, along with others, did a thorough investigation, correct?
I believe there was a thorough investigation done.
And you didn't collect video from Northland Mall, but it was eventually given to you, correct?
Yes.
As a officer in charge, you reviewed the videos, correct?
Yes.
And you had videos from LA Diamonds, correct?
Yes.
And video from civilians, correct?
Yes.
If I showed you some videos, would you tell me whether or not these are part of your collection of evidence?
Yes, I should be able to.
Yeah, and what's the witness?
You can't put it up there?
Yeah, you're right. Good idea. Yeah, forget he's not feeling well. Let me show you defense proposal exhibit number 1. Hey, I'm sorry. I'm sorry.
Is this something that's already been committed?
Judge, it's a collection.
Oh.
Sir, are those videos that you collect as part of being the officer in charge?
Yes.
All right. Now, each one is by itself, correct?
Yes.
So this is a collection of all three, is that right?
Yes.
Yeah, I would admit this exhibit as to the page.
No objection.
Submitted.
Nothing further.
Nothing further, Your Honor.
Nothing further? Thank you, Mr. Hancock. You may sit down.
I'll watch my step.
Watch your step. All right, and it's my understanding that this is the last witness you have to present today. You have one more witness that will be presented tomorrow afternoon?
Yes,
All right then. Ladies and gentlemen of the jury, I'm going to release you for the day. I do caution you not to discuss the case with anyone, and also not to watch any news reports or read any articles about this case, whether in paper form or on social media. Thank you.
All rise, jury.
You may be seated. Before you all disperse, you have one final witness, is that correct?
Yes.
And at this point, you don't know if you'd have any rebuttal witnesses, is that correct?
Not sure about rebuttal.
Well, that's what I'm saying, you're not,
Yeah.
okay. And it's my understanding that you have, the defense has 2 witnesses to present?
That's right, most likely.
Okay. How long do you anticipate, is it Dr. Schmidt?
Yes.
Okay. How long do you anticipate his testimony being? I'm just asking for direct. I know that the defense will probably be a little lengthier than.
Maybe 30, 40 minutes, and that's on the outside.
Okay.
I don't think we need much longer than that.
Okay.
We'll try.
I'm just trying to, I'm just trying to figure out if we have time to at least do one of your witnesses in the afternoon. We'd be starting at 1:30 because I have my criminal call in the morning. So an hour, it's about an hour and a half, 2 hours max, so that would be 1:30, 2:30, 3:30. We could still get a witness in. So I just wanna, I don't wanna waste any more time than is absolutely necessary. So, you can pick which one of your 2 witnesses you wish to call, and please have them.
We'll try to have them available tomorrow. Thank you.
Thank you.
All rise.
Try to keep the witness who you intend on calling, that would not take more than an hour and a half, okay?
You got it.
Okay.
So I have a question about your witness. Is the medical examiner still going to be via Zoom?
No, the medical examiner will be live, but the use of force expert, so he said he had logged on to the Zoom and was in a waiting room or something.
Oh, today?
He just texted me that right now.
Yeah, tell me.
King, which is standing behind you, my pin is 5778.
Good afternoon, Your Honor. Wright Blake appearing on behalf of Aaron Maury.
Good afternoon, I'm Keith Bretzer, here on behalf of Mr. Cyberling, P7985.
All right, thank you. All right. Is she giving it to you?
She is, she's writing them up right now. All rise for the jury.
You may be seated. Good afternoon, ladies and gentlemen. We're ready to resume the taking of testimony. Please call the next witness.
Your Honor, at this time, the people will call Dr. Carl Schmidt.
Judge, I would just point out that there was a sequestration order they had at the beginning with Dr. Dragon, which is in the courtroom. They are both expert opinions, so I would ask that you accept him from the sequestration order.
I note that that's an allowable exception, Your Honor. People have no objection.
Very well, thank you.
Thank you.
Watch your step, please.
Do you solemnly swear or affirm, under the penalty of perjury, that the testimony you're about to give before this court is the whole truth and nothing but the truth?
I do.
You may be seated.
Good afternoon.
Good afternoon.
Could you state and spell your first and last name, please?
My name is Carl, C-A-R-L, Schmidt, S-C-H-M-I-D-T.
And what do you do for a living, sir?
I'm a forensic pathologist
And where do
employed
you currently work?
at the University of Michigan.
And in 2021, where did you work?
I was also working at the University of Michigan, but I was the Wayne County Medical Examiner.
And do you have to have specialized education and training to be a medical examiner?
To be a forensic pathologist, you have to have a degree in medicine, and then I did residency training in anatomic and clinical pathology, and then I did some specialty training in forensic pathology, and I am board certified in anatomic, clinical, and forensic pathology.
And how long have you been a forensic pathologist?
About 30 years.
And have you ever been called to testify as it relates to your opinion involving a postmortem examination?
Yes.
About how many times have you testified as an expert?
Both in the casework that I personally did, the autopsy and consultation, it's been at least 400 or 500 times.
Your Honor, at this time, I would move to have Dr. Schmidt declared an expert in the field of forensic and anatomic pathology.
No objection, Judge.
No objection, Your Honor. No objection.
You'll be so qualified. You may
Thank you.
proceed.
Dr. Schmidt, could you explain to the jury what forensic and anatomic pathology are?
Anatomic pathology is the branch of medicine that studies the changes that occur in tissue as a result of disease. So, for example, if you have a tumor and the surgeon biopsies it, he will send it to the pathologist who will look at it under the microscope and render a diagnosis of, let's say, malignant or benign. And a forensic pathologist is a subspecialty of anatomic pathology that studies the changes that occur in tissue as a result of the process of death and the mechanisms that lead up to the process of death, whether they be natural disease or trauma. And because many of our cases died due to trauma, we are often also called to testify in those cases that fall under the medical examiner statute.
And I believe you've testified that you perform postmortem examinations, is that correct?
I have.
And what is the purpose of a postmortem examination, sir?
The main purpose is to determine the cause of death. In the hospital case, that's really the main issue, documentation of the changes that happened as a result of the disease and therapy. In the medical examiner's case, it's also the manner of death or the context in which that individual died for the certification of death.
And how is a postmortem examination conducted?
A typical postmortem examination includes basic measurements such as height and weight. You then do an external exam where you look at the changes that occur externally as a result of disease or trauma, or both. And then you proceed to do what most people think is the autopsy, which is where you open the cavities of the head, chest, abdomen, and pelvis, and you examine the internal organs and you correlate the changes that you find in the internal organs with those changes that you saw externally.
And typically, when a post-mortem examination is done, are the findings ultimately placed in a report?
Yes.
And I'm going to ask you about this case in particular. How did you become involved in the death investigation of Mackenzie Cochran?
I was called one day by the Attorney General who asked me to look at the case.
And is it fair to say you are not the forensic pathologist that conducted the original post-mortem examination?
That's right.
So if you are not the original assistant medical examiner, how is it that you can conduct a review and form an opinion?
So we look at the medical record. In this case, I looked at the medical record, video from the scene, autopsy pictures, as well as the autopsy report, and also the microscopic slides that were generated as part of the autopsy.
Now let's take those individually. You said you reviewed some video from the scene, is that correct?
Correct.
And how would that assist you in rendering an opinion as to cause and manner of death?
When you're defining the context in which the death occurred, in other words, the manner of death, you try to gain information as to how it is that the events that led up to the individual's death took place. So in this case, the video was informative regarding how it is that the individual ended up on the ground and subsequently died.
And specifically the video in this case, what was helpful about the footage as it related to you rendering an opinion?
Well, there is one particular scene where you can see that he is pepper sprayed, then basically thrown to the ground, and he did not get up afterwards, and that was basically it.
And Your Honor, permission to publish that portion of People's Exhibit 29 to the jury?
Yes.
Thank you. For purposes of the record, Exhibit 29 is currently displayed at the time stamp of 18 minutes and 54 seconds on that file. Dr. Smith, is this the camera angle that you were referring to that was important to your considerations for cause and manner of death?
Yes.
And I will play until you tell me to stop, sir.
So at that point, right there, he's pepper sprayed for the first time, and it doesn't look like he was actually going to do anything to the security guard.
It calls for speculation, Judge.
It does. We'll strike that. The video will speaks for itself, and the jury can decide what it shows and what it doesn't show.
Understood. Could you explain why that part was important to your ultimate opinion?
It all goes to the determination of the manner of death. The manner of death is a part of the death certificate where you have to cite the context in which the death occurred. So there's 5 manners of death. The first is natural, when you die from natural disease. The second is accident, which is when death is an unintended consequence of an action that you were not expected to result in death. The third is suicide, which is where death is self-inflicted. The fourth is homicide, where death is a result of somebody else's actions. And when you can't neatly pin the manner of death into one of these 4 categories, then you say that it is indeterminate.
Now, other than the security video, I believe you said you reviewed a series of reports. What kind of reports did you review, sir?
It was the medical records. There was the EMS report from when they came to resuscitate him, and those are the ones that come to mind.
Taking the EMS report first, what was significant about what was in that report that ultimately helped you form an opinion?
He was unresponsive when EMS came, and when they put on the electrodes, he was in pulseless electrical activity, or PEA. And when you're in PEA, the actual survival, when you have electrodes put on and you're in PEA in the field, the mortality rate is over 95%. So he was essentially dead by the time that the paramedics came. He had a measurable electrical activity, but the ability to recover the person from PEA is very low.
And you said you reviewed some additional medical records.
Right.
And what was significant about those that helped you form an opinion?
He was in the emergency room. The main issue with those medical records was that the emergency room physician replaced the endotracheal tube, but it wasn't clear to me from the EMS records that it needed replacing. Basically, that's all I have to go by.
Could you tell from the EMS records to the hospital records whether or not Mackenzie Cochran's status of PEA had changed?
No, but he was manually ventilated, but his electrical activity in the heart didn't change.
And ultimately, did you review the post-mortem examination report?
I did.
Okay. And understanding that you were not the author of that report, do you recall who the author was?
Cheryl Lowe.
And do you recall the Oakland County Medical Examiner number for that report?
No.
Would that have been something you would have placed in your own memo?
Yes.
And when seeing that, refresh your memory?
Yes.
Permission to approach your Honor?
Yes, you may.
Sir, do you recognize the document that I've handed you?
Yes.
And what is that?
This is the report that I wrote from my review on this case.
Okay. Please take a look at that and let me know if that refreshes your memory as to the Oakland County Medical Examiner's number for their report.
It's case 542 for the year 2014.
And what was significant about your review? Well, was it just the report itself that you reviewed, or did you review anything in conjunction with the Oakland County Medical Examiner report?
The slides.
And what are the slides? Could you just
So when you
describe
do an autopsy, sometimes you will take microscopic slides. And what that means is that you take a slice of tissue and you put it in a small plastic cassette about the size of a matchbox. And then that gets processed, and at the end of that processing, a wax block remains with the tissue embedded in it. And then you can make slices, very thin slices, of that tissue embedded in wax and mount it on a glass slide and look at it under the microscope.
And how many slides were created in connection with this postmortem report?
23 slides.
And did you find anything remarkable about those 23 slides?
The liver had acute congestive changes due to terminal heart failure, but there were no other significant findings.
And as to the body of the report itself, was there anything significant within that report that helped you formulate your opinion, sir?
The heart was heavy. The heart was 549 grams.
Okay. And what is the significance of that weight, sir?
When you have an enlarged heart, an enlarged heart in a male is about 300 to 325 grams. You have an increased risk of sudden death. And that's really the main significance.
And after reviewing the surveillance video, the EMS and hospital reports, as well as the post-mortem report and histological slides, were you able to form an opinion as to the cause of death of Mackenzie Cochran?
Yes.
And what was your opinion, sir?
That he died of asphyxia and heart failure under prone restraint.
And can you explain to the jury what that means, heart failure under asphyxia due to prone restraint?
So there has been relatively recent literature on, and actually research on what happens to a person when they're in prone, in other words, face up on the ground, and they're being restrained. And although young people in good shape are able to tolerate it, above a certain weight, and if you're not physically conditioned, there can be changes present. The pH of your blood goes down. You're not able to move your chest to adequately breathe, and eventually that leads to changes which cause terminal heart failure.
Is prone face up or face down?
Prone is face up, supine is face. No, prone is face down, supine is face up.
Now, as it relates to manner of death, you've explained to us the 5 manners of death. Were you able to determine a manner of death for Mackenzie Cochran?
Yes.
And what was that?
I think that there's an argument to be made for indeterminate. I don't think this was an accident. But you can also argue because he was basically thrown to the ground and after that he died, that you could also argue that it was homicide.
And for purposes of the post-mortem report, homicide means what, sir?
That death was inflicted by the people and the circumstances that he was surrounded by.
And it is by no means going into the criminal form of homicide, correct?
Right. Homicide is a different definition in medicine. The manner of death was something that came into existence in the early 1900s. It's unclear exactly when. It seems to have been around 1910 that it started appearing on death certificates. And that came about, at least as far as we know, because public health researchers wanted to know the context in which deaths were occurring. So let's say that you had a gunshot wound and that was the cause of death, but you didn't know if it was inflicted by somebody else, which would be homicide, whether or not it was self-inflicted, or it was inflicted while hunting, for example, where you could argue that it was an accident. So essentially, that has been around since then, and it places the forensic pathologist in the position of having to assess what the context the death occurred in, and to make a determination regarding that.
Now, the original autopsy report that you reviewed identified the cause of death as position compression asphyxia. Is that the same or different than your opinion, sir?
It's related. I think to some extent it depends on how you want to phrase it, but I think that the more modern terminology of asphyxia under prone restraint better describes the physiology that happened behind that.
People would pass the witness, Your Honor.
Dr. Schmidt, are you telling this court that you were asked by the Dana Nessel? She called you up and she asked you to review this file, or was it someone from her office?
No, it was Dana Nessel.
Okay. Because you and her have a friendly relationship, do you not?
No, I hadn't actually seen her in years.
So your answer is yes, you are friends, or no, you are not friends? Because I have friends that haven't seen yours either.
No.
So you're not friends?
Right.
Okay. But you do work for her often, do you not?
No, not often.
Okay. So when you do work for her, you get paid for it, do you not?
Yes.
How much do they pay you, by the way?
Actually, for this case, we didn't set up a contract. I haven't been paid.
Okay, but you're gonna be paid, correct?
That's something we haven't even discussed yet.
Okay. Is it based on whether they win or not?
No.
Okay. So, is it gonna be more or less than what you're paid for in Muskegon, where you testified in a case where you said it can be indeterminate or it can be homicide, like you're doing today? Is it gonna be the same amount, same rate, or different?
No, it's the same rate.
What is that rate?
$4.50 an hour.
Oh, wow. And so you had to review the file, correct?
Right.
You're keeping track of your time, are you not?
No, actually, for this case, I haven't set up a contract and I haven't kept track of the time, and I haven't sent a bill, and I probably won't.
Oh, so you do that out of goodness of your heart, correct?
Objection, Your Honor, argumentative.
Not that, Mr. Holder, please.
Sir, you're asked to look at medical examiner's report from Mackenzie Cochran, correct?
Right.
And you're given a file to look at a report that's almost a decade old, correct?
Now it is, yes.
Almost 8 years when you got the file, correct?
Right.
And you realize the examination was made by an Oakland County medical examiner, correct?
Right.
It would be logical to call the medical examiner's office and talk to the person before the autopsy, would it not?
No, not necessarily.
Okay. Did you ever try to get a hold of Dr. Lowe?
No.
Did you ever try to get a hold of Dr. Dragovich?
No.
Who's Dr. Dragovich to you?
What's that?
Who's Dr. Dragovich?
He's the Oakland County medical examiner.
And he's been Oakland County medical examiner for quite some time, correct?
Right.
And he's a very competent doctor, isn't he?
That's what they say.
Well, you don't like him, do you?
Objection, Your Honor, relevance.
Do you have issues with him as a doctor, sir? No, I'm sorry. Let me rephrase the question. Do you have issues with him as a forensic pathologist because he has overruled your findings and found incorrections in your reports? Many times, hasn't he?
No, not many times.
But he's done it a number of times, hasn't he?
Yes.
Did you ask the AG's office, hey, have you sought someone else's opinion in this case besides before you called me? Or did you determine that you're their go-to guy?
No, it just happened.
Okay. Because you're their go-to guy, right?
No. I know they've called other people for cases. I don't know why in this particular case I was called.
And when those other people reject their case, they come to you, correct?
Objection calls for
No,
speculation
if he knows.
and not relevance.
If he knows.
If he knows.
I don't.
Okay. The report drafted by the medical examiner of Oakland County, sir, determined it was an accident, correct?
Right.
And you watched the video, more than one video, not just the one they showed you today, correct?
Right.
And in your report, after watching the video, in the report that you have in your hand, sir, you note that you don't see any security personnel sitting or somehow securing the back or chest or placing weight on him, correct? Page 2 of your report, sir.
Yes, I think that's right.
But you know he's struggling for quite some time with the public safety officers, correct?
I think he's struggling to get up.
Okay. Which means he's struggling with someone that's trying to prevent him from getting up, correct?
Right.
And were you told that the individual, the decedent, had made threats to kill someone? And that's why they're trying to restrain him?
No.
Sir, you testified in direct examination that he was on pepper sprayed once. Are you sure of that, sir?
No, that was the first instance. I think he was pepper sprayed twice.
Okay. Sir, had he left the mall if he was requested to leave, he'd be alive today, wouldn't he?
I think so.
If he had been peaceful with the sergeant, he'd be alive today, correct?
Yes, probably.
And had he not resisted, he'd be alive today, correct?
Right.
Had he not struggled with one officer, he'd be alive today, correct?
Yes.
How about two officers?
I don't know.
He'd be alive today if he didn't struggle with two officers, correct?
Probably.
How about three officers?
It depends on how he was being restrained and whether or not those three officers could have restrained him.
Right. But if he didn't struggle with that, he complied, he'd be alive, right?
Yes, I think so.
Sir, would you agree the act of securing a person's hand in and of itself wouldn't cause a person to die? Would you agree with that?
Yes.
The decedent had an enlarged heart, right?
Yes.
And that was something important to you because you noted it in your report, right?
Right.
And there is no telltale signs when you're looking at someone to determine whether or not they have an enlarged heart, correct?
No, not physically, externally.
And the heart of Mr. Cochran was enlarged for a person with his height and his weight, correct?
Right.
How big was he? It's in your report, right? Obviously, it should be in your report.
No, I did not put it in the report, but it's in the autopsy report.
Wait. You draft a report about a decedent, and you know that report's going to be relied upon by the prosecutors that pay you. Was it $550 an hour or $450 an hour?
I haven't been paid.
I know, but they pay you only $450 an hour, correct?
In the previous cases, yes.
And excuse my memory, but did you say that you're not going to bill for this case?
I hadn't thought about it.
So you intend I'm billing for this case, correct? I mean, the
No.
jury's here. You can be honest. You're on the record.
No.
Because if you say no, you're not going to get paid. So you better make sure it's clear.
Your Honor, I believe the witness answered the question.
Well, what? I didn't hear it. Well, what is? You going to get paid? You going to bill for it or not? You're on the record. You have cameras and everything.
No.
Oh,
Move to strike that oath.
that wasn't the words. It's not. I'm sorry. Okay.
Refrain from making nonverbal editorial comments. Thank you.
Absolutely, Judge. I apologize. So, sir, his heart is listed at 591 grams, correct?
549.
Right? 1.5 times larger than the average heart, correct?
Right.
And we don't know from your report the size of Mr. Cochran, correct?
No, it's in the autopsy report.
But I'm talking about your report.
No.
So, being that, with that being said, the autopsy report is more detailed than your report, correct?
Yes.
And one could rely on that report more than your report, right?
No, they're different.
When a person with an enlarged heart, as Mr. Cochran has, begins to resist like he did, he's increasing the risk of his own death. Would that be fair to say?
Yes.
When he's resisting, sir, he's also impairing his oxygen intake, correct?
That's right.
Unlike someone that would have been calm and compliant, correct?
Right.
And when he's yelling and screaming, that's having an adverse effect on his cardiac output, correct?
Yes.
And his oxygen intake, correct?
Yes.
And he is hindering his ability to ventilate, correct?
Yeah, actually being prone is probably the more significant factor in the ability to ventilate.
But he himself, by screaming and yelling and fighting, he's also exerting more energy, and the ability to ventilate can be affected as well, right?
No, actually, the screaming is actually a sign that you're still ventilating. It's when you stop screaming that you know that you're no longer ventilating, because it takes the ability to ventilate to scream.
Okay, so basically, if he's talking, he can breathe.
Right.
Okay. Sir, is it enlarged heart? What's the medical term for that?
Cardiomegaly.
Okay. Cardiomegaly. That's a form of heart disease, right?
No, it just means an enlarged heart.
Does marijuana have an effect on that heart, sir?
No.
You looked at the labs, correct?
Right.
And what did the lab show?
I don't remember.
Look at your report. It should be in the report, right?
No, if the labs were insignificant, I would not have put them in the report.
Well, would you put in your report that the labs were insignificant?
No, if the labs are not relevant, I will not put them in the report.
But you know someone else is relying on the report, yes?
Right.
Okay, so if someone's not relying on, they don't know how Dr. Schmidt thinks. Would you think it's important to put down the labs are insignificant in your report?
If they're not relevant, sometimes I don't put them in the report.
That wasn't my question. If someone else is reading a report, they don't know the Dr. Schmidt that we know, that works for free, they may not know that. Right?
So the question is?
Someone else reading the report may not know that it's not significant, but it's not noted in there, correct?
I don't know. I just don't always put data that is irrelevant in my reports.
Sir, you referenced the issue of PEA, correct?
Right.
Sir, you know that PEA, what they can do in the EMS or EMT, they can give epinephrine to help with that, correct?
Right.
And do you know whether or not epinephrine was administered?
I don't offhand. Probably it was.
Oh. Would that be in the report as well?
No, not necessarily.
And if epinephrine can be administered in what way, sir?
Well, there's several ways. You can do it intravenously. They can sometimes do it via the endotracheal tube, or they can do it intracardiac.
Yeah. So basically, they can actually go through a vein or through the tube, right?
Right.
Do you know if it was given through the tube?
No.
But if the tube was placed incorrectly, that wouldn't help, would it?
Probably not.
And you make a notation about this tube potentially not being placed correctly, correct? In your report.
Right.
And would cause inadequate ventilation, correct?
Right.
Sir, would pepper spray be a factor in terms of a person's ability to breathe?
Yes, it can cause edema or swelling of the airways in people, especially people who are allergic to pepper spray.
Okay. And do you know if that was an issue in this case, sir?
I doubt it, because the autopsy report does not mention any changes in the airway.
Okay. Did you note that in your report?
No.
So are you going off memory right now?
Yes.
How many cases have you testified in since you made that report in your hand in 2021?
40, 50.
Probably more than that, right? Because you're a paid expert, right?
No, actually, 90% of them have been cases in Wayne County.
Okay. That was half my question. How about the other half? You're a paid expert, right?
Right.
Hired gun?
Objection, Your Honor.
Okay. You saw no signs of trauma, correct?
Right.
Sir, any issues with blood in the lungs?
With the what?
With blood in the lungs? Well, actually, hold on. Let me bring you a professor. Your testimony was that when you looked at the report, the slides, all you saw was, let me read this. issue with the liver, nothing else of significance, correct?
Right.
So seeing blood in the lungs would be significant, correct?
No, there is normally blood in the lungs.
Okay. Hemorrhaging in the lungs would be
That,
significant, correct?
it depends. A lot of hemorrhage that you see in sections are actually artifact, but I don't remember that there were any gross changes in the lungs. That's really where you assess hemorrhage.
Okay. But you noted that there was nothing issue other than this liver issue, correct?
Correct.
All right. Sir, in your report and your testimony, would it be fair to say, sir, that you kind of go back and forth in terms of the manner of death?
Right.
All right. And you said that, quote, you testified under oath before, correct, in this case, at the examination? You
Right.
You remember that, right?
Right.
No. And in your report, sir, you went back and forth, and you said there's an argument to be made for homicide, correct?
Yes.
And then you also said there's an argument to be made where it's not homicide, correct?
Right.
And you don't have a conclusive opinion, is that right?
No, that's why I said that indeterminate
Okay.
was probably the best manner of death.
And indeterminate is a reasonable opinion, correct?
Yes.
Based on your medical certainty, correct?
Right.
And it's reasonable that it's not homicide, correct?
Yeah, that's
And
right.
that's also a reasonable opinion based on doubt, correct?
Right.
Nothing further.
Doctor, what was the date that you received the phone call from Ms. Nessel to inquire as to whether or not you're interested in this case?
I don't remember.
You remember what year?
It's been at least 2 or 3 years.
So you don't know the specific year, you don't know the specific date, correct?
Correct.
And did you take notes of this particular correspondence you had with her?
No.
When you received that call, were you employed by any other county or?
The University of Michigan.
Now, you mentioned on direct, I believe, at one time at point you were employed as the Wayne County Medical Examiner as well as University of Michigan, correct?
No, I've been employed by the University of Michigan since 2011, I think. But we were providing forensic services to Wayne County as employees of the University of Michigan.
Okay, how long were you providing services to Wayne County?
I was actually chief medical examiner for 18 years and an employee of Wayne County until 2011. And then when we changed over to the University of Michigan, then I became an employee of the University of Michigan.
Weren't you fired from your medical position at Wayne County, sir?
No, I resigned it.
You resigned amid a lot of controversy. Would you agree with that?
Yes.
And you are now the chief medical examiner in Monroe County?
Yes.
And Monroe County had absolutely nothing to do with this case. Would you agree?
Correct.
So you seem to be quite a busy man between the University of Michigan, your job at Wayne County, Monroe County, correct?
Right.
And you're telling us today that out of the goodness of your heart, you're just going to volunteer your services on this case, correct?
I hadn't thought about billing until you brought it up.
I didn't bring it up. I just asked you, you thought about just volunteering your services with all these duties that you have way back in 2014 to take on this job, right?
I don't think he was asked in 2014.
Okay, I'm sorry. Well, he doesn't remember. You don't remember when Ms. Nessel called you. So
I think it was in the middle of the pandemic.
in any event, when you take on this job, you're you get a file and you get you get an autopsy, you get police reports, correct?
Right.
Who are you working with at that time and point? Were you doing this all on your own, or did you have someone from the Attorney General's office assisting you?
The Attorney General sent me the files and the slides.
Okay, but was there anyone assisting you in this?
No.
You were doing it all by yourself?
Well, I read the autopsy report and I looked at the slides by myself.
You prepared a letter regarding your opinion of this case, and it's dated August 29th, 2021. Would you agree with that?
Yes.
And in that report, you indicated all the materials that you reviewed for this case, correct?
Right.
And that letter was directed to a Mr. Aronde Patterson,
Yes.
an Attorney General in Detroit.
Yes.
And in that account, or in that letter, you indicated that you looked at security camera videos.
Yes.
And I would assume that you're referring to People's Exhibit number 29, correct?
Correct.
And you testified on direct, so that I'm crystal clear that you ruled an important cause of death was the individual being pepper sprayed and thrown to the ground in that particular situation, right?
No, that was a circumstance that led to him being in prone restraint. And it was actually the prone restraint.
Okay, so it wasn't the
led to his
pepper
death.
spray and being thrown to the ground.
No.
And how long was the individual in a prone restraint, if you know?
I think he was unresponsive in about 7 minutes.
And that's when you say unresponsive, that's when he went into the PEA?
Yeah, I think so.
So the PEA could have come from suddenly being put on the ground, screaming, kicking, in large heart.
Yeah, eventually what all that leads to is the inability of the blood to deliver oxygen to the heart, so the heart goes into pulseless electrical activity.
Now, your report also indicates that you looked at videos that included media accounts and reporting from the incident. Remember that?
Yes.
So you were provided what kind of media accounts and from who?
It was like TV newscasts.
I know, but who provided that to you? And
The Attorney General.
And specifically, you know, we're talking CNN, we're talking local news.
It was local news.
You also put in your report that you had cell phone documentation of Mr. Cochran while being subdued. It says, and cell phone documentation.
Oh, yeah,
of
videos.
Mr. Cochran while being subdued.
Right, cell phone videos.
Okay, not from Mr. Cochran, though.
No.
Now, you were asked by Brother Counsel about signs of trauma on the body. This was an individual that was roughly, what, 7 or 6 feet tall, 203 pounds.
How about?
And was there any abrasions or bruises on this individual?
I think he had a couple of abrasions like on the knees, but they were really superficial.
Sir, in the report, and you did look at the autopsy, right?
Yes.
That was performed, because you didn't perform an autopsy in 2021 or 2014?
No.
You wouldn't disagree that the only signs of trauma were 2 minor cuts or abrasion on the individual's fingers?
Yes, something like that.
Knuckles? And other than that, there are no signs of trauma on the head?
No.
The body, period?
Right. Right.
So there's not even any trauma around the wrist where the handcuffs were supposedly placed. Would you agree with that?
Yes.
And if 5 individuals would kick somebody, hit somebody, or place a knee on the back, there clearly would have been some kind of signs of trauma, such as a bruise or an abrasion, right?
No, if you had placed a knee on the back, There may not have been, there probably would not have been anything.
Okay, well, what about if someone was struck?
Yes, if you were struck, it is much more likely to leave an abrasion or a bruise.
Okay, and someone was grabbed by the neck.
No, not necessarily. It depends on how you were grabbed.
What if someone placed forcefully their hands on the person's shoulder in order to keep them in the prone position?
No, that may not leave, especially if you have clothing in between the fingers and the skin, that may also not leave.
But chances are it would you agree?
No, it depends. I think that more often than not, it wouldn't leave any evidence of anything.
Now, you were also asked about some of the reports. Did you look at the toxicology report?
Yes.
And in that report, did it not include the fact that Mr. Cochran had marijuana in his system?
Yes.
Were there any other drugs in his system, if you know, based upon looking at the
No.
autopsy?
No, not that I recall.
When you watch this video, you were giving the description of the various individuals or the security guards, were you not?
Given the description?
Right, you were given the police reports, correct?
Yes.
And you were giving mugshots of these individuals, these various individuals?
I don't remember seeing that.
You don't?
No.
Okay, so can you tell us who's who in those videos, or you can
No.
just say it's just a bunch of people around, standing around, right?
Well, I didn't identify them individually, no.
Did you see an individual hand a cup of water to the decedent, Mr. Cochran?
I don't remember that.
Did you take any notes upon your observations and your findings while you were preparing to come to trial in this case?
No.
So you just put together a report, and that's memory that you're using today, your memory and the report, correct?
And I looked briefly at the autopsy report.
You looked briefly at it?
Yeah.
In your preparation of your letter, you just looked briefly at the autopsy report?
No, before I came here, when I was preparing the letter, I looked at everything in detail.
Let's go back to the autopsy report that was prepared by Dr. Lowe. Clearly, you had some conversation, or you reached out to the doctor who performed the original autopsy?
No.
So basically, you're just handed an eight-page report. You read it over, and you were instructed what, to find something inconsistent about it?
No, they just asked me to review it along with the slides.
Okay, and so in your review of the slides, you said the individual had a enlarged heart, correct?
Right.
And that could have been the cause of death, correct?
I think it contributed to it, yes.
In your report, you put down a confounding factor is the enlarged heart, which is a risk factor for sudden death.
Right.
And then you go on to say physical restraint in an individual that is agitated will increase cardiac output and oxygen consumption, needs to keep pace with the muscular effort expended by the victim while struggling to fend off the attempts of restraint, and is itself significant contributor to death in the circumstance when prone and with decreased ventilatory capacity. It is easy to see how the heart can fall, especially in already enlarged heart, which is less adaptable to increased metabolic demands. That's in your report, correct?
Right.
Now, in reviewing Dr. Lowe's findings, in which she conducted the autopsy, the physical, as you described it, cutting the body,
Right.
gathering the reports. You didn't have anything to do with the body, but you were going off of Dr. Lowe's report, correct?
Right.
And when you make your report, you really don't give a definitive opinion one way or another. It seems like you're on the fence. On one side, you're saying it could have been a homicide, and then on the other side, it's inconclusive or indeterminate, right?
Yeah, but it was not an accident.
But you can't say that this was a homicide, in your opinion.
Right.
So why are we here?
Objection, Your Honor.
I think that's a question that isn't, I think that's a question that isn't going to receive an answer.
Okay, so you also put in the fact that there was an inadequate placement of some kind of medical device while the decedent was en route to the hospital that could have caused death as well.
Yes, there is documentation that the emergency room physician replaced the endotracheal tube because he thought it was out of place.
So there was negligence from the hospital contributing to the cause of death?
No, EMT.
Oh, the EMT, I'm sorry.
That's unclear because if you look at the EMT records, he was well ventilated during that time.
But you put in your report that that could have been the cause or contributed to the cause of death.
If that was actually the case, yes.
Well, if it wasn't the case, you wouldn't have put it in the report, correct?
No, it was something that had to be documented because it was there, and it may be related to the cause of death.
All right. Thank you, Dr. Northland.
Mr. Braxton.
Good afternoon.
Good afternoon.
To be clear, you're not trained in the law or any kind of legal theories or anything, correct?
No.
Earlier, you were watching the video, and when it got to a point where Ms. Cochran bent over, you said he was pepper sprayed.
Yes, that's what it looks like.
Okay, but you've also stated that that he was pepper sprayed twice. Was there pepper spray after that?
I think it was after that, yes.
After that. So in the video, it showed Mr. Cochran walking towards one of the officers, and then he backed away.
Right.
Okay. You also saw that the officer put up his arm when he walked towards him. Did you see that?
Yes.
Okay. Did he have the pepper spray in his arm at that time?
I don't remember.
You don't remember? Okay.
Yeah, and I believe we previously established that the video speaks for itself.
No, I'm just.
Well, he's just trying to elicit the order of which the two pepper sprays were.
Correct.
That's all. I believe that's what you're trying to do.
Correct. One of my main questions is, could you agree that if you could have more accurately did a report if you were the actual examiner of Mr. Cochran's body than what you have today?
I'm going to answer no because the autopsy is a medical record. And the idea behind the medical record is that you document everything that you did during the autopsy or when you examine the patient so that a subsequent physician comes along and reads a chart and he can reach the same or different conclusions as you did.
But don't some physicians make mistakes?
Sure.
Okay. In your report, you also said But it's been covered. That the video, as far as I can tell, do not show the security personnel sitting on, show how somehow securing the back and the chest or placing weight on him, meaning Mr. Cochran.
Right.
Okay. You also stated a factor is the enlarged heart, which is a risk factor of sudden death.
Yes.
Okay. And it said you also have here the victim, while struggling to fend off attempts at restraint, and is itself a significant contributor to death in this circumstance.
Right.
Your Honor, at this time, I would like to move to admit his report.
All right. Do you have any objection to the admission of Dr. Schmidt's report?
No.
Defense Exhibit B.
B?
Yeah.
Is there any redirect this witness by the people?
I don't know. Are they done?
Well, they all sat down, so so I believe they're done with their cross.
Yes, I would like some redirect. Thank you.
Go ahead.
Dr. Schmidt, can a person with an enlarged heart live a normal life?
Yes.
Now, if just a person, let's, for the purpose of this example, a person with a normal sized heart, if they were restrained in a prone position, would they also be susceptible to death?
Yes.
What is the increased risk if you have an enlarged heart?
An enlarged heart needs more oxygen, has what we call an increased metabolic demand. And if you're in prone restraint and you start having difficulty breathing and the blood doesn't oxygenate as well, that increased mass of the heart is going to fail sooner than a normal heart because it needs more energy and oxygen to continue functioning.
And would you expect someone who's having difficulty breathing while in prone restraint to move around to try and take in air?
Objection, calls for speculation, Judge. Goes beyond the scope of his expertise.
I believe it would be within his scope.
He's a pathologist, Judge. He deals with people that are dead, not alive.
I'm sorry?
He deals with people that are dead, not alive. That's his expertise, people that are not alive.
Let's see the cause of death.
Okay, could you repeat your question, please?
I don't even remember my question anymore.
Then ask another question.
I will, Your Honor. Thank you. Now, your ultimate determination for the cause of death was cardiac arrest due to prone restraint.
Mm-hmm.
And what items did you review that led you ultimately to that decision?
Well, the autopsy report, the slides, the hospital records, the EMT records, the videos.
Now, in the video, is Mackenzie Cochran just laying on the ground by himself?
No.
And if Mackenzie Cochran was just laying on the ground by himself, would you expect him to have died from prone restraint?
No.
If Mackenzie Cochran had not been restrained on January 28, 2014, would you expect him to die on that day?
Well, it all depends on why he would have been on the ground. I mean, you could be on the ground because you dropped dead.
Well, based on the video that you watched.
Right.
So it was the restraint that led to the cardiac arrest due to prone restraint? Is that what you're saying?
I'm going to object, Judge, that calls for speculation. I already said that you cannot give a definitive answer. It's indeterminate.
Well, it's his opinion, and it's a cause of death.
But his opinion is in his report, which says it could be either indeterminate or homicide.
Well, I'm not talking about the manner of death. I'm talking about what caused the death. I wasn't talking about the manner of death. I didn't say anything about homicide.
But you asked.
Okay, enough. Rephrase your question.
Yes. As it relates to the prone restraint, from the video that you watched, who was restraining Mr. Cochran? And I'm not expecting you to give names.
The security guards.
And was that a direct cause to the cardiac arrest?
Yes.
Thank you. Nothing further.
Do we have some more, Judge?
Sure.
Sir, then why does the report say conclusively this is a homicide?
I don't think it says that.
Thank you. Nothing further.
Nothing further.
Thank you, Doctor. You may step down. Please watch your step.
Sorry, Your Honor. At this time, the people have no further witnesses, and we rest.
Thank you.
Well, we'd like to take up a matter outside the presence of the jury.
Yes, I understand. So, you don't have to approach. Okay.
All rise for the jury.
You may be seated.
Soberling was holding his legs. He was not directly on top. He wasn't applying any kind of pressure. Again, this witness was not credible as in his, or he did not have a conclusion. So we asked the director.
May I? Yes. Well, Your Honor, while defense counsel's motions focus mainly on the testimony of the last witness, it is the totality of the testimony, which nobody seems to want to talk about all the civilians who heard Mackenzie Cochran saying repeatedly he could not breathe until he couldn't talk anymore, at which point he's just crying and wailing until he became ultimately unresponsive. And Your Honor, this isn't about, and while the court has to look at each defendant individually, it's not about their individual actions. It's about the compounding of all of their actions that led to Mackenzie Cochran's death. And as it relates to Gavin King, yeah, the video shows him grabbing Mackenzie Cochran's left arm. Now we know that Mackenzie Cochran, because of Dr. Smith's testimony, died from cardiac arrest due to prone restraint, which means while he's laying face down, he cannot take in air, and eventually his heart gave out. Now, there's been much ado about the manner of death, but as Dr. Smith said, that's more a statistical purpose for the medical examiner's office, and it has no bearing on the legal definition of homicide. Now, as we've seen the video, the people are not saying that the defendants did this intentionally, which is why they are charged with involuntary manslaughter. It is the argument of the people that these defendants owed a duty of care, at least owed a duty of using common sense when they interacted, when they held down Mackenzie Cochran. And because of that failure to use due care, their acts were grossly negligent, and it led to the defendant's death. And in the light most favorable to the people, the video, the testimony of the witnesses, even the testimony of Dr. Smith shows that they are the direct cause of Mackenzie Cochran's death, and this case should move forward to the jury. Thank you.
At this time, the court, having viewed the testimony and evidence in the light most favorable to the people, does find that there is a question of fact as to whether the defendants were grossly negligent in their actions towards the decedent. So I am denying the motions for directed verdict. And we'll take a brief recess for everyone and be back in about 10 minutes. Thank you.
Thank you.
All right. 2023-284857,
Good afternoon again, Robin Liddell on behalf of the people. And good afternoon, LaDonna Logan on behalf of the people.
Good afternoon. Jamil Khuja, appearing on behalf of Gavin.
Good afternoon, Doreen Elder, on behalf of Gavin King as well.
Good afternoon, Your Honor. Right Blake appearing on behalf of Aaron Murray.
Good afternoon, Your Honor. Keith Braxton appearing on behalf of Mr. Soberling.
My clerk is lining the jury up and will be in momentarily.
all rise for the jury.
You may be seated. All your first witness, please.
Dr. Lucia Dragovich.
Careful as you step up into the box.
Thank you.
Yes. If you could please turn towards me and raise your right hand. Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give before this court is the whole truth and nothing but the truth?
Yes, I do. Sir, can you spell your name, please?
I am Ljubisa Jovan-Dragovic, that's Ljubisa, middle Jovan, last Dragovic.
Sir, are you employed?
Yes, sir.
Where are you employed currently?
I'm currently employed in the capacity of Chief Forensic Pathologist and Chief Medical Examiner for County of Oakland.
And can you tell the jury what that entails?
Well, I'm responsible for anything and everything that the agency medical examiner in this county does things properly and according to the law, because we enforce one law, that's the Medical Examiners Act of the state of Michigan, and I'm responsible for everything that is done by my agency. There are other doctors that work with me, and there are investigators, there's clerical personnel, there's autopsy personnel. It's an operation, and that's my responsibility.
How long have you been the chief medical examiner for Oakland County?
It's 34th year running up now.
And can you tell the jury a little bit about your education and training, please?
Well, I graduated from medical faculty, University of Belgrade in former Yugoslavia back in 1975. So it's I've been a physician about 49 years now. I did the rotating internship there, and I did the compulsory military service as a medical regimental officer at the time that country existed. I also worked as in an underserviced area of the country for almost a year together with my wife. And then I was given an opportunity to come and train in pathology at Queen's University in Canada. I completed that, and I followed with subspecialty training in neuropathology, which is the subset of pathology that deals with injuries and diseases of the central nervous system, peripheral nerves, and skeletal muscle. And I continued my senior fellowship here at the University of Toronto, and then I was forced to move to this country because my wife was recruited by a major hospital system here, and we had no choice. We came with our children, moved in 1985, and there I worked as a research consultant at the Division of Biological Psychiatry within the Department of Psychiatry at Wayne State University. Somehow I was recognized as a suitable recipient of a Russell S. Fisher Fellowship Award. Russell S. Fisher was a noted North American forensic pathologist, and that took me from Detroit to Baltimore, and I served there at the Office of the Chief Medical Examiner for the state of Maryland. And then at the point in time when I was making a decision to establish myself there by accepting the offer that I had, a good man, now deceased, Dr. Werner Spitz, showed up one night at the office and asked me to come and join him to work in Detroit. And that's how I ended up working in Detroit, Wayne County, for about 3.5 years. I served there as an acting chief medical examiner for, I think, 4 months. And then I had an offer that I couldn't turn down, and this offer came from Oakland County government, and that was at the beginning of 1991. And here I am, 33.5 years later, still humming. So it's that simple.
Have you been qualified by the court to give an expert opinion in forensic pathology in the past?
Yes, sir.
And how many times would you say you testified in court as an expert?
Well, a couple of weeks ago, then I took off for a quick vacation, but that was the last time I was in court, actually, down in Wayne County.
How many times do you think you testified as an expert as a whole?
I don't keep the track of that, maybe hundreds and hundreds of times.
Okay.
Because it spans for over 37, 38 years now of active practice of forensic pathology. So,
And you've testified in many different courthouses, many different jurisdictions. Would that be fair to say?
coast to coast and abroad, and provided evaluations to issues from abroad. Yeah.
And do you teach as well?
I do.
And how many autopsies do you think you performed over the years?
One this morning, that's it. Today I had only one autopsy. Thousands of autopsies. I mean, that's...
And many of them involve the manner of death.
Well, each medical legal investigation of death is by law, by the state medical examiner's act, obliged to provide the cause of death and the manner of death, and then to interpret the findings along those lines to substantiate those claims, and also to reduce everything to paper. That was the old spelling in the law. Nowadays we keep the hard copies, but we also use electronic database. So I haven't read the recent update. They may have updated it now as far as reducing things to paper, dropping that out.
I turn this over to opposing counsel. Paul, expertise?
No, I'll stick it to his expertise.
Okay, thank you.
Okay. Are you asking to qualify him?
Yes, Judge.
He'll be so qualified.
Thank you.
Thank you, Your Honor.
As a forensic pathologist, sir, can you explain the jury manner of death, different manners of death?
The manner of death is simply how death came upon a person. It considers physical circumstances, and you heard earlier about that. Those circumstances have to be looked at and then correlated with the findings on the body and in the body during the external and internal examination of the body that frequently is referred to as autopsy. Autopsy is a diagnostic instrument. So a manner of death defines how death came upon a person. And those 5 manners of death existed from the beginning of the time, because even in Roman times, they were calling physicians as experts to assess what happened to a dead individual. It did not come up recently. It was not some discovery of this century or the last century. And it is acceptable as a logical assessment all over the world, all over the planet.
And so that's the purpose of an autopsy as well, correct? To determine.
The autopsy is a diagnostic instrument. It's part of our tool to come to a conclusion about why someone died, and then to integrate those results with the information that we may have or may not have about the circumstances surrounding someone's death.
And sir, were you involved in the case of Mackenzie Cochran?
I was involved in a supervisory position. Of course, I'm involved in every case, each and every case that our office performs, because there is a quality assurance process that is a standard operating procedure. So if one doctor performs an examination, carries out the medical legal investigation of death, other doctors look over to check out if everything is appropriately done. So it is kind of cross situation. Some people examine my work, I examine some other people's work. So I was familiar, of course, because there was a lot of discussion about this case back in 2014 when Mrs. Mackenzie Cochran died.
And the case came to you, why? Why did it come to your office?
Because it happened in the territory of Oakland County. It was in Northland shopping center at the time. I don't think that it's functional now, but that was the situation. That was the grounds where this incident took place.
It was the autopsy performed by a Dr. Lowe?
Yes, late Dr. Cheryl Lowe, who performed this autopsy was one of my colleagues at the time. She subsequently, well, several years later, retired because of her back problems, and sadly enough, I just heard that she passed away about a year ago.
And you indicated that you, as for quality control, you guys double check each other's work, and that's what you did in this case here?
That's the standard operating procedure. That's the review of the documents issued, the review of microscopic slides if they are available, obviously if they're made, and in these cases with many questions, that's additional type of work that is done. We call them ancillary studies to kind of get into the inner structure of the tissues. The photographs are reviewed, any material in the file, the videos, video surveillances were reviewed, and not only by us, by law enforcement too, that was in general available for this, and that's the process.
A report was eventually generated, correct?
Yes, Dr. Lowe issued the report, yes.
Your Honor, may I approach the witness? Sir, I'm handing you defense exhibit C. Can you tell me what this document is?
This is the photostatic copy of the original report issued, the original report that I have in my file, because I am a custodian of records for the medical examiner's office. So it includes the general autopsy report by Dr. Law, and it has the diagram and also the toxicology report of the ancillary studies, the toxicology studies.
I move for its admission.
No objection. It's admitted. Is that your exhibit C?
Yes.
Yes. Sir, in terms of the manner of death, sir, what does the report indicate? What's the manner of death?
The report indicates that the manner of death was accident.
Okay. And was there an opinion in terms of the diagnosis of death as well?
Yes, the diagnosis, it was position compression asphyxia.
And based on that, you reviewed, did you review video as well?
Oh, of course I did.
Okay. And if the decedent had not resisted, do you think he'd still be alive today?
I would hope so.
Okay. And at some point, sir, you met with, did that case at that time, 2014, have a lot of attention to it?
Yes, there was a lot of discussion, a lot of reviews with multidisciplinary reviews. Not only the case was not reviewed just by our office, but by the outside structures as well.
When we say outside structures, who would that be?
Was it general law enforcement, the main law enforcement, uniformed law enforcement, people from Southfield Police Department, prosecutor's office, everybody that would be in line to ask questions about this matter.
So you and your staff, would it be fair to say, would you guys met with the prosecutor's office and law enforcement about this case?
In multidisciplinary setting, in our auditorium, at least several times. I don't know exactly how many, but at least several times where a lot of people being present, all the photographs being shown, everything discussed to every detail.
You said auditorium.
Yeah, we have a classroom type. It's Dr. John Burton Memorial Auditorium. That's what we call it.
Well, do you have a conference room as well?
Oh, we have a conference room, but the conference room can accommodate maybe 12 to 16 people. The auditorium can accommodate about 50 people or so.
So would it be fair to say you had a lot of people, you had to use the conference room? I mean, the auditorium, I'm sorry.
That was the purpose. That's the purpose. That's what we give lectures to.
So you render your opinion that it's an accident in the diagnosis as well, correct?
Well, the office provided that. Dr. Lowe, who is handling the investigation, rendered the opinion. We checked it out, and we concurred with the opinion, and that was the discussion going on when it was presented to other people, other subsets of law enforcement. We are an independent structure within law enforcement. There are other people who may or may not have immediate interest or developed an interest to be there and discuss this.
And at some point, sir, there is no prosecution. It's determined that this case should not be prosecuted, correct?
Objection, Your Honor.
Okay.
Relevance.
I'll rephrase it. Other than today, sir, were you ever called or anybody from your staff called to testify in this case?
Objection.
No, Judge. It goes towards the credibility of his report. Whether or not he testified before, in regards to what he's testifying today, it goes toward the credibility of his testimony as well.
Your Honor, I don't believe whether he testified to Dr. Lowe's report in a hearing outside of today or this matter goes to the credibility of his ability to testify to the report. That's circular logic.
Judge, it goes to the accuracy of his report.
It's not his report.
Well, Judge, he said Judge, he testified that it was double checked, triple checked. It's the way his office works for quality assurance, Your Honor. So he is aware of this report. He signs off on this report.
But that's not the question that was asked. The question was asked whether he's testified as it relates to his reports going forward, and that's not relevant.
Okay.
What is the relevance
All right,
of
Judge.
that? You can certainly,
I'll rephrase the question.
thank you.
Sir, after you met with law enforcement,
Yes.
after that, did anybody else from law enforcement ever contact you about your report?
Up until today or immediately after that in it?
After your file was put away, 2014-ish, you had met with all these authorities that you talked to.
Right.
Eventually your file was put away, correct?
Yes.
When's the next time you heard anything about your report?
A couple, 3 years ago, maybe 4 years ago.
Okay, so almost a decade later, you were asked about your report, correct?
Yes, sir.
And who is the person that asked about your report?
This was Mr. Patterson, Mr. Orlando Patterson from Attorney General's office.
And what did he ask you to do?
He was asking, we had a couple of phone calls and a Zoom type of communication, I remember. He was asking about the details of the case and what I had to say, and I told him everything that I thought was in the report and in the evidentiary material, and that was it.
You know, I asked the court to take judicial notice that Orlando Patterson was a prosecutor in this case, appeared before this court in this case. On behalf of the Attorney General.
I don't understand how that's relevant.
It goes to the credibility of his report. It goes to the credibility of his testimony.
It's not his report, and it has nothing to do with his testimony that he spoke with a member of the Attorney General's office before today.
Judge, it goes to the motive of the prosecution. In addition, Judge, it goes to the credibility of what's in that report because he was asked to reconsider that report.
That is not what this witness testified to.
Well, if you let me ask a question, I'll get that from him too.
Okay, enough. Ask him that question.
Sir, were you asked to give a second opinion on this case?
Yes.
And were you asked to have your opinion reconsidered in this case?
Yes.
Okay. And sir, you met with this Attorney General, Assistant Attorney General. Did you meet in person? Was it on Zoom?
It was on the phone and on Zoom.
Were there other individuals other than Mr. Patterson on this Zoom?
There was a nice-looking lady on the Zoom to another attorney, but I don't remember her name.
Okay, do you recognize her at all or not?
I don't remember. This was about 3 years ago,
Okay.
something like that.
All right, and you end up telling him that you're not changing your report.
I simply said that I have no basis to change this report because this report is well substantiated by critical evidence, and there is no, I cannot spin something out of it. That was simple as it is, and that's always the situation when you're looking at evidence and stating things that you cannot change because they are there. The evidence is there. I cannot change the evidence.
So basically, you indicated this is our findings, and they're not changing.
Yeah, unless they can provide any new evidence that supports the suggestion to change the cause or manner of death.
Speaking of spinning, you heard Dr. Schmidt's testimony, correct?
Yes.
Okay. And you read his drafted 3-page report, correct?
Yes.
And you're aware of his opinion, correct?
Yes, I listened to the testimony.
Okay. And do you have an opinion in terms of his opinion, his testimony?
I don't know where and what new his testimony brought, but the conclusions are strange, and he claimed here, right in front of all of us, that this is not an accident. On the basis of what? I have to explain a little bit more about the accident, and he actually provided the definition of an accident earlier, and he said that it's unintentional act. And you know, if someone shows me an intentional, purposeful act, well defined, then that's a different thing. But there is no such thing, and that's what everybody looked at originally in the evaluation of this case.
Dr. Dragovich, the government knew of your report, correct?
It's a public document.
Correct. And you were called by Attorney General about your report, correct?
That's correct.
I'm sorry, Assistant Attorney General, correct?
Yes.
Did Dana Nessel call you?
No, I don't remember talking to Dana Nessel in about, I'd say 20 or so years, maybe less, 15 years, but not when she got elected to become the Attorney General. I worked with her in Wayne County, and
Yeah, I don't object to this narrative. I believe the question has been answered.
Okay. Have you worked with Dana Nessel in the past?
yes,
And sir, you reading Dr. Schmidt's report, sir, do you think that his opinion flip-flops?
I don't know what his opinion is, because he simply said this can be indeterminate, which means simply I don't know, or a homicide. So take your pick. That's not how forensic science works. So that's my comment.
So you talked about quality control, sir.
Yes.
And you've been at a place for 34 years where you've never been disgraced or tossed out like Dr. Schmidt.
Objection, Your Honor.
No, Judge, it's a question.
No.
But I'm not done with my question.
Okay.
So
Let him finish his question.
and then I'm gonna object.
Thank you. Go ahead.
have you or anybody in your staff ever had an opinion where it says it could be homicide or indeterminate?
That doesn't make sense.
But that isn't the question, Doctor. The question is, have you or anybody in your staff ever done that?
Oh, no, of course not. I mean,
That's fine. That's it. Okay, continue.
So in the opinion that Dr. Schmidt is given, there is doubt as to what it may be, correct?
Absolutely, but there is no clear definition either way.
And the doubt is reasonable, correct?
very reasonable because it says, I don't know. If you ask someone to give you the evidence and they say, I don't know, then there is no evidence to interpret.
Is there anything that I did not ask you about that you'd like to elicit your opinion on?
Not that I can.
Objection, that is overly broad.
Judge, I'm asking if there's anything that he wants to render opinion about Dr. Schmidt's report or Dr. Schmidt's testimony.
I would object to that. I think he needs to ask specific questions.
Oh, yeah. So there's some slides taken, correct?
Yes, sir.
Okay, is there anything that you recall from your report that's inconsistent with what Dr. Schmidt testified regarding the slides?
Well, he ignored the findings in the lungs, and and it was clearly stated in the original autopsy report and clearly present in the microscopic slides that there was hemorrhage in the alveolar spaces of the lungs. That is a significant finding. That is a finding of a particular effective strain for someone trying to breathe, and that's associated with asphyxiation process. So this is an important finding. Also, the finding of marijuana in the system. The cannabinoids are a very, very important thing. They alter human behavior. They have the capacity to create hallucinations, and they basically affect human behavior. And then, if you even for the fact that they are legalized now, same thing. It can be transposed into alcohol. Someone under the influence of alcohol, it has changed behavior. Well, the cannabinoids are very important finding in this case because of the confrontation with the individuals from security services.
Sir, you want to plug it real quick? No, plug it. Oh, okay. Sir, I'm going to show you something on the screen, sir. Could you tell me what that item is? What is Can you tell me what that photo is?
That's a photomicrograph of one of the slides from the lungs. There were multiple slides taken, similar findings. You see the red lines; those are the walls of the air sacs, and they are engorged because of the blood vessels. Because the blood vessels are engorged with red blood cells. Now you see the kind of white empty spaces, and you see those pink dots. Those are red blood cells. They have no business being there. And any time you have red blood cells in the alveolus, in the air sac, in the lungs, you do not have normal breathing. The breathing is cut out. So this is a representative photo from the microscopic slide. And that's mentioned in the report. It was documented. It was referenced. But the claim was that there was engorgement of the liver. Yeah, sure, there was some hyperemia in the liver, but
Your Honor, I'm going to object to this narrative. It's going beyond the scope of the question.
Judge, we move for admission of this exhibit C. I'm sorry, D. I'm sorry.
No objection.
So this is a significant issue in terms of the slides, correct?
well, it's a significant finding. It's an abnormal finding, and one has to document abnormal findings in order to integrate and define the diagnostic process, if you want.
So when Dr. Schmidt says there's nothing else of significance, that's completely incorrect.
Well, it is incorrect.
And you have evidence right there, correct?
Yeah, evidence speaks for itself.
Thank you.
You're welcome.
No questions from the doctor yet.
I just have one question. It was a question that how are you?
Fine, thank you.
It was a question I made to Dr. Schmidt. It was basically, in your opinion, wouldn't you say a live, if you are examining the body yourself, you would be able to do a more accurate report than just doing a review of someone else's report?
Well, generally, that's the reasonable proposition because someone looking at something is in the best opportunity to notice the appropriate things and to document the appropriate things. However, it is very, very important that someone who is documenting things know and carry on the proper documentation of every detail, even though that they may not be able to interpret everything, because no one knows everything. Only fools know everything. But there are levels of expertise, and people can look at the findings and conclude about it. But once one looks at someone's findings and someone's evidence, it has to be incorporated all in all and address things that are in agreement or things that are possibly not in agreement, because that's the process. You don't skip the things that you don't think are important or for whatever reason. Everything has to be there for someone who is secondarily reviewing, and if they are generating a report, the report should include everything that is mentioned there as evidence, whether they agree about the value of that evidence or not.
In the past, how many times have you had to correct Dr. Schmidt?
Objection, relevance.
Your Honor, just have a question on how many times he's had to review, and in the past, just determine Dr. Schmidt's, the fact that he's had to have a review himself.
Well, Your Honor, again, objection, relevance. I think there's, I mean, it goes outside the scope of his opinion. I mean, I could hazard to say Dragovich probably thinks Dr. Schmidt's always wrong. So,
well, let him say.
No, this is not relevant, and this is my objection.
Counselors, I'm going to sustain the objection. That's
Thank you.
No further questions.
Thank you.
Good afternoon, Doctor.
Good afternoon, ma'am.
Now, when Mr. Patterson contacted you about Dr. Lowe's report, isn't it true that he just asked you for a second opinion because Dr. Lowe was not in the state of Michigan at the time?
I don't know why he asked me for a second opinion, because I told him there is.
You answered my question. Thank you.
He's got to press the question. The answer. You cut him off.
He said he didn't know.
No, but you cut him off.
All right. I know it's been a long trial here, but let's try to keep a little decorum.
Yes.
All right? And please let people finish their answer before you.
Well, Your Honor, the witness had answered my question, and I was preventing him from running off.
Well, please let people finish their statements.
I will, Your Honor.
Ask your next question.
What was the cause of death in Dr. Lowe's report?
Position compression asphyxia.
And what does that mean to us?
It
who are
means,
not-
in rough translation, it means the heart stopped, because asphyxia in Greek means stoppage of the heart. The heart stopped because of the pressure and position of someone's body that could not oxygenate properly due to that position and compression.
And I believe you said that there were other materials that were reviewed in coming to this cause of death?
All of the materials that were part of the examination of the body, the microscopic slides, the toxicological analysis, the photographs that were taken. Yes, as far as our aspect is concerned, there were other materials. They're here. This is the original file, and other questions came from the outside, obviously.
What other materials did you review from the outside?
The video surveillance camera results, the footages that were brought by the Southfield Police, and that would be about it. And of course, the immediate situation, the emergency EMS report, and the admission to the hospital. So those are the materials that are pertaining to our scope of interest. Other questions came from different entities, but I don't have any other materials generated. No.
I just want you to answer my questions if you could. Now, when it comes to authoring the report, isn't it important to explain how you come to your findings?
Well, that's the report. The report states what the findings are. One gets the idea, reading the report, how things are assessed. That's the purpose of the report. So how the external appearance of the body looks, how the internal appearance of the body looks. Yeah.
I hate to interrupt, but my question is, wouldn't it be important to have how any external information that you review in the report that you use to come to your the ultimate conclusion of cause of death?
In the autopsy report? In the autopsy protocol? No. No, this is autopsy protocol addresses the autopsy.
So you don't explain how you determine the cause of death?
Well, if someone reads this report, they will understand what has been accomplished through the examination of the outside of the body, the inside of the body, the organs that are within the body, and everything is listed accordingly. Any external type of information will be looked at, but they are not part of the autopsy report. Okay. The police report is there, you know. So.
Dr. Dragovich, what information is in the autopsy report that leads to the conclusion that the death is positional asphyxia?
The findings, the autopsy findings.
Specifically, what are those?
The presence of blood in the lungs, the absence of other injuries, and the information in our investigative report that is part of the file of what happened, what has been reported. So we have separate investigators' report.
So the circumstances of how the decedent died is also taken into consideration, but not included in your report?
They are not described in detail in the report, but they are described in other documents that are obtained by our agency.
Okay. And your separate report, does it include information that Mackenzie Cochran was held down by multiple guards?
Yes.
Okay. And is that what Dr. Lowe took into consideration when she determined the cause of death was positional asphyxia?
Yes.
And because of the position that Mr. Cochran was held down in, that eventually caused his death, correct?
Well, that resulted in his death because of the critical position that he was placed in. Yes.
I want to talk briefly about manner of death.
Yes.
Now, Dr. Lowe says that manner of death is accident. Could you just tell us briefly what, for purposes of an autopsy, what accident is?
Accident is a category of manner of death where death results from untoward or unintentional acts of another person's acts of nature, like volcanoes, tornadoes, acts of God.
So like a car crash?
Yes. A car crash where someone is driving a car at the regular speed or high rate of speed, impacting someone crossing the street or crossing the road, or striking another car or something that is untoward effect of someone's acts of actions.
What's homicide?
Homicide is a category of death where death results from purposeful act, demonstrable purposeful act of another person or persons. If I may explain further.
Nope.
Okay.
You can redirect, okay? Enough.
So if homicide, for manner of death, is loosely defined as death at the hands of another, would you agree or disagree with that?
Absolutely not. Because that's a nonsense. That doesn't give anybody any idea what actually happens. And this is why I wanted to expand to explain
No,
the
but
things.
I just need you to answer my question. sir.
It's your question, your answer. Thank you.
Thank you. Now, when does a case fall into indeterminate?
When there is no way to determine because there is no enough information about the circumstances surrounding someone's death. It means an open case.
Okay. And regardless of manner of death, Dr. Lowe's opinion was positional asphyxiation as the cause of death for Mackenzie Cochran, correct?
So of course.
And you agree with that, correct?
I agree with that.
And that's because part of your consideration was the fact that he was held down by multiple guards.
Yes, ma'am.
Thank you.
You're welcome.
Was it because he was resisting as well, sir?
Objection leading.
Well, not that. What could it be because a person resisting as well?
Well, of course.
So if there was no resisting, then there'd be no issues, correct?
But there would be no need for anybody's intervention if there is no confrontation.
So you wanted to elaborate on when you were explaining the definition of homicide.
Yes, sir.
Right.
Thank you. The example of homicide, the example of a purposeful act, is someone loading a gun and shooting the gun into someone. There are several purposeful acts in this. If someone takes a 2x4 and bashes someone's head, and they die. That's the example of homicide. Someone takes a knife and thrusts into someone's body once or multiple times, which is a purposeful act. But in a situation where that purposefulness is not present or even part of it, because things are happening as a result of untoward effects, then you have the obligation to appropriately classify that as accident. Or if you don't know, then you say, I don't know, and there is no classification.
Nothing good.
Thank you.
No questions. No questions.
No, we're done. What? No, we're done. You get direct, cross, redirect, recross.
I didn't get him first.
Oh, I'm sorry. Yes, I apologize. I am so sorry, Ms. Logan.
You're used to him being called by people who call him.
Yeah, I know. I
Objection.
understand. I apologize. I am so sorry, Ms. Logan. Please go ahead.
I believe when Mr. Elder asked you if Mr. Mackenzie Cochran had not been resisting, then there would have been no prone restraint or prone positional asphyxiation.
Of course not.
Well, what if he's not resisting, but someone's holding him down?
Well, Judge. It's a hypothetical, Judge, that she knows it's not evidence.
Well, he's an expert, and I'm allowed to ask hypotheticals. And I do believe the video supports that. And I'm trying not to get too into the facts in front of the jury, but I do believe there's a portion of the video that supports that Ms. Mackenzie Cochran stops resisting, and they're still holding him down.
Judge, the jury the video speaks for itself.
Yes, if I have to say it one more time, the video speaks for itself.
It does, Your Honor.
You may ask the question that you
Thank you.
had asked. Repeat it for the record so the doctor can answer.
What if the decedent is not resisting, but someone is still holding him down? Prone.
This does not happen out of the blue. Someone has to be there to apply pressure to hold him down for a reason. So you're taking something out of context, something that someone is applying some pressure there to hold him down, and he's not resisting. He might have become unresponsive by that time.
Well, Dr. Dragovich, you're going beyond my question. My question is, the decedent is on the ground, not moving, not resisting, not fighting, and he's being held down by multiple people. Could that result in positional asphyxiation?
Asked and answered does many times.
It was not answered.
She may not like his answer, but he answered it.
Do you understand the question, Doctor?
I don't, because I was asked to speak the whole truth and nothing but the truth, and not half the truth or 1/4 of the truth, Your Honor. And here are questions coming up that make no sense to me.
Okay. If you don't understand the question, then just say so and...
I don't understand the question.
Okay, very well.
Okay. This is an example, just hypothetical. Mackenzie Cochran is laying on the ground, prone, face first. He's not resisting, not anything, but someone is on top of him, not on top of him, but applying pressure on his body, holding him down. Could that result in positional asphyxiation if he cannot breathe?
Sure.
Thank you.
Thank you. Thank you, Dr. Dragovich. You may be excused.
Thank you, Your Honor.
You have further witnesses?
We have one more witness, Judge.
Yes. Defendants have one more witness, but unfortunately that witness was not able to be here this afternoon, so he will be here tomorrow morning. So we will resume at 8:30 tomorrow, and that I believe will be the final witness. Unless you have any, are you anticipating any rebuttal witnesses?
As of right now, no.
Okay. So hopefully, that will be the final witness, at which time we will then have closing arguments, and then I will instruct you on the law. And we will choose 12 of you to begin deliberations at that time. All right? Once again, I caution you not to discuss the case with anyone, not to listen to any news reports or read any articles about the case. And I will see you tomorrow morning at 8:30. Have a good evening.
All rise for the jury. All rise. The Sixth Circuit Court for the County of Oakland is now in session. The Honorable Martha D. Anderson presiding.
Good morning.
Good morning.
Right now, my clerk is lining up the jury to bring the names.
Recording in progress.
I have to double record this judge because of the suit witness.
Your Honor, calling People v. King, case number 2023-284855 FH. Calling People v. Marie, case number 2023-284856 FH. And calling People v. Cyberling, case number 2023-284857 FH.
Good morning, Your Honor. Robin Liddell on behalf of the people.
Good morning, Your Honor. LaDonna Logan on behalf of the people.
Good morning, DeRay Elder, Mr. King, would you stand behind me?
Good morning, Jamil Kuja appearing on behalf of Gavin King.
Good morning, Your Honor. Wright Blake appearing on behalf of Aaron Marie.
Good morning, Your Honor. Keith Braxton appearing before you for John Cyril.
All rise for the jury.
You may be seated. Good morning, ladies and gentlemen. We're ready to proceed this morning. Call your next witness, please.
Thank you, Your Honor. We call Mr. Charles Joe Key to testify, and he is appearing via Zoom. Thank you. Tell me you lost him.
Signed on and admitted, but his camera is closed and his sound is closed. Hold on, I have him on my screen, but he's not on this screen. That's the largest view I can get. You can hear and see us, Mr. Key?
Yes, ma'am.
Okay. If you could please raise your right hand. Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give before this court is the whole truth and nothing but the truth?
I do.
You may proceed.
Thank you, Your Honor. Good morning, Mr. Key.
Good morning.
Could you explain to the jury your educational background and your general work history?
I became a Baltimore police officer in October of 1970, went through the academy, came out, did the job of a police officer, was assigned to post, made arrests, car stops, gave tickets, checked buildings, that sort of thing. In 1972, I was selected as one of 27 officers out of the 3,310 police department to walk foot posts in high crime areas in an outreach to communities to try to get community organization in reducing the amount of crime. I stayed there for approximately 15 months and then was selected to go to the intelligence unit as a detective, where we investigated upper echelon level crime in the police department. We were not internal affairs. Our focus was on command staff and or outside influence, such as organized crime, corrupting the police department. Then,
So I'm going to stop. Can I interrupt you for just a second, Mr. Key? Could I just ask you one question about that? Are you saying you investigated fellow police officers at that time?
Yes, sir. We investigated. In fact, during my time there, we put 20 Baltimore cops in jail.
Thank you. Please continue.
1975, I was promoted to sergeant because of the work I had done on international terrorist incidents. I was sent down to tactical to start their SWAT teams. I started the SWAT teams for the Baltimore Police Department, became the first SWAT commander, first trainer. Worked in that position for approximately a year and a half, 2 years, and then was promoted to lieutenant in 1977. In October of 77, I graduated magna cum laude from the University of Baltimore with a degree in criminal justice. I stayed a lieutenant in the Central for approximately 8 years. During that time, I had 65 officers, 5 sergeants under my command. I was, after a year or so as a ship commander, I was sent down to become operations commander, which is like a mini tactical section. Worked in high crime areas, worked with crowd control, that sort of thing. Then, after a short stint as operations commander of the Southern District, they had a problem firearms training unit, and they sent me out there as the first commanding officer of the firearms training unit. And during that, my tenure there, because of my background in ballistics and the work with firearms, then I assisted homicide at the direction of the commissioner and the state's attorney's office in investigating serious police use of force, meaning the use of force that results in individuals being injured or killed. I wrote the police standards for the Maryland Police Training Commission on use of force training for police officers, including lethal force firearms. I also wrote the general purpose and guidelines for Baltimore Police Department. At the same time, served as a non-paid consultant. I was working as a member of the Baltimore Police Department with other agencies on the East Coast in designing their use of force training programs.
Do you have any experience with private security training?
Yes, sir. I wrote the security program for the Johns Hopkins Hospital. Their security requires the handcuffs, pepper spray, and the pods. I also wrote the security program, and including use of force and training for the Rouse Company. The Rouse Company was one of the largest of the recreational mall type. They had places all over the country, and including Inner Harbor and Baltimore. I wrote their security and set up the training program, and did the training program for their security officers.
Could you tell the jury what specialized training you had?
Every police officer in Maryland, actually in every state, has to undergo the recruit training level, and depends on, generally depends on what's being offered. But they're all last approximately 6 months. Then you're required to go to in-service training every year to catch up on if laws have changed or policies have changed, and or go over again issues that are important to police officers, like probable cause, reasonable suspicion, that sort of thing. In addition to that, when I went out to the firearms training unit, I became the sole instructor on the use of lethal force. As I said, I've written a program. And my specific training in that involved the 2-week requirements from the Maryland Police Training Commission, 80-hour course on becoming an instructor. I had, because I was mid-level management, I also was required to go to in addition to the in-service, the management schools put on once a year by the Maryland Police Training Commission. I had training from Northwestern University in use of force from the Federal Bureau of Investigation, hostage negotiation, SWAT, also became an FBI certified defensive skills instructor. I've had various courses throughout. Of course, my degree, again, in criminal justice covers a very wide range of subjects that are involved in law enforcement.
Do you have any experience in use of force?
I was assigned to assist homicide and any use of force which resulted in serious injury. Homicide, the Internal Affairs Division, and the State's Attorney's Office. As a supervisor, any officer that uses force, the supervisor has to write a report indicating what occurred during that. As a lieutenant, you're responsible then for each of the sections. As I said, I had 65 some odd officers and 5 sergeants. And then when I went out to training, I oversaw the entire use of force training program and put together their defensive skills training program.
What certifications have you had as an expert in police use of force?
Certifications were certified by the Maryland Police Training Commission to teach use of force subjects.
Have you been qualified by any courts to testify as an expert in use of force?
Yes, sir. In 110 courts, that includes circuit courts from around the country, and it also includes 20 some odd federal courts.
So, over 20 different federal courts, as well as different state courts across the country?
Yes, sir, 110 times.
Have you ever appeared at a court and then failed to qualify as an expert in police use of force?
No, sir.
Okay. What is your experience in training police officers?
Other than what I mentioned, I was the sole trainer for 3,000 some odd police officers, but in addition to that, I worked as an adjunct instructor for the University of Delaware and the University of South Carolina in teaching police agencies up and down the East Coast. Today, I am the chairman of the board of the Harvard Associates of Police Science. No organization is no longer sponsored by Harvard.
It cut out a little bit.
There at one time, it's now sponsored by the Maryland Medical Examiner's Office, and what that job is teaching not just police officers, detectives, but attorneys and medical personnel, policing personnel, how to properly investigate in custody death and homicide. That's ongoing. We've been doing that for about 10 years. I was president of the organization for 2 years.
And so what is your training as a police trainer? Is that what you're discussing?
My training, in addition, of course, to my degree, is every individual who is a trainer in the state of Maryland has to be trained at whatever level they are trained. In my case, you start out as an instructor, so you have an 80-hour course as an instructor. Then you have different courses from 40 to 80 hours in specific subjects like firearms, defensive skills, that sort of thing.
All right. So in addition to qualifying as an expert in use of force, have you been qualified as an expert in any courts on police training?
Yes, sir. 117 times, as I recall. 24 of those are in federal court, the rest are in circuit courts throughout the United States.
Have you ever failed to qualify as an expert in police training?
No, sir.
What is your experience in policy and procedures?
Policies and procedures are those guidelines, general orders, etc., that govern how police officers act under certain situations. I wrote a number of general orders. I wrote the general order for the resolution of cyber barricade situations. I wrote the general order for use of force. I wrote the training guidelines for use of force. I wrote the general orders for use of pepper spray and the training for it. And then anything that had any officer's safety concern came to me for comment from the Planning and Research Division, who were the ones that put out the general orders. From the standpoint of those policies and procedures, I've authored a number of them, some of which have been adopted by other agencies. And from the standpoint of the running, if you will, of the police department, I serve on trial boards, which is a trial to determine whether an officer has violated the departmental policy, and I serve numerous trial boards.
All right. Do you have any certifications as an expert in police policies and procedures?
As an expert, qualified in 120 some odd courts, 26 or so federal. The rest are circuit courts throughout the country.
Have you ever failed to qualify as an expert in police policies and procedures when offered as an expert?
No, sir.
Now, what is your experience in defensive skills?
65 years of martial arts. I started out at boxing at 10 years old and bowling gloves, and have taken judo for a number of years. The Krav Maga, the Israeli defense, Eastern Karate. I was qualified by the FBI as a defensive skills instructor. I took their 80-hour course. There is now it's ceased, but there was a 10th and black belt named Coda from the West defensive skills course, specifically batons, and received certification in the use of pepper spray, and also had spent a year or so in learning Filipino knife fighting.
All right. And have you been qualified as an expert in defensive skills in any courts?
46 courts, I think 10 or 12 of those federal.
Okay. Have you ever failed
The
to,
rest very.
okay. Have you ever failed to qualify as an expert in defensive skills training?
No, sir.
All right. Your Honor, I would turn Mr. Key over to the government if they have any questions regarding his expertise on the areas of use of force, police training, including private security, police policy and procedures, defensive skills. Do you stipulate or do you?
No, I have some questions.
Well done.
Good morning, Mr. Key. Can you hear me okay?
Yeah, ma'am, okay, good morning.
Okay. Now, if I am looking at your curricular vitae correctly, a lot of your law enforcement experience took place in the state of Maryland. Is that correct?
That's correct.
Okay. Have you ever served as a law enforcement officer in the state of Michigan?
I have not.
Have you ever conducted any trainings with law enforcement officers in the state of Michigan?
In the state of Michigan, no, I have trained Michigan police officers.
Thank you. You've answered my question. Have you ever worked as a mall security officer in the state of Michigan?
No,
Are you familiar with Michigan's Public Act 330?
not specifically as, with that number, no, I'm not sure what it is.
Do you know the difference between a security guard that is PA 330 certified and one that is not?
Not given that specific reference, no.
Your Honor, I would object to this witness being an expert in this case. He may have a lot of expertise, but as it relates to this case and these defendants, he does not have the requisite expertise outside of general knowledge that is already known to our jurors.
Your Honor, this man has testified across the country. He has written books on private security training in addition to police training. His opinion is relevant to the issues before this court and could aid the jury in making their decision.
May I respond to that, Your
He
Honor?
does not need to be an expert in a particular statute to be able to give opinions on the areas for which we are offering him as an expert.
May I, Your Honor?
Yes, you may respond.
Well, first and foremost, as I stated, these defendants are not police officers, so his expertise in police officer use of force is not relevant. And as the court said in People v. Drossart, Drossart at 99 Mission Appeal 66, a 1980 case, an expert is not supposed to give an opinion that invades the province of the jury. Specifically, it applies to an expert opinion that is being offered on a matter equally within the scope of a jury's common knowledge. We're talking about gross negligence here, which, as the court knows, the law defines as ordinary care. There is nothing that I heard in the in the witness's very lengthy expertise that would put him in a place to talk about ordinary care more than what the jury could define and discern for themselves.
Judge,
Yes.
if you want to respond?
Go ahead.
Judge, he testified that he has literally written the use of force training for private security at Johns Hopkins University, as well as Rouse Corporation, which is one of the largest mall companies in the country. And so his opinion regarding the use of force by security officers at a mall is relevant. He does not need to be familiar with the specific statute within each state. I'm sure in the 117 or so courts he said he's testified in, he probably didn't read each state's particular law regarding security officers. They're likely all very similar.
Thank you. At this time, based upon the witness's qualifications, the court will allow him to be qualified as an expert. Thank you.
Thank you, Your Honor. And again, that would be in use of force, police training, including private security, police policy and procedures, and defensive skills.
That's correct.
Thank you, Judge.
You may proceed.
Thank you, Your Honor. Mr. Key, I see that you're testifying via Zoom. Could you tell us where it is you are?
I'm in wonderful downtown Swope, Virginia.
All right. And I know initially you were going to come here to testify in person. Is there a reason that you needed to testify via Zoom instead?
Yes, sir. My wife had a deteriorating shoulder. Felt she had to have a complete shoulder replacement, reverse, they call it. And she can't do anything for herself. So I have to be available to take her to the doctor, she's now getting physical therapy. Anything that has to be done, I better do it for her. And that's, I've got about 2 more weeks of that.
All right. Well, thankfully, we have Zoom now. So thank you for being willing to testify for us. Can you please tell the jury what you have reviewed in preparation for your testimony here today?
Yes, I sent you a list so that you could provide, because it's lengthy. I would have to read off that list.
Do you have that in front of you?
Yes, I do.
Okay. Could you tell the ladies and gentlemen of the jury what it is you relied on to prepare for your testimony?
Okay, the Southfield Police Department case report, test investigation by Officer Hancock, handwritten memo from, I'm going to pronounce his name best I can, Labib and Sarah, and Southfield Police Department follow-up report, test investigation, Southfield Police Department follow-up report, test investigation by an Officer Rolando Riviera, statement from Northland Security Sergeant Gary Chapin, written statements from security officers Severling, Hamilton, King, Marie, and Hale. A number of Southfield Police Department death investigation supplements, handwritten statement of Keel Copeland, the Southfield Police Department case report, death investigation by Officer Hancock, handwritten statement of Rafina Kinney, Southfield Police Department case report. It's another follow-up by Officer Hancock. Interview of Latifah Kinney, handwritten statement of Latifah Kinney, Southfield Police Department case report. Interview of Oy Monk, handwritten statement of Oy Monk. Southfield Police Department case report. Interview of Jasmine Monk, handwritten statement of Jasmine Monk. Southfield Police Department case report. Interview of Gary Dyson. The autopsy of Mr. Mackenzie Cochran. Surveillance video on LA Diamonds, camera 4. Surveillance video of LA Diamonds, camera 5. Northland security video. Cell phone videos, there were a number of them, 911 tape regarding the call that was made to the police. Document entitled The Assistance of Customers, Visitors, Employees. Document entitled Continuing Education Series, Handcuff Procedures, Instructor Presentation Outline. A document from the Department of Justice about the effects of OC spray, that's oleoresin resin capsicum pepper spray. The U.S. Department of the National Institute of Justice study on the effectiveness of pepper spray, and the discovery materials in this case provided by you, including the handcuffing lesson plan that was in effect at the time of this event. The U.S. Department of Justice pepper spray affects suspect's ability to breathe, and again, it's the Department of Justice and Northland training materials.
Okay. Mr. Key, I'm going to ask you some questions regarding your opinions in this case. Will your answers to these questions that are asked be given to a reasonable degree of certainty in your field of expertise?
Yes, sir.
Going to be asking you questions about how police are trained, and when I refer to police training, that may also include security officer training. Do you understand?
Yes, sir.
It sounds like you reviewed a long list of materials. When were you first contacted to review this incident?
In the summer of 2014.
Who contacted you?
Mr. Paul Walton. He was the chief prosecutor, chief assistant prosecutor, the Oakland County Prosecutor's Office.
All right. Is he someone you knew beforehand or not?
No, sir. I'd never heard of him. Didn't know him.
Okay. And what did Mr. Walton, who's the chief assistant prosecutor for the Oakland County Prosecutor's Office, ask you to do back in 2014?
He asked me to review the case, the materials, the videos, and provide an opinion as to the reasonableness or lack thereof of the security officer's actions in the attempt to control Akron.
I want to ask you, did he at any point suggest to you which way he wanted you to rule?
No, sir.
All right. After you completed your analysis, did you write a report regarding your conclusions back in 2014?
Yes, sir, I did.
And what conclusions did you reach?
Your Honor, may we approach? Yes?
Yes.
You may proceed.
Thank you, Judge. I think where I left off was that I asked you after analyzing all of the materials that were provided to you in 2014 by Oakland County Chief Assistant Prosecutor, if you were able to reach a conclusion and write a report.
And yes, I was and did.
All right. And did you reach a conclusion regarding whether the actions of the security officers in this case were consistent with accepted standards of police policies and training, including that of security officers?
I did, and they were.
Okay. Did anyone from the Michigan Department of Attorney General, who is currently prosecuting this case, contact you at any point?
No, sir.
All right. The last government official that you interacted with regarding this case would have been Mr. Paul Walton back in 2014, is that right?
That's correct.
All right. After providing your opinion to the prosecutor's office back in 2014, when is the next time that you were contacted regarding this incident?
When you called me earlier this year.
Okay. And what did I ask you to do?
Essentially the same thing, review the materials. You said you were representing Mr. Gavin King, to focus on what Mr. King had done, review the new materials in discovery, and then provide you with my conclusions.
Did I at any point suggest to you what your conclusion should be?
No.
So, we'll get to those conclusions in a bit, Mr. Key, but according to police training, including security officers, what is the definition of a use of force?
Use of force is a physical, an intentional physical act by a security officer or officer in order to lawfully control an individual and or protect the officer or others from attack.
When can a security officer use force?
When it's lawfully necessary to control the person, such as attempting to arrest or trying to frisk him, whatever, and then to protect themselves or someone else from an attack or threat of attack.
When you train police officers, including security officers, do you have a standard of performance that you are trying to achieve?
Yes, sir.
What is that standard?
The objectively reasonable officer.
Could you explain that to the jury?
To act in a situation or manner that is consistent with how an objectively reasonable officer would act given the circumstances that the officer is confronting.
Would the officer's experience and training factor into whether his actions were objectively reasonable?
Certainly.
Okay. And what is the standard based on?
It's on real life situations. The trainers look at the role of the security company and or police department. They see what they have to do. They then develop training to allow the officers to be able to handle that situation. And then they make sure the training is in line with company policy or agency policy, and finally that it is in line with the law, and that's actually where the name or the phrase objectively reasonable officer comes from. It comes from the law.
Okay. Is that how use of force is analyzed from the perspective of a reasonable officer?
Yes.
Are you familiar with a concept in police training called the force continuum?
Yes, sir.
Could you please explain to the ladies and gentlemen of the jury what that means?
It's called several different things. The force continuum, model force, real force, etc. What it is a way of teaching police officers and security officers how much force, if any, is reasonable to overcome specific threats. And it goes from all the way at the bottom of it in when the individual is cooperative, of course, and the force continuum would say there's no force necessary. Then as it steps up and the person is not cooperative or not compliant, then there are methods that the officers are taught to be able to use in order to gain compliance. Things like pepper spray, pressure point control, the joint manipulation. Then it extends all the way up as the person becomes more threatening or aggressive to, in the end, finally, when it would be permissible to usually force to stop a threat. So the force continuum is a model that teaches security officers and police officers how to respond and when to respond to certain threats.
Do you know how police officers and private security personnel are trained regarding handcuffing subjects?
Yes, sir.
What is that training?
They're trained, and specifically Northland, the only time they can handcuff somebody is if they are, if there is an assault that's occurred. And that training, then with police officers from the standpoint of protecting their safety, the safety of the individual, and the safety of others, then they may handcuff. Excuse me. They're taught to handcuff them behind their backs, and finally they're taught to visually look to see that the handcuffs have a space between the strands. That's the steel things that hold the wrist, and that there's a space between the strands and the wrist sufficient to put a finger in. So those are the three main keys in handcuffing.
Okay. And you said typically for private security, assault is one reason that they are allowed to handcuff a subject. Is that right?
That's correct.
And was that the policy and procedure for the Northland Mall based on your review of their training manuals?
I'm sorry, I missed part of that.
I said, was that also the case for Northland Mall based on your review of the training manuals?
Yes, it was.
Okay. All right. And when we say assault, how do you define assault?
Assault is putting someone in fear that they're going to be injured. It turns into a battery if they actually attempt to or strike the individual, but essentially the definition of assault is putting someone in fear that they're out to be injured.
Okay. So, as far as you understand it, threatening somebody and putting them in fear is enough to commit an assault without ever touching the person. Is that accurate?
Objection, leading.
Okay, I'll rephrase it. In your opinion, to assault someone, is it necessary to even touch them at all?
No, as long as they have the capability to carry out the threat and they put the person in fear that they're going to be assaulted, that is the assault construct.
Okay. How do officers and security personnel determine if there's a threat or potential threat to their safety or the safety of others?
From their observations of the actions of an individual, from information that they obtain from a reliable source, that the individual has done something that is threatening.
Right. What would you consider, or what is the definition of a reliable source?
It's a person known to the officer who has provided information in the past, and or a person who is known to the officer that the officer may deal with on a daily basis, and that the person would be available should it be necessary to provide a statement and or testimony depending on how the situation is resolved.
Okay. In your experience and your training, would the owner of a store within a mall be someone that security officers in that mall should consider to be a reliable source?
Absolutely.
Okay. Sir, what are the reasons for cuffing a person behind his back and ensuring, I think you said, a finger's width between the cuff and the wrist?
The reason for cuffing behind his back is because it's safer for the officer and it's safer for the individual. The reason for making sure that there's that finger's width between the strength hands and the wrist is so that the handcuffs are not applied so tightly that they cut into, handcuffs are steel, that they cut into the wrist.
So leaving some width between the handcuff and the wrist is for the safety and comfort of the person being handcuffed. Is that what you're saying?
Correct. Yes.
Okay. In all of the training manuals that you have reviewed and written, are you aware of any that say to handcuff a subject to the front and not the back?
No, there's the only time that is ever permitted is if there is a lock mechanism, keeps the hands from being able to move. In other words, there'll be a belt around it where the handcuff, and the reason is because the handcuffs are a deadly weapon. They can be used to crush the bones, choke. Cops have been killed with people that have gotten their handcuffs in front. So every police department, every security agency trains them to handcuff on the back for those reasons.
Okay. Are police officers and private security personnel trained to take people to the ground?
Yes.
According to police training, when can officers and private security personnel take someone to the ground?
When, for their safety and the safety of the individual, they have an individual who's actively resisting their attempts to control them, it's safer for the individual and safer for the officer to take them to the ground.
Why is that?
Because when the person is upright, then all of they're called personal weapons are available. Personal weapons are hands, feet, elbows, forehead. And or reaching for a weapon, if a weapon it could be involved. That's all much easier to do when the person is upright. Plus, they can move. Once they're taken to the ground, that all diminishes greatly. The strikes cannot hit with as much force. The kicks won't have much force. The ability to reach for a weapon is reduced. So it's safer for the individual because if he is less capable of assaulting or increasing his assault against the officer, then there's less force used in order to control it, and in order to control it. It's safer for the officer because it's easier to control. So taking him to the ground is safer for the officer and the individual.
Is it fair to say, in your experience, that sometimes whether a subject ends up on the ground depends on his own actions and whether he's resisting and struggling with officers?
That's frequently the case.
So are you saying that sometimes it is not even a conscious decision being made by the officer to take him to the ground, but rather simply a result of the subject's actions?
Objection, leading.
I could rephrase it. All right. It's kind of a long one. It's taking a minute to think about it. On what different scenarios would it depend whether a individual being handcuffed is handcuffed while standing up or ends up on the ground for the handcuffs to be placed on him?
The only way that the handcuffs can be placed behind a standing individual is if the standing individual is cooperating. But he can move, twist, turn, kick. When he's on the ground, then it's easier to control him, putting him down on his face so that the hands can be brought behind his back. So if that answers your question, yes.
You mean, you said the goal is almost always to handcuff the individual behind the back. Is that right?
That's correct.
Right. Is it possible to do that on the ground if he's laying on his back?
No.
Does he?
It's not possible to be laying on his back.
Okay. So, are you saying the only way to accomplish that goal would be if he's face down? Is that what you're saying?
If he's face down or mostly face down, and I mean by that, he can be on the side toward his face, but all that really depends on the person being arrested. If they are confined and they're face down, then it becomes an easier task. However, if you've got to force them, and because they are constantly resisting, fighting back, then you're going to have to put them down as much on their face as possible in order to manipulate the arms, or you can get them to handcuff them behind their back.
And you said ideally, if they were cooperative, it would have been done with them standing up, and you wouldn't be on the ground anyway. Is that right?
They wouldn't be, if they were cooperative, they wouldn't be on the ground.
All right. Did you review some videos in this case? I think you said you did, right?
Yes, sir.
All right. When reviewing those videos, did you calculate how long Mr. Gavin King was involved in the effort to secure Mr. Cochran?
I did.
What was that time?
He arrived, Mr. King arrived 2 minutes and 36 seconds after Mr. Soderling and Chapin had pepper sprayed and taken Mr. Cochran to the ground. The effort to control and handcuff Mr. Cochran took an additional 7 minutes and 9 seconds.
Okay.
So the amount of time that Mr. King was involved in this was 7 minutes and 9 seconds.
Okay. I know you said just now that when Mr. Seiberling and Sergeant Chafin pepper sprayed Mr. Cochran and took him to the ground, did you see two individuals pepper spray him or just one, if you recall?
No, I was talking about the two people that were arrested. when he was pepper sprayed, it was shaken that pepper sprayed.
Okay, I just wanted to be clear. So you said that Mr. King was present for a total of about 7 minutes and 9 seconds.
That's correct, until the final cuff was put on Mr. Cochran at the 7 minutes and 9 seconds.
Would it normally take that long to handcuff an individual if he's compliant?
No, if he's compliant, it takes about 30 seconds.
All right.
If that.
Would it take more than one security officer to handcuff an individual who is compliant?
No, one officer can, if the person is compliant, one officer can handcuff him easily.
Okay. Now you said you, in addition to reviewing the videos, you reviewed all of the material that was provided to you back in 2014, and you reviewed it again now. Can you tell the jury what actions you determined my client, Mr. King, took in those 7 minutes and 9 seconds?
Your Honor, I'm going to object. It's either going to be from the video, which speaks for itself, or by hearsay.
Well, Judge, he has given an expert opinion. I think the materials he relied on to form that opinion are admissible.
Well,
He can give that opinion.
Sorry. It goes out the scope of what the judge limited his testimony to be, which is training.
I don't think it was limited specifically to just training. I think it was the defensive skills. I think I wrote it down.
Yeah, the training of those things.
It was also defensive skills, police training, including private security, and use of force. And so the question of what actions he saw Mr. King taking, I think is relevant to the opinion he's forming, and explains why it is he forms the opinion that he does. He's got to explain what it is he saw that led him to say one way or the other.
That's not the question that was asked. He was asked to describe what he saw or what he learned from the materials, which is either going to be hearsay or describing a video that speaks for itself.
I mean, I really don't care to keep going back and forth, Judge. I think our positions are both pretty clear at this point. I think he's giving an expert opinion, and this falls within the scope of what he should be allowed to testify to.
Well, you can ask him based upon what he saw. What was his opinion of Mr. King's conduct?
Very well. Mr. Key, without explaining, I guess, to the jury why it is you reached the conclusion that you did, could you tell us what that conclusion was regarding Mr. King's actions on that day?
Mr. King only tried to manipulate the arm to get it out so it could be handcuffed.
Do you find that to be a reasonable or unreasonable use of force?
I'm going to object. That does not fall within the scope of what the court allows you to ask this expert.
Judge, you told me I could ask his opinion. And so I simply asked.
His opinion, overruled.
Thank you. Was that use of force exercised by Mr. King reasonable or unreasonable?
Reasonable.
Did you ever I'll strike that question because comply with your ruling, Judge. As a expert in use of force, in your opinion, did Mr. King ever use any force that would be considered lethal force in any of the police training you're familiar with across the country?
He did not.
According to police training, what is the definition of lethal force?
Lethal force is an act which the officer knows or reasonably should know can cause serious injury or death.
And so just to be clear, you are saying that you do not believe Mr. King used any amount of force or took any action that would be considered lethal force in any police trainings you're familiar with across the country?
Objection, leading.
I think I just kind of rephrased what he just said, Judge. I can ask it open-ended. In all of the police training materials that you've written, that you've read for police departments and security agencies, private security agencies across this country, did you find that Mr. King took even one act that would qualify as lethal force in any of those books?
He did not. The only thing he did is reach for Mr. Cochran's arm to handcuff him.
And would reaching for an arm to handcuff be considered lethal force anywhere that you're familiar with?
No, it would not.
Do you know whether any force had been used against Mr. Cochran before Mr. King even arrived?
Yes, sir. Mr. Cochran was pepper sprayed and taken to the ground after he refused the commands to stop approaching. And
I'm going to object. There's a lack of foundation.
As he was approaching, the breathing hard.
Mr. Key, please, just what? Lack of foundation?
What? There's a lack of foundation as to where he's getting this information from, if he's relying on hearsay or if he has personal knowledge, which I don't think he does, but he's reciting information, facts about what happened, and I believe it's hearsay, honestly.
Okay, but he viewed the videos. So,
but he's talking about things that Mackenzie Cochran refused to do, and that's based on, some of it, I believe, may be based on witness statements that he also read in conjunction with the video. That's why I'm saying there's a lack of foundation.
Judge, when experts reach an opinion, they review all of the material.
Understood.
Whether it's admissible in court or not, they rely on all the information to be able to give an accurate opinion. And that doesn't mean that now their opinion is somehow objectionable or inadmissible in court.
I'm not objecting to his opinion. I'm objecting to the narrative where he's describing things that he read and saw. I'm not objecting to his opinion. He can give his opinion.
Judge, he can't give his opinion in a vacuum. He's got to explain to the jury why it is he reaches that opinion. Otherwise, he'd sound ridiculous. Because they wouldn't have any idea how he reached the conclusion.
I understand that, but he can testify based upon what he saw in the videos. Those are in evidence. Okay? And if that's what he used to base his opinion on, that's fine. But there was no audio, so he can't testify as to what he assumed was said at any point in time. So let's just
Fair enough.
clear.
Fair enough.
Okay.
All right.
Thank you.
Mr. Key, did you understand the ruling by Judge Anderson?
I did.
Okay.
I did.
All right. So we're clear and there's no issues. I'm going to try to re-explain it to you as best as I can, okay? And I'm sure Judge Anderson will correct me if I'm restating it wrong. I understand you reviewed a ton of material, correct?
Correct.
All right. And some of that material was admitted as evidence here in court, and that would be the videos that you reviewed, as well as the training manuals, right?
I don't know what it is,
Okay.
but
All right.
I'm assuming you're telling me.
I'm going to list them for you. The videos, there was the training manuals, but it would not include any audio or written statements from individuals. Is that fair?
That is fair.
All right. So if you could limit the answers to being based on what I just stated, video without audio, and training manuals. Yeah, I mean, just don't describe anything other than what was on the video without audio, because it's already an exhibit in evidence, as well as the training manuals, because those are also exhibits in evidence. Am I correct, Judge Anderson? Not asking, I'm asking. So, Judge, is that correct?
Pretty much.
All right.
Yes. So let's see where that takes us, and if there's an issue, I will let you know.
Thank you, Judge.
Thank you. Go ahead, Mr. King.
All right.
Do you understand the question?
I like to hear the question again.
Yes, I forgot where I left off. Just 1 second, Judge. I'm sorry. You said, we're talking about before Gavin King arrived, if you had observed any use of force being conducted on Mackenzie Cochran. Do you remember any amount of force being used on him before Gavin King even arrives on the scene?
Yes. As he was approaching, in the video, as he was approaching Mr. Cyberly, Mr. Chapin, then you could see the pepper spray, Chapin bringing the pepper spray up, and he was then pepper sprayed. You see him bent over, and then he's taken to the ground.
Do you see any body language from Sergeant Chafin? Not audio, but do you see any body language, any gestures with his hands?
I don't recall. I mean, I saw the pepper spray come up, which is body language. By bringing it up and showing it, it's a threat to use it. But other than that, I don't recall.
Okay. Now, given the information that you have, do you have an opinion to a reasonable degree of professional certainty in your fields of expertise as to whether the actions of Mr. King were consistent with accepted standards of police practices, policies, and training, including that for private security officers?
I do.
What is that opinion?
They were.
They were what?
They were consistent with accepted standards of police training. They were reasonable under the circumstances.
All right. In order to make
that they were confronted.
Okay. In order to make the bases of that opinion clear to the jury without getting into all the material that been reviewed. I'm going to present you with a hypothetical scenario, if that's all right. And then if I could just ask you to give me an opinion on each of those scenarios. Is that fair?
Yes, sir.
All right. A store owner in a mall calls for security and indicates that he needs assistance, that a person at his counter is making him nervous, and reported that he heard the person say, "I want to kill someone." That the subject is wearing a large jacket. The store owner cannot see what's inside of it or what he has in his pockets. And the store owner says, "I will shoot him if security doesn't get here to help me." What is your opinion regarding that hypothetical?
Very dangerous circumstance coming from a reliable source, and given the number of all shootings that have occurred, both before and since then, it is something that security is going to have to act on promptly, quickly. You've got a threat being there. The store owner's comment that he would shoot him. So for the protection of the individual and the protection of other people, security is going to have to act and respond immediately.
Okay. Now, if I add to this hypothetical that the individual that security officers find when they respond is over 6 feet tall and over 200 pounds, and he's standing at the counter, looks at him, starts breathing very hard, would those facts be material to your opinion?
Yes, sir. A person that large can cause severe damage with or without a weapon. The information that there could have been a weapon there, or there was a weapon there that the store keeper had. So because of that, the security officers are going to have to take control of this individual for his safety and the safety of themselves and the safety of other people in the mall.
And when you say other people, would that mean employees and just customers, patrons of the mall?
Yes, patrons and employees.
As well as fellow security officers. Is that right?
Yes, sir. I said that.
Okay.
For security, other people in the mall and the subject himself.
Okay. What, if any, is the significance to your analysis that he was breathing hard?
Given the information that they had from your hypothetical that said that he was going to kill someone, that would be interpreted as being an aggressive, very aggressive and angry response.
How about if he had his fists clenched? Would that affect you?
That is good. You've got somebody breathing hard with fists clenched would be reasonably perceived as setting up and beginning an attack, particularly based off of the information where he said he was going to kill someone.
Do officers need to wait until they are struck, punched, before they can take action to defend themselves?
No, sir. If they had to wait, then the likelihood is they wouldn't be able to take action to defend themselves or someone else. They had to act based on their observations, based on their knowledge.
You said
prior to the person drawing the gun, prior to the guy assaulting them.
Okay. You said you've been qualified as an expert also in general defensive skills. Is that right?
Yes, sir.
All right. Would even a normal citizen, not a police officer or private security officer, but just a normal, everyday person walking down the street, let's say a lawyer like me, would he have to wait until such an individual strikes him before he's able to take any action to defend himself?
No, sir.
All right. And
No, sir, for the same reason. If quick, until you're struck, you may not be able to respond at all.
now, would any of these facts that I gave you in this hypothetical of the individual breathing heavy and having said he wants to kill someone and staring and clenching his fists, couldn't that possibly indicate that he could have mental health issues?
Well, it could. The real concern is not just breathing heavy by itself and clenched fist. Is not by itself indicative of a person that has mental issues. It goes along with the information that they had, but the other part of that is even if it did indicate some sort of mental issue, then they still are duty bound to get him under control for his safety and theirs before they can deal with his medical problems.
Okay. If someone is shot at a mall, do you think his family's going to care whether the shooter had mental health issues or not?
Objection, Your Honor. Relevance.
I can rephrase it in a more accurate way to his opinion, Judge. In the scenario that I provided to you, would it matter at all to your analysis of whether it is reasonable to use force, whether that individual is suffering from mental health issues or not?
No, it would not.
Why not?
Their first responsibility is to secure the person for his safety and theirs and the patrons and the stores.
Okay. Now, as part of your job in your training of police officers across the country, you look at events that take place, current events, mass shootings, stabbings. Do you keep up with these things?
Yes, sir. I have both been hired to do so as a consultant, and I've also been approached many times by various news media to comment on them.
Okay. And would it be fair to say that sometimes these sorts of things are committed by someone with mental health issues? Is that fair?
You broke up a little. I'm sorry.
I said, let me get closer to the microphone for you. Would it be fair to say that sometimes mass shootings, stabbings, or other incidents of violence in public places are committed by individuals with mental health issues?
Objection, Your Honor.
That has occurred,
Relevance.
yes.
It goes to the hypothetical that I'm getting at, Judge. If the whole thing they've been arguing is, well, this is somebody with mental health issues, and the opinion that he's giving is that when they do their analysis of whether the use of force is reasonable, it does not make a difference beforehand, before the individual is under control, whether he has mental health issues or not.
That was not the question. I'm sorry. I'm sorry. I thought you were done. My apologies.
No, go ahead. What's that?
Yeah, that was not the question that was asked. And one, we haven't argued anything because we're still in the evidence presenting process. But whether or not mass shootings across the country occur with someone with or without mental health issues is not relevant and goes outside the scope of what this witness's expertise is supposed to be.
No, it does not, Judge. His expertise is whether, the question I'm asking regarding his expertise are whether the use of force is justified or not. And so the question specifically is whether an individual's mental health status, known or unknown, affects the conclusion that he would reach on whether or not the use of force is reasonable.
That's not the question that I objected to.
It's not. I'll let you ask that question.
All right. Yes. That's what I was getting to in my head. Did you hear what we discussed? All right, I'll repeat it. All right, I'll repeat it. When analyzing whether use of force is reasonable, does it, if all other things are the same, individual said he wants to kill somebody, he is breathing heavy, his fists are clenched, comes towards someone when told not to multiple times, should officers stop and try to assess his mental health situation before trying to protect themselves?
They absolutely cannot. No, they should not.
Okay. Would it be reasonable to try to do so, in your opinion?
It would not be reasonable. Their responsibility is to ensure that the man is controlled, that he cannot get to a gun, that he is not going to hurt somebody, given his size, that's possible, that he may have some other weapon. All of that has got to be determined before they start trying to talk or think about his medical condition.
Okay. What about the individual's safety?
It's a concern. I mean, if all of this worked the way we love it to work, then nobody gets hurt. And they've got a responsibility to try to ensure his safety. But the best way to do that, given the circumstances, given the knowledge they had, the best way to do that is to get him under control as quickly as possible.
Now, in the scenario that I gave you, nobody had told the security officers that the man had a gun or any other weapon. What impact does that have on your analysis?
It doesn't, because the information that they got was that the store owner was concerned that he did, although he didn't see it. And the other part of that is the store owner had a gun. With an individual who is resisting aggressively, if the person gets away, then he's got access to other weapons, and we know that there is a gun close by because the store owner said he was going to shoot him.
Should officers wait to see whether or not the individual has a weapon before taking action?
They can't. If they have to wait to see the weapon, by the time they see it, somebody is going to be dead.
In this hypothetical, would it be significant if officers asked the individual to take his hands out of his pocket? What significance, if any, would that have to your analysis of their use of force?
The significance is that frequently the weapons are in the front and or pockets of an individual, particularly when they have a large kudo. So asking him to take their hands out is a de-escalation technique, because by taking his hands out, it doesn't completely remove the threat, but it reduces the person's ability to obtain a weapon if he had a weapon. So it's a de-escalation technique in two ways. One, it lessens the potential of the individual being able to reach quickly for a weapon. And two, it also engages him by telling him to do something, and if he does it, then they're communicating, which is de-escalation.
Okay. What what is the definition of de-escalation?
De-escalation is any action or word taken by an officer to reduce the likelihood that you use more force. It's also using lesser force or threatening lesser force when more force would be reasonably necessary.
Now remember my caution to you earlier about only or answering the question but not telling us about materials you may have reviewed outside of the videos without audio and the training manuals. Were you able to tell whether or not the security officers in this incident took some or engaged in some de-escalation tactics? If you could tell.
Strictly from viewing the videos, because I didn't, well, the phone videos, I don't know if they're in, the phone videos,
they are.
Sound, because I heard the handcuffs clicking. But from viewing the videos, the fact that they kept trying to get in his hands to handcuff him, the way that they were trying to control him on the ground, considering the threat that they had, which was he's potentially armed and he's going to kill someone, using those tactics is a de-escalation because this guy presented a serious threat from the information they had. So, yes, it's de-escalation because all they're trying to do is handcuff him. They don't use any other force other than the initial pepper spray.
And so, in your opinion, would they have been justified in using even more force than you observed being used in this case?
Yes, sir.
If the individual, after this de-escalation tactic of asking him to take his hands out of his pockets, he complies, but then begins walking toward the officers, breathing hard with his fists clenched down at his side, how does that affect your conclusion?
That would be perceived by any reasonably trained security personnel or officer as a threat of assault. It would be considered an assault, an aggressive action, and it would also support the information they had from the store owner that this guy said that he was going to kill someone.
Now, if security instructs this man to stop, asks him to walk toward the exit, and points pepper spray at him without actually administering it, and again tells him to stop, would those facts be germane to your opinion?
Yes, they're again de-escalation. The threat of using a force like showing the pepper spray is de-escalation. Communicating with him is an attempt to de-escalate. By getting him involved in talking, then it changes, or that's what it's designed to do. It changes the dynamic, or it's an attempt to change. In this case, it did not.
Now, if at some point pepper spray is administered and the individual, still with his fists clenched, bends over and then unclenches his fist just to grab his face, does that affect your opinion on whether force could be used while he's attempting to wipe his face from the pepper spray?
At that point, the pepper spray has done what it's supposed to do, which is distract. And at that point, because of the previous actions and the information, taking him to the ground was the safest thing for him and the safest thing for the security personnel.
Okay. And why is that?
As I said, it's safer with him on the ground because he can't strike effectively. It's harder for him to reach for a weapon. That's why they will put him on his stomach. In order to be able to handcuff him, they've got to do that. But also, weapons are most frequently kept in, well, different cultures call it different things. It's called a dip. That is in the front of the pants where a gun is stuck down. But when they have a coat, that also could be in the pockets. So by putting him on his face, it allows him to get the handcuffs on more quickly, more easily, and it also restricts his ability to reach for a weapon.
Okay. And so you said that using pepper spray in this situation would be justified as reasonable in your opinion?
Absolutely.
Okay.
Pepper spray is at the low end of the force continuum. It's at the same level as joint manipulation.
Okay.
It's a compliance tool.
And once administering the pepper spray, in your experience, do subjects become more or less combative with officers after they've been pepper sprayed?
It actually, there been studies about that, and I participated in it. Pepper spray can really tick some people off, and some people become compliant, other people become combative. The reaction to it depends on the individual.
Okay. If the individual is somebody who's unknown to the security officers, in your experience and the way you train police officers, including private security personnel, do you train them to just leave the man alone after administering pepper spray, or to then proceed to handcuff that individual and get him under control?
No, the pepper spray, if the pepper spray does not make him immediately compliant, then they're taught to gain control. Gain control on an aggressive individual means also taking him to the ground.
Okay. So I submit to you that Mr. King add this information about the store owner's concern and arrive 2 minutes, the store owner's concern about the man threatening to kill somebody, and that he arrives 2 minutes and 36 seconds after the person was pepper sprayed and taken to the ground. And he observes security personnel attempting to handcuff the person. Would you consider Mr. King's reaction of attempting to bring the individual's arm behind his back in order to be handcuffed a reasonable thing to do?
Your Honor, I believe that's been asked and answered.
We have asked him, he has answered.
In your opinion, if a security officer comes upon another security officer who is on the ground struggling to restrain an individual, what do you train students or officers in your training sessions to do?
They're to assist. That's what their job is.
Okay.
The more people you have, it's incorrect that some people think that having 3 or 4 officers is somehow wrong. The more officers you have, the better chance you have of controlling. The more quickly it can be controlled, and the less chance you have of injuring the individual with multiple officers. particularly when you've got somebody that's very strong.
And so, are you saying that as long as officers are struggling, any available officer should assist? Is that a fair statement?
Yes, sir. Yes, sir.
In your opinion, should officers be concerned with keeping it a fair fight one-on-one?
No, they're not fights. They're attempts to control, and in fact, the reason they're not fights one-on-one is because the officer's response is structured. The officer can respond in certain ways. That's the way the force continuum is designed. The guy they're dealing with can do whatever he wants. Kick, gouge, bite, hit with a hammer. But in their case, they've got to structure it. That's the way they're trained.
Now, if the individual is resisting the attempts to handcuff him and says several times that he can't breathe, does that affect your opinion?
It doesn't affect my overall opinion, and it's the saying I can't breathe. It brings up a couple of things, and that is one: if he's talking, it means he's breathing. He may not be breathing well, but he is breathing because you can't talk without breathing air. The second part of that is, as you've described him as resisting aggressively, that also cannot be done unless he, in taking an oxygen, because the harder you resist, the less oxygen your body has, carbon dioxide builds up, and you can't resist. So as long as you're resisting and he's talking, then his breathing is at least sufficient until they gain control and address his medical problems, if any.
Now, I'm wrapping up. I don't want to put everybody to sleep here, but it's very important. After finally handcuffing this individual, they used 2 sets of handcuffs and turned him on his side against a pillar. What is your opinion of those actions?
The appropriate technique for allowing someone to breathe that you've been struggling with is to turn on the side. Making it back against the pillar, depending on how his chest was positioned, is also an attempt to allow him to breathe.
How about giving him water?
And giving him water is, that's, if you're talking about spraying it on his face.
No, giving him water to drink. Giving him a cup of water to drink.
You broke up.
I still don't hear you.
I said giving him water to drink, not, I'm sorry if it cut up, not spraying it in his face. Giving him a cup of water to drink. What do you think of officers doing that after they have him under control?
If they do that, they've done that, and he's able to drink it, then that's perfectly fine.
Okay.
They're trying to do something to make him more comfortable.
And Mr. Key, in your opinion, in your background, when a sergeant is on the scene, as well as other just low-level or entry-level officers, who is in charge?
Sergeant is.
Right. What do you train officers to do with respect to any commands or orders that may be issued by their sergeant?
As long as they're legal, they're to follow them.
Okay. Would instructing subordinate officers to grab someone's arm or place handcuffs on his arm be a lawful order in your opinion, or an unlawful order that they should disobey?
Given the circumstances we've discussed here, would certainly be lawful.
Okay. Mr. Key, have all your opinions been expressed with a reasonable degree of certainty in your fields of expertise?
Yes, sir.
All right. Back in 2014, did you author a 22-page report upon conclusion of your review of the materials provided to you by the Chief Assistant Oakland County Prosecutor?
I did.
All right. And that was dated August 20th of 2014. Northland Mall Security Incident Expert Report, addressed to Mr. Walton. Is that your report?
Yes, sir.
Your name at the top, Charles J. Key, Senior Consultant?
Yes.
Your Honor, I would move to admit Mr. Key's expert opinion that he prepared 22 pages back in 2014 upon request of the Chief Assistant Oakland County Prosecutor. Is there any objection? Yes, ma'am.
Is that
I got it from you.
Is that your exhibit? What exhibit?
That would be Defense Exhibit E.
That's would be the next letter I would be using. So is that what it is?
Yes.
Your Honor, I would have to object to the admission of this document. It contains hearsay with no hearsay exceptions. There are statements that would violate the people's right of confrontation. There are opinions in that document itself that would invade the province of the jury, and so the people would object to the admission of this document. The witness has been able to testify to his opinions without violating the hearsay, the people's right of confrontation, or the province of the jury, and I believe that's sufficient.
May I briefly respond, Judge? And I will keep it brief. The right of confrontation is a constitutional right, and I'm sure the court is aware the Constitution provides rights to its citizens, not to its government. So these defendants have a right of confrontation, but the government does not. And so that is not a proper basis to object to entry of this man's 22-page report conducted soon after the incident we're all here to decide.
With all due respect, Your Honor, pursuant to Crawford v. Washington and U.S. v. Davis, the people have a right of confrontation when you have testimonial statements within a document. I have a right to confront those witnesses who are not available, who are not here.
Thank you.
Thank you.
He has testified based upon the report that he did back then and a more current review of the information. So the court will not admit that document. Thank you.
Thank you, Judge. Mr. Key, thank you for your time. I hope your wife is getting better. I have no further questions for you.
Okay.
Thank you.
We're not done yet, Mr. Keys. We have more people to ask you questions.
Yes, ma'am.
All right, thank you.
Good morning, Mr. Key.
Good morning.
I'm Attorney Wright Blake, and I represent Aaron Marie. So I'm going to ask you a couple of questions regarding Mr. Marie. You've testified that you reviewed the video or videos pertaining to this case. Is that correct?
Yes, sir.
And you've testified to the initial interaction between the security officers and Mr. Cochran, correct?
Yes, sir.
And the initial interactions would have been Sergeant Chafin with the pepper spray and another individual, Mr. Sieberling, who was present subsequently after that, correct?
Correct.
Now, in your observation of the videos, did you ever see Mr. Marie pepper spray anyone?
He did not.
Did you see Mr. Marie take anyone down?
I don't recall whether he was involved in taking this Cochran to ground. So I don't recall that.
Would you agree with me that he was the last security guard to arrive to confront Mr. Cochran?
Objection leading.
Ask it as a question.
Sir, isn't it true that Mr. Marie was the last individual to arrive?
It is, and I'm sorry, Councilman, what I was doing is I was speaking with Siegerling, and you said you were representing Mr. Marie. Mr. Marie never took anybody to the ground. He was the last to arrive.
And did you see him?
If that answers your question.
Yes, sir. And what actions did you see him take, if any?
All I saw him do was attempt to assist in handcuffing.
So that would have been the manipulation of one of the arms?
That would be the manipulation of one of the arms along with perhaps Mr. King, but they were tugging on the arms and you really couldn't tell from the video exactly who had what arm.
Could you tell how, in terms of time, how long Mr. Marie's interaction with Mr. Cochran was?
It was shorter because he was the last to arrive, but I don't know the exact time.
You said you had some trouble discerning the individuals through the video because of the quality of it?
You broke up, sir. I didn't hear what you said.
Did you have trouble in your observations reviewing the video because of the quality of the video?
To a certain degree, but I watched them dozens of times to try to get everything out. The quality wasn't that great, but you could tell what they were trying to do, such as Mr. Marie trying to get his arm out so he could handcuff.
So, Mr. Key, did Mr. Marie, in your opinion, act in a reasonable and acceptable police standard or safety or security guard standard? Thank you, sir. Nothing further.
Braxton?
Good morning, Mr. Key. I am Attorney Keith Braxton for Mr. John Cyberling.
Good morning.
Just have a few questions for you. My first question, you were talking about force continuum model. Are there any particular elements or a checklist for the different levels that you had listed earlier? Like you were saying something about pepper spray in particular. You said there were use of no force, then you also said pepper spray. Are there any particular elements to those?
Elements as to when to use it?
Yeah, when to use pepper spray.
Certainly, that's the way the model is set up. The amount of force on the one side starts at the low end, and by the way, they don't have to go step by step, but it will tell you that under certain circumstances you can use this amount of force. Pepper spray is at the low end, along with pain compliance techniques. Pain compliance techniques are you have nerves that are close to the surface that the officers are taught to be able to squeeze or push that causes a minor pain. Joint manipulation is what they were doing in trying to remove his arms out. And it also can be used like in a hammer lock or something like that where you can apply pain like that. Pepper spray is down at that level, and what you use that for is when you have a non-compliant individual, even a passively non-compliant individual, then you can use those types of low-level pain compliance techniques, including pepper spray.
And so, going by what you just said, was Sergeant Chafin actions reasonable in pulling out the pepper spray?
Your Honor, I'm going to object to the form of the question. It does not comply with the court's order as to what this witness can opine.
He can opine as to whether or not the use of pepper spray was reasonable, but that's.
That's what I asked. If it was reasonable.
That's not the way I understood your question, but I will allow you to ask whether the sergeant's use of pepper spray was reasonable.
Was the sergeant's use of pepper spray reasonable?
Under these circumstances, absolutely.
Also, based on your information and your opinion, my client, his use of force was at the time at the scene. Can you give me your opinion on his use of force?
You broke up when you were telling me who your client was. So would you repeat that, please?
On Mr. Cyberling's use of force, could you give me your opinion on Mr. Cyberling's use of force?
His use of force was consistent with how they're trained. It was necessary to take an aggressive, assaultive individual to the ground. So, and then later to pin his legs down in order to keep him from being able to kick was also reasonable. Those are the two things that I recall that Mr. Cyberling did.
Actually, you answered 3 of my questions in a row. I have no further questions. Go ahead. Hypothetically, if the officers were not trained in passive techniques, how would that affect the situation?
Sorry, we're not trained in passive what?
Point techniques. How would that have affected the situation?
I'm sorry, I can't understand what what kind of technique.
If they were not trained in the pressure point techniques, how would that have affected the situation?
It makes it more difficult. Because the pressure point control techniques. I'll give you an example. Right back of the wrist, you've got when you've got an individual that won't give you his hands, you use your middle finger, press into that. Generally, that'll convince them. So if they didn't have that training, then it falls back more on simply having to grab, and it becomes an issue of strength. You can do the joint manipulation. I didn't see it specifically, but by using the arm as a fulcrum and you press against the point of the elbow, you can also get the arm out. So if they didn't have the training, then it really just becomes a test of will and strength.
Thank you.
Ladies and gentlemen, would you like a brief recess before we have cross-examination by the Attorney General? Yes. Okay.
All rise for the jury.
I'll take about a 10-minute recess.
Thank you.
Thank you.
Your Honor, recalling People v. King, case number 2023-284-855-FH, calling People v. Marie, case number 2023-284-856-FH, and calling People v. Cyberwing, case number 2023-284-857-FH.
All right. Hopefully, is the jury out there?
They're lined up.
But they're lined up? All right. Let's put them in. Thank you, Deputy.
All rise for the jury.
You may be seated. And they proceed slowly.
Thank you. Mr. Key, can you hear me?
Yes, ma'am.
Okay, thank you. Now, you were asked several questions about the use of force continuum, and that use of force continuum applies to police officers, correct?
It applies to anybody that has a role that might have use of force, whether it's all that or not, because you have to teach whoever that person might be under what circumstances they can use what force. And so the force continuum is just a general rule, but it applies across the board. If somebody can use force, such as in handcuffing, then the force continuum would apply.
Okay. And when we're looking at a use of force, we're looking at the objectively reasonableness standard as far as what facts were known or maybe not known at the time, correct?
Yes, ma'am. Well, the facts that were known at the time.
Okay. And when a police officer uses force, they're doing that largely to protect themselves and protect citizens, correct?
Well, that and control, there are two elements, and we're all fully permitted to control the actions of individuals in certain cases. It's the way I use the example, if you're going to a football game or whatever, it says get back on the curb and don't do that, and they can push you back on the curb. That's the use of force. That's control. The other is to protect themselves or protect others. So those two factors are, and they're allowed to use force.
Okay. And even if you're allowed to use force in a circumstance to control an individual, you still have to keep in mind that individual's safety to the best of your ability, correct?
That's correct.
Okay. And I believe you stated on direct that you had received the Northland Mall security manual regarding handcuffing procedures?
I did.
Okay. And did you see the portion regarding positional asphyxia?
I did.
And is it part of your training that, when a person is handcuffed face down, that you have to move them from that position to prevent the possibility of positional asphyxia?
As soon as practicable, yes.
And that's because positional asphyxia could lead to injury or death of the handcuffed person, correct?
Well, for a period of time, I'm certain.
Okay. Now, I asked you earlier about Public Act 330, and you said you were not familiar with that, correct?
Correct.
Are you aware that in the state of Michigan there are some security guards that may have police authority and there are some that do not?
I'm aware of that. That's in every state. I just didn't know what it was called in Michigan.
And are you aware that the Northland Mall security officers did not have police authority in January of 2014?
I believe I'm aware of that.
Okay. And were you aware that there was actually a Southland Police office in the parking lot of Northland Mall?
You mean Southfield?
Southfield.
I wasn't aware it was in the parking lot. I was aware that they were, that there was a police agency close by.
Were you aware that the Northland security officers were under the directive that if there was an incident that may lead to their own harm of merchants, harm of citizens, or harm of other persons, that they were to call 911?
I want to object. In
I'm aware that
fact, that's completely untrue.
Mr. Keys, just a moment, please. I'm sorry.
That's completely untrue based on the training manuals that they admitted as exhibits. That's a mischaracterization of that evidence. We have testimony from Neil Webster as well that contradicts that.
If you don't see it happen, you can't take action. Collect the information, call the police.
Judge, that is referring to arresting individuals for shoplifting. There's no allegation that they're trying to arrest a shoplifter here.
This doesn't say shoplifting.
Counsel,
I'm sorry.
Is this from the training manual?
Yes. This is from, and I'll tell you specifically which exhibit. This is from Exhibit 45, page 2.
But again, it's mischaracterizing it because that is saying you cannot go and arrest a shoplifter, and that's not what they were trying to do here.
With all due respect, there's nothing on here that says shoplifter.
Judge, it talks about if you don't see it, you can't take action. They're not reacting, they're not taking action based on,
Thank you.
Thank you.
You're going to have to ask it differently or ask another question.
I will ask it differently. What's his name? Mr. Key, are you aware that the training manual that is marked as People's Exhibit 45 actually advises Northland Mall security officers that they are not police officers and they have no police authority?
No, I actually am not aware. I don't know that I read that. I wouldn't dispute that it might say that.
Okay.
I don't recall reading.
Okay, well, would you wouldn't disbelieve me if I told you it's on page 2 of the legal powers and limitations section, would you?
No, ma'am. I'm good.
Okay, and on that same page in that same section, it advises that public safety officers do not, in most states, have any more arrest authority than a private citizen. Were you aware of that?
I'm aware of that some security officers do not have the same authority to arrest as a police officer, and that would be stated that they're ordinary citizens and therefore have the authority to arrest under the auspices of being a citizen.
Okay, and are you aware that the manual that are given to Northland Mall security officers says, if you did not see the event take place, you must collect as much information as possible and contact the police. And it says it right
No, I
there.
understand it's there. I'm going to object to the way she's mischaracterizing it by cherry-picking different parts of this 1,000-page manual they're giving that don't apply to this scenario. It's talking about an investigation. It's talking about the arrest of somebody who has done something in the mall, like shoplifting, and that's a far cry from somebody threatening to kill people.
With all due respect, I have not left page 2 of this document, and I am reading in sequential order, and I read the sentence exactly as it is written.
I understand. You just don't know what comes before page 2 or anything else.
Page 1.
I understand that. What I'm saying is, if there's any other references before page 2 that would delineate.
Oh, it's part of the exhibit, but just for purposes of the record, page 1 is just identified as an introduction. It actually gets into, I would call it the meat and potatoes where I'm from. It's under the public safety heading on page 2, and it basically delineates what they can and cannot do as a Northland Mall security officer. And I am reading it exactly as it is written, and I'm leaving nothing out.
You can ask him questions about what's in the manual. If he's aware of it, he can answer it. If he's not aware of it, he can say he's not aware of it. Let's move on.
I believe that's what I did. Is that okay if I
Yeah,
re-ask
yes,
the question?
yes.
Thank you.
I didn't mean move on to another question. I meant, let's get back to questioning the witness.
Thank you. Mr. Key, do you remember the question, or do you need me to restate it?
I would appreciate you stating it.
Not a problem. Were you aware that in what is admitted as People's Exhibit 45 on page 2 of the Legal Powers and Limitations Manual given to Northland Mall security officers, that it states, if you did not see the event take place, you must collect as much information as possible and contact the police?
I recall reading something like that, yes.
Now, there's also sections in there that carve out circumstances where Northland Mall security officers are allowed to handcuff citizens within the mall. Were you aware of that?
Yes.
Okay, and did you read what has been marked and admitted as People's Exhibit 46, the handcuff procedures?
Yes.
And I'm going to read you from page 18 of Exhibit 46. And I'm asking you if you are aware that this was in the manual. Once you have placed handcuffs on someone, you have assumed the legal and moral responsibility for protecting them from harm. Were you aware that was in the manual?
Yes.
Isn't that just common sense?
Well, yes, I am, but you're training people. Common sense needs to be emphasized at some point.
And that's why they put it in writing, even though it should be common sense that when you handcuff someone, they have restricted mobility, right?
That's correct.
And that's why that same chapter, handcuffing, talks about positional asphyxiation, because it needs to be spelled out that sometimes someone face down might not be able to breathe like a normal person, correct?
Under certain circumstances, correct.
Okay. Now I'm going to ask you, you were asked several questions about the role of Gavin King, and you recall testifying that from what you observed, he just had Mackenzie Cochran's arm trying to cuff him?
Yes, ma'am.
Okay. While Gavin King had Mackenzie Cochran's, and I believe it was the left arm, correct me if I'm wrong, were other security guards also engaged with Mackenzie Cochran?
Engaged with him?
Well, also involved. Yeah.
Yes, the other security officers were also trying to gain control.
Okay. So it wasn't just Gavin King holding Mackenzie Cochran's arm. There was also Sergeant Chafin involved, Lucius Hamilton, Aaron Murray, and John Sieberling, correct?
Correct.
After Mr. Cochran is handcuffed, strike that. When it comes to police officers handcuffing a person, if that person is in some sort of medical distress, do you train them on attempting or performing any life-saving measures?
It depends on what the medical distress is. 1, 2, in most cases, the first thing they're supposed to do is call for medical assistance. Okay. Most police officers don't have advanced training in how to, depending again on what the injury is, be able to treat them.
Okay. Now, in this case, you had the benefit of a video. Before Southfield Fire gets there, do you see anyone in that video performing CPR or attempting CPR on Mackenzie Cochran?
Not in the videos that I watched, no.
Okay. And in the materials that you received, did you receive any information that John Sieberling, Aaron Murray, and Gavin King are all CPR certified?
I believe I saw Coach I believe I saw in Mr. King's deposition,
I'm gonna object as to what, that's hearsay.
the,
Wait, Mr. Key. All right, that deposition isn't part of this case.
Correct.
He's referring to a deposition, Mr. King.
Well, that was the question I asked. I just asked him if he was aware. I didn't ask him how he was aware. So I'll ask him to narrowly tailor his answer.
And I'd ask that be stricken because there was an express statement by the previous prosecutor, Mr. Orlando Patterson, that depositions would not be used in this case.
I did not elicit that.
I know, I understand. That's why I'm asking it to be stricken.
Yes, that will be stricken.
Yeah.
Just listen to the question, please, Mr. Key, and just answer the question as posed. Thank you.
Yeah. If possible, if you can answer yes or no without elaborating, that might help us get through this, if that's okay, Mr. Key. Okay?
I thought your question was as to whether they've been trained in CPR.
I asked if you were aware that they were trained.
He would only be aware by hearsay, Judge.
I am aware.
Okay, objection.
Just a second, please, Mr. King.
It'd be hearsay. How would he know?
Well, there's a certificate. I said, was he aware based on the documents, but. Based on the I'll rephrase. Based on the information that you received and reviewed regarding John Sieberling, Gavin King, and Aaron Murray, and the trainings that you provide, would after Mr. Mackenzie Cochran was handcuffed and unresponsive, would that have been an appropriate situation to attempt CPR?
Not with just those circumstances. You'd have to do an analysis first, an evaluation first. You have to make sure that, one, he is not breathing, two, his heart is not beating. So you can't start CPR because the person is unconscious. As long as they're breathing and their heart is beating, then CPR is not warranted.
So you said something that I really appreciate and resonates. You have to assess the situation before you act, correct?
That's correct.
And that's appropriate when you're assessing whether force should be used, as well as whether or not life-saving measures should be implemented. Is that correct?
You work with counselor. I didn't get part of that.
It would be appropriate to assess a situation before acting when involving either using force or whether or not to implement life-saving measures. You have to figure out what you have first, right?
That's exactly right.
Ms. Logan, if you could just, instead of combining two questions in one, could you just ask individual questions so that in case the answer would be different for one of the other scenarios?
I'll do my best.
Thank you.
I actually have no other questions.
Okay.
Thank you.
Just one moment. Mr. Key, you were told that the Southfield Police Department apparently found it necessary to have a branch of their police department in the parking lot right next to Northland Mall. Would that affect your determination of whether security officers present and closer to an individual who is threatening to kill somebody should do anything?
It does not affect my opinions that the security officers acted as promptly as they did, and it makes no difference that there was a police agency that close by, because the threat was immediate, the threat was severe, and even as citizens, they had a duty to overcome and control this individual.
So if I'm hearing that right, you're saying it doesn't even matter if they were security officers. If they were just shopping at the mall, you believe they would be justified in taking action based on the information that they had. Is that right?
Leading.
No, I rephrased what he just said, Judge. Maybe I clarified it in a leading way. But I'll rephrase it in a non-leading way. But it wasn't words. What is it you just said about the same would apply even if they were everyday citizens and not security officers?
With that kind of information, with the horrendous effects the mass shooting has, even as a citizen, they had a duty, if they had that information, to try to control that individual, hold them until police got there. You cannot wait, because waiting could get people killed.
Okay. Now, you were told to look at it, I don't know, one of the pages in this, like, 2,000 pages of manuals, page 2 on one section of these thousands of pages, taking chronological order, this is page, actually it's page 752. It might be page 2 of one section, but it's at the bottom, it says page 752, where it talks about they are not police. Remember being asked about that? Yeah, because that's page stamping the order of all the pages in the manual.
No.
Do you remember being asked that?
I'm sorry, I didn't hear you.
We didn't hear you.
Do you remember being asked about how at some point in the manual it tells them you are not police?
Yes.
Right? Would you expect to find that in every manual for private security?
There are different types of security, but most are not. They're not treated like, or they don't have the same authority as they don't have the same authority as a police officer would.
Okay. So, I mean, by definition, if they are private security, they are not public police officers. Correct?
That's correct.
All right. Now, would it surprise you that above that, in bold, on that same page, it says, with a box around it, your number one priority is your safety and the safety of the public? Would it surprise you to see that type of language in a private security manual?
It would not surprise me. I recall reading it in fact.
Would simply observing and reporting a man making a threat to kill people be consistent with the number one priority of their own safety and the safety of the public?
It would not be.
Okay. You were asked if it would be common sense to protect a person being handcuffed. You remember that?
Yes.
What's your answer to that?
I didn't hear you. What you
I said, what was your answer? Is it, in fact, common sense to protect someone who is handcuffed?
Well, the question was about training, but it's common sense, and my answer was that training sometimes has to use common sense. It is common sense that anybody that is handcuffed can't move. It is common sense that if they have some sort of medical, you better deal with it.
Did you observe one of the officers, I believe it was specifically Officer Seiberling,
checking pulse?
I did.
Would you consider that to be common sense?
I would consider it an effort to see, well, common sense way, but I would consider it an effort to determine Mr. Cochran's situation.
Okay. And depending on whether he feels a pulse or not, it may or may not be a good idea to give CPR. Would that be right?
No, if he feels a pulse, it would not be a good idea. So the answer is, if he feels the pulse, you would not administer CPR.
Okay. And if a instructor on CPR and first aid was there to observe and says they were doing everything exactly right and nothing wrong, would you, from looking at videos without audio, be in a position to contradict that?
Yeah, I'm going to object.
No.
One, it exceeds the scope of my cross.
It was based on her question of not giving CPR.
But I didn't ask anything about an instructor observing.
She's implying they were negligent by not giving CPR.
I'm just asking questions.
Right. And so the question was, if he's feeling pulse and a CPR and first aid instructor is there and says he's doing everything right and nothing wrong, is he, from looking at a silent video, able to contradict her?
Well, how is he supposed to answer that question without speculating?
I think the answer is obvious. That he's not in a position to contradict her.
So I don't know what the basis of the objection is. It's not based on any rule of evidence.
That's true. She just stood up and said she objected, but.
No, I said it was outside the
beyond
scope of my cross.
I'm sorry, I apologize. You did say that.
And I said it's not beyond the scope because she asked about performing CPR, and I asked him if he's in a position to say that the failure to perform CPR is necessarily a bad thing.
That wasn't your question. Your question was, if there was a CPR instructor there who said they did everything properly, is he in a position to discredit that? That was the question you asked, and that was the question I objected to.
I don't think that's anything wrong with that question, Judge.
It's still not outside the scope because you have no CPR.
But I really don't think it's an objectionable question. I think it's within the scope. She's talking about CPR, and I'm basing it on the question that she asked. I think it's right within the scope.
Overruled, let's move on.
Thank you.
Right? You can't necessarily say that there's some mistake made by not giving CPR. Is that right?
That's correct.
Right. And you were told that there was pulseless electrical activity. Do you remember that?
I'm going to object to that. This is outside the scope.
She asked him about it, and I said, do you remember her asking you about it?
I did not ask about PEA.
I thought she did, Judge. I mean, I wrote it right here.
Absolutely.
Yeah, I don't know where I would have got it from, but
No, she did not.
I thought she asked about it when she was talking about
She did not
CPR.
ask about
Okay.
PEA.
Okay.
Okay, so don't go there.
Okay,
That's
I understand.
beyond the scope.
Judge, if I may, it is related to the appropriateness of giving CPR or not. So it is related to whether she asked about that specific term, it is related to whether or not it's appropriate to give CPR. So that's within the scope of our questions. And I'm pretty much done anyway. That's my last question. But if you don't want me to ask it, then I am definitely done.
She did not inquire about PEA, so nothing go there.
Thank you.
All right, thank you.
No other questions, Judge.
No questions, Your Honor.
I just have one question. You were asked a question about calling the police for their arrest. In the manual, in handcuffs section, it states there are 3 situations that the officers may detain an individual. I don't know if you remember the manual. Can you remember the 3 situations in which the officers may detain?
The one that I recall that was specific to this was in the case of assault.
That's my,
That was the one. The other two, I did read it, but the one that was specific to the facts of this case was assault.
okay, thank you.
No requests. All right, thank you, Mr. Pease. We're all set. Have a good day.
Thank you, ma'am. Good day.
Councilors, would you report?
Thank you.
All right, ladies and gentlemen of the jury, the attorneys and I have some issues that we need to address out of your presence. So I am going to release you to go to lunch. I'm going to ask that you come back at at 1 o'clock. All right? Please do not discuss the case with anyone, even among yourselves.
All rise for the jury.
You may be seated. All right, then, counsels, are your clients going to be testifying?
Judge, on behalf of Mr. King, Mr. King, may I go to the client?
Yes. Would you please swear Mr. King in?
Yes. Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give before this court is the whole truth and nothing but the truth?
I do. Mr. King, we are at a point in our case where we have no other witnesses to call. And at this point, you have a right to testify in your own defense if you want to testify. Understand that, sir? Yes. And the judge obviously instruct the jury that they cannot hold it against you if you don't testify. And you've heard all the testimony. So now you have the right to take the stand and give your version of events if you choose to do so.
I would not like to do that.
Okay. Has anyone promised you or threatened in a way not to testify?
No.
Are you doing this freely and voluntarily, on free will?
Yes.
Thank you, Judge.
This is where Mr. Mahoney, please.
Do you solemnly swear or affirm, under the penalty of perjury, that the testimony you're about to give before this court is the whole truth and nothing but the truth?
Yes. Mr. Murray, could you state your name for the record?
Actually, no, that was not. We were on the
You're
same
right,
side.
sir.
Yeah. Mr. Martin, do you solemnly swear or affirm, under the penalty of perjury, that the testimony you're about to give before this court is the whole truth and nothing but the truth?
Yes. Mr. Murray, you understand that you have an absolute right to testify on your own behalf in this matter, is that correct? Yes, I do. And you've discussed this matter, the strategy with me as well? Yes. And have you elected to remain silent, exercise your right to remain silent? Yes. Has anyone threatened you, promised you anything? No. You've made this decision on your own volition, is that correct? Yes.
Mr. Sieberling, do you solemnly swear or affirm, under the penalty of perjury, that the testimony you're about to give before this court is the whole truth and nothing but the truth?
I do. Mr. Seiberling, we have discussed this situation. You know your rights, yet you have the right to testify, correct?
Correct.
We've discussed this previously, correct?
Correct.
You stated to me that you do not wish to testify.
That is correct.
No one has promised you anything and not to testify, correct?
Correct.
Your Honor, at this time, I would like to say that my client will not testify.
Does anyone threaten you or again not to testify?
No, Your Honor.
Thank you. All right. All right, let's deal with the jury instructions, please. You both have each side's instructions that were presented to the court.
Yes.
Yes, Your Honor.
I take it that there are, it's my understanding that all three defendants have agreed upon the jury instructions that were given to the court?
Yes, sir.
Yes, sir. Okay.
Yes, sir.
Thank you. All right, so I take it nobody has an issue with 3.01?
Correct.
Correct.
And 3.02?
No objection.
No objection.
No objection.
3.03?
No objection.
No objection.
No objection.
3.05?
No objection.
No objection.
Okay, the only issue that I found between the two that were given to me is that the Peoples has 9 sections and the defense has 7 sections. Although I believe that 9 sections is the correct one.
It is.
Yeah, let me see why we did that.
I don't know, but I can show you what you provided.
Oh, yeah, no, yeah, that was probably just a typo, all right, I'm sorry.
Okay,
Yeah,
that's fine.
All
I
nine
just-
apply, yes.
3.06?
Yes.
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 3.07?
Yes.
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 3.10?
Yes.
Yes.
3.11?
Yes.
Yes.
All right, the defense has 3.13, which is the penalty instruction. The Peoples does not.
Oh, that's an omission. Yeah, we should have penalty.
Can you
Yeah,
just
I
scan
know.
it?
That's why I'm just making sure that you understand. I went through these and you can see my little quick books here that,
No.
uh, 3.14.
Yes.
Yes.
3.15.
Yes.
Yes.
3.16.
Yes.
Yes. I think we left the brackets, Judge, because we weren't sure if the court gives them electronic or paper.
And I give them a paper copy. So.
I just take out the brackets now.
3.18.
Yes.
Yes.
And once again, the people didn't have this, but 3.23 about the verdict form.
Yes.
Yes.
Right. And the people had 4.01 defendant's statements as evidence against the defendant.
Yeah,
I don't
no.
believe there were any
Right.
statements.
Right.
Correct.
No.
Okay. 4.03.
Yes.
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 4.05.
Yes.
Yes.
The people have, okay, I guess I should start. The defense has 4.06 judicial notice.
No.
Yes.
I thought you took judicial notice when Dr. Dragovich said he was called by Assistant Attorney General Rodney Patterson to judicial notice that he was one of the attorneys of record on this case.
No, I objected to that.
But I think he took it.
Yes, we did.
It's true.
Well, I know that to be true, yes, and he has appeared before me on this case, so I believe I did. So I am going to give that instruction.
Thank you, Judge.
4.07.
Yes.
Yes.
What did we stipulate to?
I thought we did, but I think we just sometimes didn't object to each other, but I don't know if that's a stipulation. I don't know.
Okay, what are we talking about?
Just the lawyer stipulated something.
4.7, Judge.
Were there any stipulations? I don't remember
No,
any stipulations, but
I'm indifferent.
they're your jury instructions that you wish to give me to give, so
No, there were no stipulations.
I didn't think so, but.
No problem. Might be my first trial without stipulation.
Okay, the defense has 4.16 intent.
No.
Which one is that, Judge?
Intent.
416, 4.16.
I guess they object. We don't see why or what the basis is of an objection. It's just standard instruction that it's probably been given just about every case I've ever done.
It's been in every criminal case I've had also, but I'd like to hear what your objection is with respect to that.
Well, Your Honor, I think the basis of our objection is that the defendants are charged with involuntary manslaughter as general intent. Your Honor, one of the issues for the trial fact is whether or not there was gross negligence. Your Honor, this speaks to their specific intent. It's a general intent crime. That's not. This is involuntary manslaughter.
I just don't know of anything that says it's limited to crimes where specific intent is an element. There's certainly nothing to indicate that it's specifically excluded from involuntary manslaughter cases either. So it just says, the note says, the instruction may be used when requested or deemed helpful by the court. We're all three of us requesting it.
Okay. All right, the court's going to give 4.16.
Thank you.
All right. 5.02.
Yes.
Yes, Judge.
Okay, 5.10, which is expert witnesses.
Yes.
Yes.
But I'm going to, yours, the people's only has Dr. Carl Schmidt, and since we have had other, I will be using the one by the defense that has all three.
Understood.
Thank you, Your Honor.
5.11, police witnesses.
Yes.
Yes, Your Honor.
And the defense has testimony provided, 5.16, which is testimony provided through video conferencing technology. I think that's appropriate based on Mr. Key's
Yes.
I did submit later 5.12. I don't know if you want to do it at the end or.
Okay, I see that. Okay. 5.12 about Matthew Clark.
We would be objecting to that.
I beg your pardon?
We would be objecting to that, Your Honor.
Matthew Clark.
Who's Matthew Clark?
He's an endorsed witness on the prosecutor's witness list. I think we all, in good faith, relied on that X being placed on their list, that he would be here. And in fact, at the beginning of the trial, they introduced a cell phone video recorded by him as an exhibit. And we didn't object. We thought he's going to appear anyway because he's listed on their witness list, endorsed. And
Wait. What cell phone video? The one that the witness in the box testified to?
No, there are
The
two
other.
cell phone videos.
I think it was authenticated by Mr. Monk. And the way they got it was that, well, he was sitting on the opposite side and he could say it was a fair and accurate depiction even though he didn't record it himself. We didn't really care because we thought it's going to come in at some point through Mr. Clark anyway. And now they don't call Mr. Clark. And there was some commentary on that video by Mr. Clark that is very favorable to the defense. But the audio was kept out at that point because we said it's hearsay, right? It's commentary. Unless you produce the witnesses, was the words from the court. And what Matthew Clark says on there is, well, why won't he just stop resisting? And so I can't think of anything more favorable than a direct eyewitness saying, I don't know why he won't just stop resisting. Especially since we've introduced his recording.
Well, Your Honor, it was the defense that actually objected to the audio being played at the time it was being published. The people intended to play that exhibit with all of the audio as it was intended. But as it relates to what we're here for right now, Matthew Clark, yes, he was endorsed on the people's witness list. Efforts were made to serve and Mr. Matthew Clark, and when it was apparent that he was avoiding service, we actually petitioned and received a witness detainer from this court, which was e-filed to all parties, so defense counsels were on notice that Matthew Clark...
But that order was for him to be picked up and be produced to testify. Did you send a state police officer to pick him up and detain him until he could testify?
We sent, our special agent took the warrant. It was entered into the lien. Southfield Police was actually requested to go get him because it's my understanding he lives in Southfield. He cannot be found.
Judge.
So he is making himself absent. But all efforts were made to locate and serve him and produce him for this trial, up and until attempting to get a detainer and arrest him to bring him.
So one of two things. Either the video will stay in evidence, but the audio will be played. We'll play it to the jury. Or I give this instruction.
Judge.
We never had a problem with audio.
Because there is audio from another individual who is unidentified, and that part is what's commentary. But since we know what Matthew Clark is saying, and we know who he is, that is different than the subsequent commentary from an unknown female. And Judge, I would point out that we were never told anything about difficulties with Mr. Clark. You know, there was, I think they filed motions to bring out-of-state witnesses and things like that too, and we just assumed, okay, they're going to bring these witnesses. I think it was Wednesday afternoon, we asked Ms. Logan, you know, who she has left, and she mentioned who she had left, which I think was just Dr. Schmidt, and we said, well, wait a minute, what about Matthew Clark? And so we can't find him. So that's when we learned about it, was Wednesday afternoon about 4:30 after court wrapped up.
Yeah,
And Judge, if I may, Your Honor, there are other mechanisms other than calling Southfield Police Department to go pick up with the Southfield judge. Judge, you're a seasoned jurist, and I can tell you that you've seen them use the U.S. Marshals. You've seen them use cell phone towers, cell phone pings, cell phone technology. Locate someone within a few minutes, Judge. So they did not exercise all reasonable efforts to locate this witness.
Yeah, first and foremost, as this court requires, the petition was e-filed, and all people attached to that e-filing get notices. So the petition for the detainer.
I know, but I gave you the detainer.
Well, no, I was addressing that Mr. Kuja said he did not have notice that Matthew Clark was.
That puts him on notice that he's being difficult.
Exactly.
Be a cooperating witness.
Exactly.
That doesn't put him on notice that he's not going to be present for testimony. Okay.
That's fair. And as it relates to the U.S. Marshals, I don't believe we can use the U.S. Marshals in state.
Well, how about the Michigan State Police? You are the Attorney General's office.
Well, we can also use Southfield Police.
You could, but when that was unsuccessful, then, I mean, you just don't try once. You keep trying until you locate the witness. All right, enough. You've placed your arguments on the record. I will give this instruction.
Thank you. So is Exhibit 17 without audio? Because that was going to be a question I had for the court.
Yes, that will be continued without audio.
Is it 100% without audio? Because a portion was played to the jury that actually was audio involving the incident.
And I think that's when they objected,
Yes.
and I said no audio.
Right.
So the whole thing will be no audio. Okay?
Okay. Thank you.
All right. All right, so now we have, the defense has 7.16, conditions for using force or deadly force.
No. Yes.
Self-defense?
Yes, that would be for self-defense.
Yana, I don't believe there's any evidence on this record that these three defendants were acting in self-defense. Self-defense is an honest and reasonable belief that the defendant, the person, was in imminent fear of death, great bodily harm, or sexual assault. And there is nothing on this record that these three defendants were in fear of either of those harms, any of those harms.
Judge, when Gavin King sees his fellow sergeant rolling around with another individual and that said he's going to kill someone, Your Honor, that's sufficient evidence to determine he needs assistance. And then the second individual is, according to the witness, getting their ass handed to them, Your Honor. That's enough information to determine that these individuals need help because they are they're being assaulted by you, pushed off, so on and so forth, Judge. They were acting within their authority of trying to detain an individual that was making threats. That's more than enough, Judge, for an individual that like Gavin King to walk into a scene and see that there's a struggle between his sergeant and other officers, Your Honor.
Well, there's no evidence on this record to what Gavin King saw and how he interpreted. The record is void of that because Mr. King exercised his right not to testify, and there's no witness on this record that said Mr. King saw this and he thought this. What we know, and as I said, the record does not establish that these three defendants have a legal claim for self-defense.
I agree with the prosecution.
Judge, that's the whole case.
Right.
Judge, that's the whole case. And if I could just interject, yeah, James Hale testified that he was working dispatch and told them he got the call from Labib Ansara that the man said he was going to kill someone, and then dispatch people. And it's in the CAD reports. It's all we have to do is present some evidence to get this instruction. We don't have to convince the court that it agrees it's self-defense. All we're asking is that the jury should be instructed on self-defense, and they can decide whether it applies or not. But everything they're talking about is use of force and protecting the safety of yourself and others. That's been the whole case.
Judge, and if you recall, the second 911 call, Your Honor, when they played it to the jury, you can hear James Hill on dispatch and other officers' assistance needed immediately. While he's on the phone with 911, Judge. So you can clearly hear the dispatch go out from Hill himself.
Your Honor, I need to correct some things about the facts. First of all, when James Hale testified, the first radio call he made out to the security officers was assistance requested at LA Diamonds. He didn't even know what the nature of the call was until Labib called back. And that information was personally relayed to Sergeant Chafin. And that's what James Hale testified to. The second 911 call that James Hale made was for, if I'm recalling, a disturbed person.
Yes, he's doing two things, Judge. He's talking to the 911 operator, and he's also talking to he's communicating with the fellow officers. You can clearly hear it on their second 911 tape, Judge.
They requested police for a disturbed person. He did not relay anything that would lend credence to self-defense for these three defendants.
He testified that they were having their asses. What does that mean?
I believe that was the first
All
two
right.
defendants.
Thank
I mean,
you.
Schaefer.
On reconsideration, I will give the instruction.
Thank you, Judge.
Thank you. All right, that takes us down to 16.10.
Judge, we also had 7.20.
All three of those.
Oh, okay. And then 7.22.
Okay?
All right, thank you, Judge.
All right, 16.10.
Yes.
Yes, Your Honor.
Yes.
Defense has 16.15.
Yes, Your Honor. It goes along with involuntary manslaughter, that the act of the defendant must be the cause of death. It goes with the very first element, sorry for not saying, it goes with the very first element under 16.10, that the defendant caused the death of Mackenzie Cochran. And so it only makes sense that 16.15 goes along, the defendant must be cause of death.
Your Honor, according to the use notes that I read on that instruction, that instruction is to be given if evidence is introduced that there may have been an intervening cause and the defendant's actions were not a proximate cause for the death of the deceased, and there is no evidence that there was an intervening cause.
The record is filled with it, of their own expert testifying, had he not resisted, he would be alive. And I think that goes to another cause. Him resisting, him struggling, resulted in his death.
That is not an intervening cause, Your Honor, and I have a case that says that. If you give me 1 second.
Your Honor, the placement of the tracheal tube was an issue too with their expert. He talked about tracheal tube, Your Honor. He talked about
We did talk about the tracheal tube.
But he said he did not believe that was an intervening cause because and actually the report that was admitted, what Dr. Schmidt said was that he noticed in the Providence medical records that the doctor felt that it wasn't properly placed and he replaced it, but he didn't think that was contributory. That was what he said. He noticed that it had been replaced, but that the victim was still PEA, so he wasn't deceased, so he was obviously getting air still. That's what Dr. Schmidt testified to. But I do have a case regarding intervening causes and that a victim's actions do not amount to an intervening cause. If I could just have 1 second.
Judge, we're not talking about the victim's actions. We're talking about actions of another. Now, what we have is the tracheal tube that it clearly is an issue with their own expert, is what the ER doctor said. Judge, the drill that stopped working, which is another way to give the epinephrine. The fact that the epinephrine wasn't administered through the tracheal tube if they couldn't get an IV in them, Judge. Those are all things that could have helped the PEA. Schmidt said that, and so did Brodovich. They're both physicians.
So, Your Honor, the case that I have, let me pull it up. It's an unreported case. It's People v. Travis Lamar Hudson. It's actually a 2017 case, and it cites FEASL, which is also in the use notes for 1615. And the court in Hudson, the victim is shot, and the defendant produces a gun, and apparently during the altercation, the victim runs towards the armed defendant and tries to grab the gun, and it's discharged. And the defendant tried to get an instruction for contributory negligence and intervening cause. And the court said that the victim's actions in running and trying to disarm the defendant were not an intervening cause.
Judge, do you want me to respond to this?
Yes.
Okay.
Go ahead.
So,
Just trying to-
the case that she cites as being mentioned in the use notes, People v. FEASL, says that what that case actually did was the Michigan Supreme Court cautioned trial courts against providing inadequate jury instructions on the causation element. And it was for the crime of operating a motor vehicle while intoxicated causing death. So when it cautions a court against providing inadequate instructions, it's cautioning you to give the instruction. You know, I mean, they're not saying to be overly adequate. They're saying don't be inadequate. And, you know, we filed our jury instructions, both of us did last week. We filed these. I emailed them in a Word document. They could be edited. I emailed again last night when the court asked us to try to coordinate this amongst ourselves. The people had plenty of time to object. They knew we were asking for this instruction. And now, basically, they cite some unpublished case from 7 years ago, and I'm supposed to read it and respond on the clock when they could have replied a week ago and said, hey, here's this unpublished case that says you should not get this instruction.
But Judge, the distinguishing factor of Hudson versus here, Judge, Hudson is the defendant. The defendant blames it on the victim. These are third parties involved, Judge. That's the difference.
Well, the reason I brought up Hudson was because counsel said that Mackenzie Cochran's act of resisting also contributed to his death. That's the only reason why I brought up Hudson. Which I'm saying it's directly not an intervening cause, and we did discuss this morning.
Yeah. A victim.
All right.
Okay, sorry.
Please.
Go ahead, Judge.
I'm looking at the commentary with respect to this instruction, and it refers to People versus Barnes, where the court wrote that death must be the natural or necessary result of the act of the defendant. This is the statement of the general rule. This statement of the general rule has been repeated and employed often. So, the burden is, the proof is that the acts of the defendant must have been the natural or necessary result of the act. So I will give this instruction.
Thank you, Your Honor.
Okay.
Just can I ask just what that case was reported for?
People versus Barnes.
Got it.
I'm sorry, I should have given the citation. I just closed the book.
It's okay.
182, Mich. 179, 1914.
It's a classic.
Still good law. That's it. All right. Now, the next one that the defense has is 16.17, which is the degrees of negligence. Okay. So why am I going to be giving that one?
Judge, the jury, it talks about gross negligence, the definition of gross negligence, but also instructs them on different types of negligence, Judge, so the jury is not confused about what regular negligence is versus slight negligence versus ordinary negligence versus gross negligence, Judge. This will help the jury understand the concept of gross negligence better than, Judge, just giving the definition of gross negligence, because they're not going to know the difference between ordinary and and gross, because here it defines, Judge, different types of negligence. So I think, Judge, it educates the jury to make a better decision in terms of what type of negligence they're dealing with. What's the difference between gross versus ordinary? There is no harm, Judge, in this whatsoever.
I just feel it's unnecessary. We have a specific instruction That's limited to gross negligence, which is the only consideration before this jury. If we were dealing with negligent homicide as well, then this would be appropriate because you're dealing with gross negligence and ordinary negligence.
It differentiates. It tells them gross negligence is for manslaughter, ordinary negligence is for negligent homicide, slight negligence is not a crime at all. They know they're dealing with manslaughter. So this tells them you've got to find gross negligence, and it kind of gives them examples of how you go from each level to the next. And so unless they get to the top level, they know there's no gross negligence.
There's an instruction around that speaks and defines what gross negligence is.
And in fact, it's not even included in this instruction. It prompts the court to go to 1618, which is just gross negligence.
I don't see the harm in giving both. I think the more instruction they have, if it's on point, it applies to the facts that they've heard. I don't know why hearing more law would prejudice either side.
But it's not on point. 1618 is on point.
They're both on point.
We have jurors that sat on the civil jury, as a civil jury. They're instructed on that type of negligence. All this is, Your Honor, is making sure that the jury is not confused. This instruction will not confuse the jury judge. It will clarify things for the jury, especially jurors that sat in civil cases. I do believe we have a few of them that sat as civil jurors.
One.
And this isn't a civil case, it's a criminal.
I don't know, right, but it's different. They understand the difference, Judge. This is not confusing the jury. It's giving them clarity.
I don't know why you harmed them.
Okay. The court will give that instruction.
Thank you, Judge.
I neglected to indicate that the prosecution is asking for 16.16, susceptible to improper medical treatment to be given.
Judge, our objection to that is it says if the defendant unlawfully injured Mackenzie Cochran and started a series of events that naturally or necessarily resulted in his death, it is no defense, and it goes to this, like previous medical conditions and such. We're not arguing that the cause of death is not the defendant's because of a prior medical condition that he had. We're arguing because of his actions. And also that the defendants are not the ones who started this series of events. The victim started this series of events by threatening to kill somebody and then lunging towards one of the security officers despite repeated commands to not approach and showing a pepper spray. So this does not fit these facts, that the defendant started the series of events. And further, we're not arguing, that he had some prior medical condition that's the cause of his death. Nobody's arguing that. So.
It's not just about what counsel is arguing. It's about what fits the facts of this case. And a fact in this case is that, Mackenzie Cochran had an enlarged heart, which made him susceptible to sudden death. So this instruction is appropriate because the jurors need to understand that just because he had a heart condition that may have killed him eventually, that does not mean that the defendants escape liability if the jury believes that they contributed to his death on January 28th.
Judge, if you think about the fact pattern in this fits a fact pattern where the defendant, right, was the aggressor, and later on tries to argue, well, he died of something he already had, when the defendant is the one that put everything in motion. Judge, you heard all the evidence. The accused did not put anything in motion other than doing what they're lawfully supposed to do, which is prevent a threat. So This doesn't fit our fact pattern, Judge. This would fit a fact pattern where someone was aggressor and tries to blame it on a medical condition that the person already had. That's not the case here. And that's why there's a distinction between the two.
I don't think the use notes say that we can only get that instruction if the defendants are trying to blame the victim's prior medical condition. I think if the facts support it, it can go to the jury.
Judge, if the defendant unlawfully injured Mackenzie Cochran and started a series of events, they didn't start it, Judge. They're trying to stop a series of events in this case.
That's for the jury to determine.
Yeah, but you're given them information that is not consistent with the fact pattern whatsoever.
That's for them to determine as well. It's all a question of fact.
There is no set of facts they could rely on in this record to say the defendants started the series of events. Nothing. I mean, yeah, it's for their props to make a finding. If there's conflicting evidence, they can decide which one they believe. Mm-hmm. But all the evidence is that the series of events is started by the decedent, not the defendants. So I don't see it applying.
Judge, if Mackenzie Cochran had hurt, if it was the other way around, where the security guard went to stop Mackenzie Cochran when he began to make the threats, Mackenzie Cochran survived, and the other security officer died, then this instruction should have been given, because the events were started by someone other than the accused. So that's why, Judge, it should be given.
I don't even know how to respond to that. I don't understand. Never mind. I don't understand what that was. But I believe the facts support giving this instruction. Because the people have the burden, this is something we have to address. It was brought out, it was talked about at length that he had this enlarged heart. And the jury needs to understand that just because he had a prior medical condition that may have exacerbated what happened on January 28th, if the cause of death were the acts of these defendants, that heart condition does not mean they escape criminal liability.
The court will give 16.16.
Thank you.
Thank you.
And then there's, the defense has, well, you both agree on 16.18, correct? Gross negligence?
Yes.
Yes.
Okay. Finally. And then the defense has 16.20.
People object.
It's appropriate, Judge, to say he was negligent in threatening to kill people, in approaching Sergeant Chafin, in resisting, in the struggle. It was negligent on his part. And the medical examiners, both prosecutors and defenses, said that had that not happened, he would be alive. That's contributory negligence.
The court will give 16.20. I think that it's all the instructions that the side has presented. Am I correct?
Yes.
That is it, Judge.
Okay. All right. And the defense has provided verdict forms.
Oh,
Are there
yes.
any objections to the verdict forms that have been presented by the defense?
Yeah. No objections.
Okay. Then that's good. All right. Okay. I think we're all set for closing arguments and instructing the jury on the count.
Thank you.
Thank you, Judge.
Appreciate your patience.
Kenny and Nehemiah Nelson that he said multiple times, I can't breathe. We know that when he couldn't talk anymore, he just cried and wailed. And then eventually he stopped moving and he stopped talking. And nothing was done by these defendants. When he was finally handcuffed, they left him face down for 2 minutes before he was rolled over. Before
Yeah. Sometimes I get so mad